TB, you ready? All right, good morning, everyone. I'd like to call to order the judiciary public hearing for May 15, 2023. We have one item on our agenda today. That's the governor's nomination of Sandra Slack Glover of Guilford to be an Associate Justice of the Supreme Court. Attorney Glover, if you could come forward, please. If you might raise your right hand for me. Do you swear or affirm, as the case may be, the information provided this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury? Great. Have a seat. If you could turn the microphone on in front of you there. Button. And if you have an opening statement, you can go ahead.
Good morning, co-chairs Winfield and Staffstrom, vice chairs Flexer and Quinn, ranking members Kissel and Fishbein, and other distinguished members of the Judiciary Committee. My name is Sandra Glover, and I thank you for this opportunity to appear before you today. I'd like to begin by thanking Governor Lamont for the trust he's placing in me with this nomination. I would also like to thank my colleagues at the United States Attorney's Office, past and present. It's been a great privilege to work with them all. They've challenged and supported me and helped make me the lawyer that I am today. Most importantly, for their unwavering support and love, I would like to thank my husband of 28 years, Eric, and my children, Teddy and Henry, who are all here with me today, as well as my mother, Charlotte Slack. My father, Doug Slack, is no longer with us, but I know he would be proud to see me today. My parents were both teachers. My father, a wetlands ecology professor, my mother, a public school teacher, and so education was a major priority in our lives. I graduated from the University of Virginia and then obtained a master's degree from Duke University before attending the University of Chicago Law School. Like my parents, except for 2 brief stints in private practice, I've committed nearly my entire career to public service. After law school, I clerked for Chief Judge Richard Posner on the United States Court of Appeals for the 7th Circuit, and then Justice Sandra Day O'Connor on the United States Supreme Court. Those experiences solidified in me the significance and importance of the rule of law. After my clerkships, I worked for the Environment and Natural Resources Division of the Department of Justice, fighting to enforce our environmental laws and protect natural resources across the country. In that position, I argued mostly civil cases, including a case, for example, that defended the Environmental Protection Agency's efforts to enforce the Clean Water Act. Then about 21 years ago, Eric and I moved to Connecticut and settled in Guilford, where we've raised our family. Between many nights working the concession stand for Little League, keeping the scorebook for Guilford Basketball League games, serving on the board of the public library, and volunteering for countless sports clubs and schools, I know full well how fortunate we have been to raise our children in Guilford and the larger Connecticut community. With our move to Connecticut, I joined the appellate practice group at Wigan and Dana. But in 2004, I returned to public service at the U.S. Attorney's Office for the District of Connecticut, where I have been ever since. Early in the Obama administration, I was appointed the appellate chief in our office, responsible for supervising all appeals, both civil and criminal, and serving as a legal advisor to the office. Under Attorney General Eric Holder, I became chair of the Appellate Chiefs Working Group, a standing nationwide committee of appellate chiefs, and an ex officio member of the Attorney General's Advisory Committee, a leadership committee of U.S. attorneys. Both of these committees advise the Attorney General and other leaders in the Department of Justice on legal and policy matters. As appellate chief in Connecticut, I've supervised hundreds of appeals and personally argued over 24 cases in the United States Court of Appeals for the 2nd Circuit. This has given me extensive experience in analyzing legal questions, applying the law to new fact patterns, and working collaboratively to ensure just outcomes in all of our cases. In the course of that work, I have regular contact with Connecticut law. One of my more recent cases, for example, turned on the application of Connecticut contract law. Another recent case turned on the application of Connecticut tort law. My role has also given me extensive experience with questions that arise in trial court settings. I've read thousands of transcripts covering, for example, evidentiary rulings, sentencings, pretrial conferences, guilty plea colloquies, and arguments on motions to dismiss. In addition, I routinely advise trial prosecutors on questions that arise in their cases: how to admit a piece of evidence, how to respond to an adverse evidentiary ruling, and even whether to pursue charges in the first place. In my role, I also have often counseled the United States Attorney not to pursue criminal charges that I felt could not be supported by the facts or law, or not to pursue an appeal from an adverse decision of the trial court. Whether I'm providing advice to a trial team or reviewing an appellate brief, my obligation has been to seek justice. Whether defending a criminal conviction, for example, or a federal agency that's been sued for tortious conduct, the question is not just what can we do, but what should we do? Or when implementing new sentencing statutes or court decisions that lead to sentence reductions for classes of federal defendants, the question is, how do we implement this new law efficiently, equitably, and in the interest of justice? By asking and answering these questions every day, I've tried to uphold the rule of law and to do justice for litigants, for the United States, and for the people of Connecticut. If I am fortunate enough to be confirmed, I would bring my expertise and experience in interpreting laws and analyzing legal questions, my independence and dedication to the rule of law, and my deep and longstanding commitment to public service. One final word, given recent media attention, and on this, I want to be clear and unequivocal. I support a woman's right to choose, full stop. Speaking as an attorney, Dobbs was wrong and egregiously so. Speaking as a woman, it was horrifying. All of us should have a constitutional right to control our reproductive freedom and our bodies. My belief in this is firm and unwavering. One important hope I can offer those who, like me, are scared by the erosion of our rights is that thanks to you and your colleagues, Connecticut law and the Connecticut Constitution guarantee more expansive rights than those found in the federal Constitution today. I hope that you will find me qualified to serve on the Connecticut Supreme Court. Thank you again for this opportunity to appear before you. I welcome your questions.
Questions from the committee? Representative Fishman.
Good morning. Thank you for being here. I wanted to ask you some questions about the backup that we received. I noticed that in 2003, you got admitted to the Seventh Circuit, and I'm just tracking through your history. The Seventh Circuit is Illinois and Wisconsin, I think. How did that come to be in your history?
I'd have to go back and look. I don't recall what in 2003 I would have been in Connecticut. I was working at Wigan and Dana at the time, and we probably had a case in the Seventh Circuit, but I don't recall exactly. I became admitted in courts that I needed to be admitted to practice. And so given the timing, I don't recall.
Yeah, and I agree. It didn't make sense because you're working in Connecticut. You have one case in the Seventh. You could have come in pro hoc vice. So I thought that was a little interesting. The clerking for Sandra Day O'Connor. I know when I was a student at Quinnipiac, that was one of the highlights of my law school career. She came and spoke at Quinnipiac, and I was, they had a lottery to attend, and it was, it was great.
Right.
But I noticed in the backup that you never mentioned her as being inspirational. You mentioned Justice Kagan. So why? Firsthand knowledge, working with this person, on an almost daily basis. And then we have this someone who I don't think you had that connection. Why the difference?
Well, let me clarify. It was certainly not meant as a sign of disrespect or a suggestion that I don't have the utmost affection and respect for her. I was trying to identify someone more recent that maybe people would be more familiar with. I was 11 years old when she went on to the Supreme Court, and it was an inspiration to me and generations of women. Kind of shocking that she was the first, but she was a phenomenal mentor and a phenomenal inspiration as a judge and as a justice. And I learned a lot from her about how to be a judge, about how to be you know, she was the first woman and she understood that role in a very deep way, but she also was incredibly humble and down to earth and cared about us as people, cared about her cases in a deep ways. And she never let her position go to her head. So my failure to mention her in the back was not about any disrespect or suggestion that I didn't learn a lot from her or don't still have a lot of respect and love for her.
Yeah, I'm a little, you said that you mentioned Justice Kagan because you thought it was somebody that was more relevant and that we could identify. So, I'll take that for what it is. But the question specifically in the questionnaire said, what United States or Connecticut Supreme Court justice from current or recent courts do you admire the most and why? So is that because of the current or recent courts?
Yes.
Is that okay? And you said I admire Justice Elena Kagan for her approach to the law with commitment to the proper role of the judiciary, her intellect, her writing style, and her respectful and incisive questioning style. I think all of those attributes would apply to Justice O'Connor as well. So, but I take that as what it is. You mentioned Yale Law School. You did something there in 2010 and 2011, and I was unable to link that up. What was that?
So in the spring terms of 2010 and 2011, I was a co-teacher. I co-taught with 3 other faculty members a class on legal writing with then Judge Mark Kravitz. I had worked with him when he was an attorney at Wigan and Dana. And he had developed a class on legal writing and asked me to come teach with him. And we taught with 2 other faculty members at Yale, who were, I think they're both still on the faculty there. But Judge Kravitz and I were the outside faculty members, and we taught it in the spring of 2010 and then again in the spring of 2011.
And is there a reason why you didn't do that anymore? I was looking at your employment history in conjunction with that. Was there some event that gave rise to you not? Why didn't that continue?
So Judge Kravitz was the sort of the leader and the force behind that course. And in this, I don't remember the exact timing, but in the spring of 2011, he was diagnosed with ALS and was unable to continue teaching. And so the class wasn't continued because it was his class.
Okay. And then, you sort of referenced the letter, right? And so the letter's dated May 26, 2017. It's in support of Professor Barrett going on to the US Supreme Court. And in that letter that you signed, you stated that she's smart, honorable, and fair-minded. So how did the letter come to be?
Just to clarify one point, it was not a letter in support of her nomination to the Supreme Court. It was a letter on behalf of a colleague who was being considered for a position on a lower court of appeals, a lower court. I don't remember exactly how it came to be. It would have been probably a group email from somebody else. The letter was signed by every single clerk who clerked that year. Every justice has 3 or 4 clerks, depending on their preference. And so everybody who clerked that year, including all of the clerks for the liberal justices, everybody signed a letter saying, based on our experience with then Professor Barrett, based on our experience from 1998 to 1999, she had the qualifications to be on a lower court of appeals.
Okay, yeah, and I do rightly corrected. It was not for the Supreme Court, it's for the 7th Circuit, which happened to be the same, I believe, the same circuit that we were talking about earlier. And that letter was approved by you 20 years after you had contact with Professor Barrett?
I have not spoken to her since 1999 when we left the court.
Okay, so it's over 20 years, right? 99, 2009, 2017.
2017, right?
Yeah, so just about, okay. So in the governor's press release that he did on April 25th. He says that both in private practice and public service, you've demonstrated a respect for the rule of law. And I just, is there anything that you provided the governor's office with to support that statement with regard to private practice? Because you haven't been in private practice for quite a long time, right?
Correct.
So I'm just, that jumped out because I know you've had a lengthy career of public service. And we are not provided everything here. So I'm just trying, where did the governor get that from? Or did they just make it up?
I doubt the governor's office did that. I can't say specifically. I would say, my reputation and my practice of law has been consistent over the course of my career. And I have always practiced law with a deep commitment to the rule of law in whatever I have done. Whether it was in private practice when I was representing private clients in their disputes, or individuals who were involved in investigations by government bodies, or I worked on a couple of cert petitions to the U.S. Supreme Court. It's always been my practice to practice law with a deep commitment to the rule of law.
Yeah, I only asked because, I don't know if during your term in private practice, you got a bunch of awards or something like that. We have nothing before us with regard to that. So I'm trying to balance, is it a statement or does it have backup as I go through my review? That's all. So, I have no reason to believe that, you're disrespectful or something like that. But certainly people do get, an award from the Bar Association for, excellence in practice or something like that. So am I to understand that there was nothing like that during your term of private practice?
I don't recall receiving any awards during my time of private practice.
Okay. So then in the questionnaire, you're asked about litigated matters that you have handled.
Mm-hmm.
It says list 3 of the most significant litigated matters. So you mentioned the Manzo case, and why was that significant?
That Manzano was a case that I handled. Let me give a little bit of background. Manzano was a case where our office was prosecuting an individual who had been charged with producing child pornography. He had videotaped himself having sex with a young teenage girl. And before trial, his defense attorney told the trial judge and told us that he wanted to argue to the jury that even if his client had actually done this and had actually produced child pornography, as we alleged, that he wanted to argue that 2 things. First of all, the penalties for this conduct were too high, but actually also that this shouldn't actually be criminal conduct, that everyone should be able to have sex with children and it shouldn't be illegal. Putting aside whether that would be a valuable argument or a winning argument or not, he wanted to argue that to the jury. And that's an argument for what's called jury nullification. Now, juries nullify sometimes. Sometimes a case is presented to a jury and the jury decides, we're not going to convict for different reasons. Whatever reason, we have maybe it's mercy, maybe I don't, whatever the reason, we're not going to convict. But in our system, the U.S. Supreme Court and the Second Circuit Court of Appeals have said, we're not going to encourage that. And the reason we don't encourage that is because once you tell a jury, you get to make up the law in your case. You get to decide that even though the legislature has decided that production of child pornography is a crime, you don't get to decide it's not a crime. Because if you get to decide it's not a crime here, the next jury can decide, it's not a crime to actually violate the drug laws. It's not a crime to violate the laws against robbery. And more perniciously, and this is why I thought it was so important, this is why I felt so strongly about this case, you could have a jury decide, the government didn't prove every element of the offense beyond a reasonable doubt, but he's kind of a bad guy So even though the judge told us we had to find every element beyond a reasonable doubt, we're going to convict anyway. Because once the jury doesn't have to follow the law, they don't have to follow the law. And more perniciously, and this is actually the history of jury nullification in our country, more perniciously, it's a history of juries deciding that they're not going to convict defendants who've been charged with harming people of a disfavored class. So if your mind is right now going to Jim Crow South and white juries that refuse to convict white defendants of harming African-American victims, that's where you want to go with jury nullification. So we went to the Court of Appeals and we asked the Court of Appeals to tell the trial judge, you have to stop this. You can't allow the attorney to make these arguments. And the Court of Appeals agreed with us and said, you're right. You can argue within the bounds of the law and you can argue for mercy, but you cannot ask the jury to ignore the law.
No, I appreciate that. And I just, as a precursor, it's difficult because I can't review decisions that you've written because you haven't served as a judge. So I have to sort of pull out opinion based upon positions. So I think I have to ask you, is there any position that you've taken as a prosecutor that you disagree with?
That I personally disagree with?
Yeah.
No.
Okay, because we bring those things to the bench. So in that case, you thought it was inappropriate for the lawyer to be able to inform the jury as to what the penalty would be, because that was part of the nullification challenge, correct?
That was part of it. So under governing law from the U.S. Supreme Court and the U.S. Court of Appeals for the Second Circuit, sentencing consequences are not something that is supposed to be presented to the jury. There is a little minor exception that actually no case has ever said that they found the exception to actually hold. So it's sort of a theoretical exception as far as I could tell. But the U.S. Supreme Court and the Court of Appeals have held that sentencing consequences are not something that the jury is supposed to think about or is supposed to make a decision on.
And what is the rule of law in Connecticut with regard to that?
I don't know specifically if there's something specific, but I would assume that same position would, because it's a U.S. Supreme Court holding, but I don't know specifically if there's a specific ruling on that.
Okay, so if you were to, because the Connecticut Supreme Court is the last end in most cases, like 80% of the cases actually, that would be something that you would be adverse to, is a jury knowing what the possible penalty for the accused is should they be convicted.
So let me just clarify. When I was arguing in Manzano that the jury should not be told the penalties, I was arguing because that was what the law required. If under Connecticut law, and I confess I don't know if there is a specific provision or if the Connecticut Supreme Court has passed on that question under a Connecticut law or under the Connecticut Constitution, if that were authorized under the Constitution, I would not, or if that were authorized under law, I would not. It's not a policy position. It was an argument that I made in Manzano based on the law, based on the federal law that I was following. Does that make sense?
I do. It's sort of, and that's why I had asked you about differences of opinion in a position that you took and, the personal opinion. I mean, I guess my concern is, sometimes prosecutors overcharge. And overcharging results in harsh penalties. And I don't think that prosecutors should be, that practice should be shielded. And one of the ways to, stop that is for there to be full knowledge, but we'll go on. The Harrington case you also listed.
Mm-hmm.
And what was your involvement in the Harrington case?
So I was involved at the end of Mr. Harrington's case and helping get him out of prison. In 2015, the United States Supreme Court invalidated part of a major sentencing statute called the Armed Career Criminal Act. And they only invalidated part of the statute. They left other parts of it intact. And when that statute was invalid, or when the part of it was invalidated, our job in the U.S. Attorney's Office and around the country was to identify those defendants who were automatically either entitled to a sentence reduction or to be released from prison, depending on where they were in their time. Some of those cases were really easy because it was clear that they were sentenced under this part of the statute that was invalid. Then there were some other people for whom it was really easy that their sentence was still valid because they were sentenced under the part that was still valid. There was actually this large middle ground of cases where it was actually really hard to tell. Should this defendant still have been sentenced as an armed career criminal or not? And that turned on looking at the defendant's prior convictions, looking at the record support for those convictions, looking at the history of the litigation. And we were trying to do that in a way that was consistent so that if we were arguing a Connecticut conviction for robbery qualified to make this defendant eligible for sentencing under the Armed Career Criminal Act, that we were doing that consistently in every single case. And if we were arguing that didn't qualify, we were doing that consistently in every single case. So, but that middle ground, these cases that required a lot of digging back through old files, digging up the old Connecticut convictions, digging up the paperwork, digging up their prior pleadings, those took a lot of work. For Mr. Harrington's case, and my job actually in the office has mostly been at the supervisory level on those questions and helping make sure that we are doing that consistently. Mr. Harrington's case is emblematic of the work that we did. And I actually had personal involvement in that case at the trial court level. I was handed that case a day or two before a status conference, and I don't really recall why. It wasn't my case originally, but the assistant U.S. attorney who was supposed to handle it couldn't be there. And I was asked to go into court. So I picked up his file and I started looking at it. And I recall when I walked into court for a status conference thinking, this guy's in this big middle, but I think he may be over here. I think he may be somebody who should be getting out of prison. And, but I didn't have time before the status conference. And when we got to the status conference, the trial judge asked us to brief actually a different legal issue and gave us, I think 10 days, 7 to 10 days to brief this, a different legal issue unrelated to my concerns about the case. So when I left that status conference, I went back and I dug through all the files and I got all of the underlying documentation about his prior convictions. And I determined that I thought his conviction was no longer valid, or his sentence effectively was no longer valid as an armed career criminal. And I got the approvals from my office and I called his attorney and I said, we would like to agree to relief. I drafted the stipulation. I got his attorney we negotiated the stipulation and I filed it and he was released from prison the next day.
So I have to go back to the questionnaire because it asks about cases that you litigated.
Mm-hmm.
And I've read just about every case you've been involved with that's in the system.
Mm-hmm.
So Pacer, Westlaw. You weren't involved in the conviction of Harrington.
No, I was not.
In fact, Harrington was convicted in 2005. And it wasn't until 2015 that he filed a motion to vacate. It was actually December of 2015. So he had been in prison for 10 years already.
Mm-hmm.
In 2016, an attorney, Carwin, from your office, filed an appearance. And then in, I think it was April. Yes, April 19, you filed your appearance. So he had been in prison for 11 years at that point. And then there's a stipulation shortly thereafter. So when I was reviewing in conjunction with the questionnaire, I don't know how you could make the representation that that you litigated that case? Can you explain that?
Because I handled one of the more significant parts of the case and I worked with his attorney to get him out of prison. My definition of litigation is appearing on behalf of the United States in cases of significance. That case was significant to me for two reasons. First of all, I was really proud of the work we were able to do to get Mr. Harrington out of prison. And it also reflected the larger scope of my work at the U.S. Attorney's Office. And I thought it would be helpful for this committee to understand a little bit about what I did.
Okay, I saw a lot of cases that you've been involved with on the federal, and I was just a little puzzled, why that would jump out, but so in your questionnaire, well, before I get to the questionnaire for the Supreme Court, you mentioned that Dobbs is wrong, and not that I want to get highly controversial because I haven't spoken about Dobbs, but many people's takeaway on Dobbs is it's a states' rights issue. And certainly, as you recognize, Connecticut has made its overtures to codify Roe v. Wade prior to Dobbs. Why and how is Dobbs wrong?
I don't see it as a states' rights issue. We in this country, as rights have expanded, partially they've expanded because we don't leave basic civil rights to the discretion of states. Dobbs was wrong to take away my constitutional right to control my body, to control my autonomy. The Supreme Court has never taken away a right like that, and certainly has never made women effectively second-class citizens in this country, subject to the whims of the legislators in the states where they live. They were wrong to ignore stare decisis and to overrule a precedent that had been repeatedly reaffirmed by judges and justices over the course of time, without so much as a passing glance at the significant reliance interests that women had built up, that women had used to make decisions about their future and about their ability to decide when and if they want to be pregnant, and all that that entails. They were wrong to tie basic civil rights to whether those rights, whether that particular right was recognized at a prior term in history, back to the Dark Ages, but certainly at the time of the founding or at the time of the enactment of the 14th Amendment, when, I wouldn't have been allowed to vote. I didn't have a whole lot of rights beyond what, my husband would have allowed me if I had been alive at that time. And to suggest that that's how we should evaluate the scope of rights, I think is wrong.
No, I appreciate it. It's an interesting question. The whole topic is the lightning rod. But anyway, in the Supreme Court questionnaire, you're asked, do you believe states are free to develop constitutional rights and protections separate from federal guarantees? And your answer was the U.S. Constitution provides a floor above which states, including Connecticut, are free to provide greater rights and protections. I would conduct an independent analysis of any claim under the Connecticut Constitution. So what is your opinion on the supremacy clause in the federal Constitution?
My opinion on the supremacy clause is there's a supremacy clause and it's there and it controls with respect to interpretations of the federal Constitution. That doesn't mean that a state Supreme Court, such as the Connecticut Supreme Court, is bound by that interpretation when interpreting the Connecticut Constitution, because the Connecticut Supreme Court is the final word on what the Connecticut Constitution means. Even if the United States Supreme Court has interpreted even identical language to mean something slightly different, the Connecticut Supreme Court can decide, and in fact has decided repeatedly, that the Connecticut Constitution protects more than what is protected by the US Constitution.
Well, that begs, what is the supremacy clause? Not what portion of the US Constitution, but what does the supremacy clause mean?
It means that federal law controls on questions of federal law, that the Constitution controls inconsistent, but it's not inconsistent to protect more rights.
Okay, well, the supremacy clause at its core means, I believe this is how our courts have fallen on this, the federal courts, that when there's a conflicting law passed by a state that is invalidated because the federal law is supreme. Do you agree with that?
You know, there's a lot of ways to analyze it. Supremacy clause questions are tough, but that is not necessarily the way that I would phrase it, because the US Supreme Court and federal Constitution doesn't control the interpretation of separate state laws and separate constitutions. And inconsistency has a pretty narrow meaning, or a pretty defined meaning, I guess, is a better way to phrase it in supremacy clause cases. And I'm not aware of supremacy clause cases holding that a state Supreme Court can't interpret a state constitution to protect more rights and different rights than those protected by the federal Constitution. They're not in conflict to protect more.
Right, well, two topics I want to deal with conflicts, and this came up, I believe, when Justice McDonald was here. Marijuana. Now, marijuana is illegal under federal law. No state, no court in this whole country has found that a state's legalization of marijuana is lawful. That issue may come before the Connecticut Supreme Court. That's a supremacy clause issue, whether or not the federal law trumps the state law. So that's what I'm exploring here. And you know, in recognition of that potential conflict, where do you fall on the supremacy clause?
So, you know, because that question could come before the Connecticut Supreme Court, I need to be careful with how I answer that question. I would apply the law on supremacy and look at the cases and how those cases have been interpreted. It would depend on how that claim came and what the arguments were. Is this a claim under the Connecticut Constitution or under Connecticut law, or is this a claim under federal law and the federal Constitution? So I'm not sure I can say more beyond that, because especially if this is a question that could come before the Connecticut Supreme Court, I would not want to suggest that I have already reached a conclusion about that.
No, I understand. We are lawmakers, and you know, I mean, that's something that's of concern. I mean, I'll tell you that it's an issue with gun ownership, gun acquisition. I mean, under federal law, as you're aware, one who's addicted to or habitual user of a controlled substance that's illegal under federal law cannot obtain a firearm. And we have medical marijuana in Connecticut. And some courts have taken the position, they have a medical marijuana card, you are addicted to or habitual user of that substance. So, you know, those conflicts in the supremacy clause are of concern. One of the other questions that you're asked in your questionnaire is, do you believe the balance has begun to tip too far in favor of criminal defendants against the ability of the police and prosecutors to protect society? How is society served by protecting the rights of criminal defendants? And you said police and prosecutors work within the existing legal framework to protect society, while at the same time protecting the rights of criminal defendants. The protection of the rights of criminal defendants promotes the rule of law, which protects everyone in society. But the question was about the balance, right? Do you believe the balance may have begun to tip too far? What is your belief?
So at its core, to me, a lot of that is a policy question. I don't happen to think so, but part of that is because I've spent a large part of my career working with law enforcement. And our perspective has always been policymakers and sometimes courts make decisions that some view as tipping a balance in favor of criminal defendants. Maybe it was the Miranda decision. that said before you question somebody in custody, you have to give them certain rights that we're all aware of from watching police procedurals, right? Some people would think that would tip the balance in favor of criminal defendants. My experience has been that the police work in concert, work with whatever framework we have. I don't find it too far, mostly just because, we live with what we have. If we are faced with a case where a search is unlawful under the law, we don't use the evidence. And we move on either to another case or we find another piece of evidence to support a conviction. It's not about, I'm aware that some people believe that sometimes legislators go too far or that there's a balance tip too far. I don't happen to think so, but it's also kind of my personal view about that question has never been an issue as working in law enforcement at the U.S. Attorney's Office, because we just operate within the laws that we have and the framework that we have. And if legislature wants to say, this is how you should handle it, if the court wants to say, this is how you have to bring in an defendant at a particular time for a particular procedure, that's what we do. It's not about obtaining a conviction, because the point is to do justice. And if justice involves providing additional protections, that's what we do.
I understand it's a difficult question as a jurist, right?
Correct.
About an opinion and, but the question lies, right? The question, it doesn't not tell the truth. It sits there. Do you have a belief? This session, we're going to be changing things regarding justice and those kinds of things. And, I think once again, as lawmakers, we want to know that the things that we're doing for the most part are going to be upheld. And certainly if someone thinks that we've gone too far or haven't gone far enough, that's something that comes to the table. So
May I respond to that?
Absolutely.
So, those are policy calls. You are free to write statutes. And I think my job as a potential jurist or a jurist would be to apply those and enforce those statutes. That's not, it's part of why I talked about Justice Kagan and my admiration for her is that she understands and lives the role of the limited judiciary, that the role of the judiciary is not to make those policy calls. Those calls are for you all to make. And the role of the judiciary is to apply those statutes as written. And so that would be my obligation as a jurist, and I would take that obligation seriously.
No, I understand. But once again, we're put in this position, or I'm put in this position in that I can't review any decision that you've ever written because you haven't. So I've got to try and look at what you've done and see and when you're asked about beliefs, you bring those beliefs, right? I mean, there are certainly decisions by the Supreme Court. We've had a couple in Connecticut that some people don't agree with. The fact that a bail has to be at a level to meet a certain intent of the Constitution, and many of us, that's a gray area. The application of the death penalty, whether or not that applied to those that were already on death row at the time that this, that was a whole cloth equal protection thing that it's policy that this body didn't create. So those are examples of powers that are inherent in the Supreme Court justices that are outside of the policy that's created. But the Harris case, do you recall the Harris case? This is he was looking for a First Step Act a change. He sought a reduction. He had already gotten a reduction and the law had changed in the interim. And then he said, well, I want to, now that the law has changed with regard to these penalties, I'm entitled to another reduction. Do you recall that? This is in 2021.
No, the number of people who filed First Step Act motions was phenomenal. And I don't recall every single case.
Okay.
And there were two different kinds of First Step Act motions that were really prominent. And so Harris sounds like a name that I've heard before, but I don't recall that case specifically.
Okay, well, that case ended up going to the US Supreme Court.
Out of our district?
Yes. And they remanded, it was case remanded to the US Court of Appeals for the Second Circuit for further consideration in light of Concepcion versus the United States. The position that you took as the prosecutor in denying that was overturned by the Concepcion case. Do you recall that now?
I don't. I mean, I really apologize. I don't recall that. There were the US Supreme Court, and I don't know if this was it, because I don't recall it being Concepcion, but maybe I'm misremembering the name of the case. The Department of Justice established, and this was something that I thought, that we tried to do nationwide. We tried to adopt nationwide standards that we were handling First Step Back motions. And I'm guessing from what your description, because I can't, and I really apologize. I just don't know all the cases. And I'm on a lot of dockets that I'm not necessarily the person who was responsible, but
So just to try, the Harris case, you argued with Amanda Oakes.
okay. I would have reviewed the brief, right?
Okay. And the Concepcion case came down last year, June 27 of 2022, so less than a year ago. And as a result of that, the court ordered the Harris case to be reopened and for him to get a modification, but I'm going to move on.
So just to be clear, so one of the things that happened, the department had taken a position about the eligibility for relief of certain classes of defendants. And we took those positions nationwide. If I'm guessing, because I just really don't recall, and I apologize, but I'm guessing that it was one of those cases where the Supreme Court ended up disagreeing with our interpretation of the statute and remanding a bunch of cases back to the Second Circuit. And, so the government-wide took, if we had cases pending that were affected by that interpretation, they were reversed and we went back. I'm guessing I really would have to go back and look at that case because I just don't recall off the top of my head.
Yeah, I'm just going because,
Right.
this is an issue that's live in the state of Connecticut, is modifications of sentences
Mhm.
after the law has changed. We have the marijuana issue, right? We vacated a bunch of stuff and we're vacating more this year. And I asked you whether or not you differed with any position that you took. So, that case is like directly on what some of us have been working towards doing here. So, I mean, I take your position for what it is. In the Lewis case, do you remember the Lewis case? There was this search and seizure case in New Haven.
I do not.
Okay, so the police officers are executing a warrant.
Mhm.
And the warrant allows them to go to certain areas of the defendant's home. Well, the accused, the being searched party's home. And during the course of them being there, they find a sock that has a firearm and marijuana in it, and it's on the porch. But they didn't have a warrant to search the porch. And he was charged as a result of that. They filed a motion to suppress, which you objected to. Do you recall this?
Yes, generally, I was not the trial prosecutor. I only supervised the appeal.
Okay, and the appeal was asserting once again that that was a proper search.
Yes, we defended that search.
So how does the plain sight rule work in conjunction with that?
I could talk about the plain sight rule in general. I don't remember that case being a plain sight.
No,
Well-
because it violated plain sight. I mean, plain sight says the cops are there, by permission and they see, the growing operation in the
Right.
kitchen, right?
Right. So I don't remember, I was just gonna say, I don't remember that case being about plain sight rule. And this is just going off of my memory and keeping in mind that I handle hundreds of cases. And so I remember the facts of that case. And as I recall, our position was that the porch that was searched was actually within the authorized search area by the warrant because it authorized to search his home and that this porch was part of his home. But I would have to go back and look at that case again to see what the issues were. It wasn't a plain sight case because
It wasn't a plain
you know,
sight.
the plain sight rule, as you know, it just allows if the police are lawfully authorized to be in a location and they see something else that is not necessarily part of what they were searching for, they're allowed to seize it.
Okay, just to be clear, and I'm reading from the case.
Okay.
The warrant stated that the second floor apartment as well as the basement is the targeted location. The case goes on to say the handgun, police found it along with more marijuana inside a sock in a laundry basket located on the small back porch or landing area of the ground floor rear door of the 3-store building. So they didn't have a warrant to search that area. Certainly it wasn't plain sight because it's inside a sock, inside a laundry basket. I mean, I found it a little difficult to work with, but we go on. In the Corley case, do you remember Corley was a prisoner? Is it?
I remember Mr. Corley. Yes.
Okay. Did you, not as a prosecutor, but as an individual, potential Supreme Court justice, did you see an injustice in the Corley case?
No.
Okay. So can you tell us what you remember about the Corley case?
If we're talking about the same case, what
Yeah,
I
that's
remember
fine.
is that
Clear.
Mr. Corley had filed suit seeking a recovery for medical malpractice. Are we talking, I assume we're talking about the same case.
Yeah, it's dental malpractice.
Dental malpractice, and that there was a finding by the district court that he had not complied with Connecticut's good faith certificate requirement. And so the district court dismissed the case. And so the question was, is that a substantive or is that a procedural rule? Because this was a case under the Federal Tort Claims Act. The Federal Tort Claims Act adopts the substantive law of the state, so Connecticut law here, but not the procedural law. The procedural law is the federal rules of civil procedure. And so the question on appeal was, is that a substantive or is that a procedural defense or standard? And there had been in our circuit, in our district, all but one judge who had ever looked at this had always said that this was a part of Connecticut substantive law based in part on a Connecticut Supreme Court decision that has subsequently been changed, like just a few months ago, actually. But we defended that position and the Second Circuit disagreed with this.
Okay, so the good faith certificate basically says that you have to hire a neutral, somebody who has a license in that area, or perhaps a dental hygienist who would have the acumen to certify that there was malpractice before you can bring an action. Is that fair?
That's fair.
Okay. So how does one who's incarcerated get a good faith certificate? What's the process?
I don't know the Bureau of Prisons processes, but it is entirely, if you need medical care or need access to a medical provider or a dental provider, you can make an appointment through the prison. You can send your medical records to an outside provider. You could have an attorney do that. There's certainly no limitation. I mean, there's nothing that the Bureau of Prisons does to prevent you from obtaining that. They would facilitate legal calls. They would facilitate medical appointments if necessary and appropriate. So that's how that would happen.
But in this scenario, the prisoner is seeking a good faith certificate. They are not seeking medical treatment. They are seeking something that is, in my experience, not recognized by our prisons. So I do see an injustice, quite frankly. The injustice was there is no ability of that individual, in my experience, to get that. So to get that certificate.
Well, I don't recall the exact procedures. My understanding at the time and what the Bureau of Prisons told us was that he was free to take, and I also, my understanding of Connecticut law, and perhaps I am wrong about this, but my understanding of Connecticut law from what we had been told was that he could send his dental records from the prison to an outside provider, and an outside provider could review those records and, offer the good faith certificate.
Understood. So what is your knowledge about state practice book rules, that kind of stuff? I know you have acumen with regard to the feds, but do you have any acumen with regard to the state rules?
So I have not practiced in state court. I am broadly familiar with the practice book, but obviously, that has not been where my practice has focused. I have broad familiarity with Connecticut law at various times. As I've mentioned, we've addressed Connecticut tort law in the Corley case, or in a case that we just won at the Second Circuit about the eggshell skull rule in tort law, which I haven't seen since law school, which was fun. Connecticut contract law. So the substantive law, I'm not obviously as familiar with as I am federal law, but I will say my job is as an appellate lawyer. I learn new procedures and new laws all the time. That's part of what I do. I provide advice, I provide guidance. And when I do that, I learn new things all the time. So when somebody calls me and asks a question about federal law, I don't know everything about federal law. I get calls and my first reaction is usually gather the information. And then I say, can I call you back? And I go to the books and I study and I look up the answer. And invariably, I then call back with a better and more nuanced answer than my initial reaction. So I would imagine my practice would be the same if I were fortunate enough to be confirmed to the Connecticut Supreme Court. I would do the research. I would do the work to look things up. Now, about Connecticut practice in particular, I would, of course, hope to learn from colleagues on the bench who have more familiarity and maybe even practice from practicing or being trial judges and superior court judges in the state system. I know a number of people who are current superior court judges. I would expect to learn from them. I would expect to gather from their experience, just as I hope they would gather from my experience and my perspective. It is one of the great things about a multi-member court is that people come to that court and that experience with a lot of different views and a lot of different experiences. Some people come with civil experience. Some people come with criminal experience. Some people come with deep experience as a trial judge, and some people come without that. I think different perspectives and different experiences are good. I would expect to do a lot of work to get up to speed, and I would expect to learn a lot from my colleagues.
So just to go back, because I did take very basic portions of our practice book with the intent of asking you about those. And I don't want to take up the time of this committee. And but am I to understand, when's the last time you opened up the Connecticut state practice book?
I reviewed it in conjunction with this process. I am broadly familiar. I am, fully aware that there are a lot of distinctions between Connecticut practice and federal practice. But that said, I spent a fair amount of time looking at the rules, for example, of appellate procedure in the Connecticut practice book. The broad outlines of that practice are, broadly familiar to what I am familiar with. The details and the rule numbers are going to differ. But over the course of my career, I've practiced in the 8th, 9th, 10th, federal circuits, 3rd Circuit, Colorado Supreme Court, District of Connecticut, 2nd Circuit. I learned new rules and I learned new practices. Now, obviously, I would have to become more familiar, but I would learn those rules. And certainly at the Connecticut Supreme Court, the way those questions would come up would be in the setting of a legal question that would allow me the time to get up to speed on those rules and how those rules operate in practice. Understanding, of course, and this is one of the things that I think is crucial, that the legal question is going to come up and framed not as the day-to-day practice, like how do you actually get this piece of evidence into evidence, but what does that mean as a legal matter? How did that affect this case legally? And also providing guidance for the trial court, understanding how this question is causing problems or not causing problems for trial judges and litigants. And I would expect to learn from my colleagues on that.
No, I understand. And I would think that, I mean, we're talking about state court as opposed to federal court. And, certainly if you were being, questioned by Congress or the Senate, actually, for the federal bench, that would not be a question, but no background in state court. I'll go on. Recently the judges met and adopted a practice book section that changes the percent of cash bail. And I know, being a federal prosecutor, you get involved with bail and some significant cases. And are you aware of that recent change?
Yes, broadly, not the specifics, but broadly, yes.
Okay, what is your knowledge?
My knowledge is that they changed to lower the cash bail requirements to make it a little bit easier for people, or to not require as much money up front. I think for cash bail. That's my general knowledge.
Okay, and a position has been taken that bail is not so much a legislative inquiry, but a judicial inquiry. Where do you fall on that?
So, and I just need to be clear here. My understanding of bail in Connecticut is, it's different from what we are in the federal system. There is a provision in the Connecticut Constitution that provides some guidance, and I understand this committee has been considering changes to that part of the Constitution and perhaps putting forward an amendment. I also know that the Connecticut practice book, controlled by the Judiciary, controls, has a lot more to do with bail and setting the specific conditions. And, can the legislature weigh in there? As I understand it, I would think that the legislature could enact general policies, but I think they would have to be harmonized with what the practice book says. And I don't want to go any further because I don't want to step into a separation of powers issues and who has this role, because I would have to study the issue more clearly in Connecticut law to make sure that I understood the proper role. I understand the primary responsibility to be with the judiciary and the Connecticut practice book, but I don't want to overstep my knowledge here. This is one of those areas where I would want to do a lot of research before I had a definitive.
Okay, well, I mean, there have been points of time where statute and practice book have been in conflict. So, but I'll go on. When did you originally apply to become a judge in Connecticut?
In March.
Of 2023.
Yes.
Okay. And how did that come about?
I just want to be clear with your question. I was contacted and asked if I was interested in being considered for the then open position on the Connecticut Supreme Court.
And who contacted you?
Former counsel to the governor's office.
Nora Danny,
Yes, sir.
who you used to work with.
Yes.
And so it's fair to say at that time you had never gone through judicial selection.
Correct.
Have you ever applied or expressed an interest to be a federal court judge?
Yes.
And when was that?
Well, I don't recall exactly. I mean, there have been a few openings over the years that I have applied for.
Okay, I mean, that's of concern, we've had three, I think. Omar Williams, we appointed in 2017. He was taken by the feds. Maria Khan, we know about that situation. We spent a lot of time doing this, and recently Vernon Oliver, Judge Oliver from Middletown, he's up for a district court slot also.
There's also Judge Bryant.
Judge Bryant as well, yeah. So and how many times did you go before judicial selection since March?
I went before just judicial selection once.
Okay, and there was an article that claims that they met once and sent you a letter saying that you were appropriate to be a Superior Court judge, and then there was another letter. Can you confirm, deny I mean, this secret process needs to be pierced at some point, but what actually happened?
I can tell you what I know. I'm not on the Judicial Selection Commission. I don't know their procedures and their processes. And as I understand it, they're supposed to be confidential. So I can tell you what I know. I submitted an application to the Judicial Selection Commission and asked to be considered for a judicial office in the state of Connecticut. I submitted the application. They asked me to come in for an interview. I appeared for the interview. And after that, they said they had approved me. And I was later told that according to their own procedures, they had to consider me separately for each potential bench at the state of Connecticut, whether Superior Court, Appellate Court, or Supreme Court, and that they had not done that at their meeting. And so they did that at their next meeting.
Okay, so they didn't call you in again for another interview. They took the information and sent a new letter. Is that fair to say?
I can tell you they did not call me in for another interview. I don't know what procedures they did at their next meeting, but at the end of that, they sent me a new letter confirming that I had been approved through whatever procedures they have.
And when you say the process is supposed to be confidential, I expect that in March you had not submitted, March was when you submitted your application to the Judicial Selection Commission, correct? Okay. I did reach out to them and ask them for a copy of your application, and they claimed that we could not get the application. However, as part of that application, you were required to give a release. Do you recall that?
I do.
And that release expressly says, I hereby authorize the commission to release a copy of this completed questionnaire to the office of the governor and to the Judiciary Committee. So that's troubling, because I would have wanted to see the entirety of your questionnaire, but unfortunately, that committee has refused to provide. So with that, I have to ask you some of the questions that would have been in the questionnaire that they won't let us see for whatever reason. In the questionnaire, you're not just asked about 3 cases, you're asked about 10. Do you recall the other 7 that you mentioned?
Not off the top of my head, no, sir.
Okay, as you sit here today, because we know the Harrington case was, you handled post judgment. Can you give me 2 more that you think were most significant in your career?
I'm positive that I listed the Ganias case that I also listed on the form here.
Yep.
That was a case I'm really proud of. I handled the litigation at the Second Circuit when the Second Circuit took that case en banc and considered the scope of Fourth Amendment protections as relevant to searches of computer data, which was a really sort of a new area. It seems like it shouldn't be new, but it really is in many respects. So that was one of the cases.
And then we already knew about that because that's in
Okay.
a questionnaire for this body. But once again, the only place that we can get information about you and your opinions is positions you've taken. And I think it's important for us to know what you think is significant, and for us to be blocked from getting your application, to know those other 7, while being, is a little troublesome. I'm just asking you here today, your 20-year career, can you give me 2 more that we don't know about?
So I'm trying to remember what else I listed on that form, and I don't recall. And I think one of them that I listed was United States versus Bell.
Bell?
That was an individual who had been charged with shooting at a police officer when he came to execute a search warrant. I think it was a search warrant. It's been many years, but he was eventually convicted at trial, and I handled the appeal. Considered it significant to be doing that.
Why was it significant?
Because I take violent crime cases very seriously, and because I consider it part of our mission at the U.S. Attorney's Office to, part of what we do is promote public safety. And, an individual who shoots at police officers who are doing their job is somebody that we are concerned about as a public safety matter. And so I'm proud of the work that we have done and that I have done to do that. And the charges, I think the other thing about that case, and this is another sort of the balance of where I have always drawn the line, as I recall, Bell, one of the challenges was to statements that the prosecutor had made in closing argument, and allegations that she had overstepped the bounds of legitimate advocacy, and over, being closing arguments in trial, especially in rebuttal arguments, sometimes people get a little overheated, and the courts have said prosecutors are entitled to be zealous advocates, but you can't cross a line. And one of the allegations in Bell, as I recall it, and I'm not going to be able to come up with any of the specific comments that she made, but there were like that she had said, 10 or 15 things that were over the line. And so one of the reasons that I handled it was because as a prosecutor, when someone accuses you of misconduct, because the claim is a claim of prosecutorial misconduct, we in our office take that very seriously. And we also understand that it's hard to defend yourself, to be sort of objective and defend yourself as a claim of prosecutorial misconduct. And one of the things that I did in that case was, after I read through the record and we were working on the brief, I sat down with the prosecutor and I said, look, there are, let's just say 10, I don't remember how many there were. There are 10 things that they say you said that are wrong or that were too far. I agree on some of them. You shouldn't have said these things, and you got to do better. And on some of them, I think it was okay. I probably wouldn't have done that. That's not my style, but it was probably okay. At the end of the day, because I think it was ultimately harmless, we're going to defend this, but you need to do better. And, I remember talking and, having engaged in a colloquy at the argument with the judges about this, and, saying, yes, we agree she went too far in some. We don't think it ultimately affected the verdict, but we agree she went too far, and we've talked to her about it. And so I was really proud of the work that we did in defending a conviction, a violent crime, and also working to ensure that we were doing our best job.
In the application, it also asks you to identify 6 lawyers with whom you have dealt most frequently in the last 3 years. Do you recall who you put down for those?
I probably listed the United States Attorney and First Assistant U.S. Attorney who I've worked with.
Dunham, and is that who you're talking about?
No, the U.S. Attorney right now is Vanessa Avery.
Okay, Avery is the one you were referring to. Okay, you were referring by title, that's all.
Oh, right. So yeah, so I wasn't sure if you were familiar with her name. Vanessa Avery, Al Pavlis, who's our first assistant. I think I probably listed Mark Silverman, who is our current criminal chief. He used to be the deputy appeals chief. I was his supervisor for a number of years. Boy, I'm not, if I'd known I could have brought it with me. I don't remember the list. I think I listed Susan Wines, who's our executive assistant U.S. attorney. I'm sorry. I really apologize. I don't remember.
No, I know it's one of I would have done if they had not blocked us getting it. But anyway, another question, 6 lawyers and or judges who know you in your work, who would you have put down for that?
Okay, I listed Judge Sarah Nagala. I listed Judge Bill Nardini. I listed Shelley Sadin, who is currently on the faculty at Quinnipiac. Who else did I list? I just don't recall off the top of my head. I think I listed Nora Danahy. And I'm sorry, I'm blanking on, I probably listed Deirdre Daly, who was a former U.S. attorney.
You know, and Judge Nadala, when's the last time you had a case before Judge Nadala?
A case before her?
Yeah.
I have not had any cases before her. She was just appointed to the federal bench. I want to say she took the bench in 2021 or 2022. I don't remember the exact timing, but she had been an AUSA in our office for many years. And so I knew her from that work.
Okay, Nardini, when's the last time you had a case before Judge Nardini?
So I've never had a case before Judge Nardini. He is someone that was in our office for a number of years. He clerked for Justice O'Connor 2 years before I did and interviewed me when I was interviewing with her. He was then a longtime member of our office until he was appointed to the Second Circuit. He doesn't hear cases from our office because of his longstanding ties to our office, but he was my supervisor until I became appellate chief.
So you applied to judicial selection in March and then you went before them in March, right?
Correct.
So it was like within a week.
Correct.
And then at that proceeding, did any member of the commission recuse themselves?
Not that I'm aware of. But I don't, they didn't introduce themselves. They, the people who were there. I don't know how they voted or if they recused themselves or not. I just don't know.
Okay.
That wasn't part of my knowledge.
Okay, well, it's part of the secrecy, but are you aware that one of the members of the selection committee used to work with your husband?
Yes, I'm aware of that.
Okay, and when did you first become aware of that?
I don't know.
Mr. Chairman, I have no questions at this point.
Thank you. Attorney Glover, do you need a brief recess? Are you okay to keep going?
I'm good. Thanks.
All right. Further questions or comments? Representative Osborne, ahead next.
Thank you, Mr. Chair. Good morning, or are we at good afternoon? Good morning still. Thank you for being here and congratulations
Thank you.
on your nomination. One thing you said struck me, and it's one of the reasons I also went to law school, was that I never wanted to stop learning. And I knew that in the law, there would always be opportunities to learn. Even if I got bored of a subject matter, I could always, switch practices. There would always be something to learn. And I'm certainly doing that here at the legislature. But when you're going to be serving on the Supreme Court, you are supposed to be the one who has the answers already. You're supposed to be the one making the decisions and deciding what the correct answers are. And that's why, we're probably prodding a little bit today, because as the good representative previously stated, we don't have prior decisions of yours to get an idea about how you might decide things on the bench. And certainly we need to basically understand what your gut is, right? What is the gut instinct you're going to bring to things? And we don't have any illumination into that. So one thing that I recall from having myself clerked at the New York State Court of Appeals, the thing I learned very poignantly there was that bad facts make bad law, right? So, you know, when you say that policy is a legislative decision, I disagree with that a little bit, about a lot, because I know that policy is frequently made by courts and especially at the Supreme Court. And that's why it's particularly important for us to understand these things. So a couple of things that you said in response to Representative Fishbein. You said you've never taken a position as a prosecutor that you personally disagree with. Could you tell us a little bit more about that? Because I know that just in my freshman term here, I have had to make decisions to vote against bills that I thought were good policy, but that maybe didn't meet constitutional muster. So can you tell us a little bit more about when your personal beliefs have, because I guess I find it almost incredulous that sometimes your personal beliefs have not conflicted with the duty you have as a prosecutor and someday the duty you might have as a judge. Is there any instance in which those two things have collided?
So, you know, when I say that I've never had to take a position that I disagreed with, one of the great things about working in my office is that I have been free to voice my position, voice my views. And in the law, there's often a range of options. And I have been able to advocate for the range of options. You know, sometimes I think the range is narrower than somebody might think. Sometimes it's larger, you know, but I have been able to advocate and to say, you know, I think this is something that we should or shouldn't do. And I have never been asked to sign a brief or to take a position that I disagreed with. I can point to two situations over the course of time, and I have to be careful because some of these are basically internal deliberations, and I you know, I'm not at liberty to describe. So I'm going to try to talk in generalities, but hopefully give you enough to understand. Many years ago, we had a case where there was a really, really sharp disagreement. And part of my job is when we lose, when the government loses in the trial court, many times we can't appeal because, you know, there's double jeopardy concerns. You know, once somebody is acquitted, we can't retry them, right? But there are a handful of situations where we can appeal. And if we are in one of those situations where a trial judge rules against us, for instance, throws out a verdict after the jury has already come in, the government has the opportunity to appeal. And part of my job is to say to the U.S. attorney, I think we should or shouldn't appeal in this scenario, right? I think that this is my evaluation of the merits. This is my evaluation of the potential for appeal. So that's kind of the scenario. Many years ago, I was in a situation, we had a case where a trial judge had thrown out part of a verdict, and the trial team was, well, not thrown out part of the verdict, threw out the whole verdict. So this was a murder case, actually. And the judge threw it out after trial, and the trial team felt very, very strongly that we should appeal. You know, this was an outrage. This was an injustice because we had a murderer or somebody who'd been convicted of murder whose conviction was not going to stand. When I looked at the case, I thought that we couldn't in good faith take an appeal because I felt like we hadn't done our job at trial. We hadn't made the right arguments. And in fact, I felt like we had made arguments that were directly contrary to what the trial team wanted us to argue on appeal. And I didn't feel like that was our place as the government. And in this situation, what the protocol is that the appellate chief in an office writes a memo to Washington, because in the Department of Justice, the U.S. Attorney's Office doesn't get to decide whether to appeal. It has to be approved by the Solicitor General. So the U.S. Attorney asked that we send a recommendation to appeal to the Solicitor General's office, but also asked that I send my memo saying we shouldn't appeal.
So if I could interrupt for a moment. So in essence, as an appellate attorney for the government, you are 99.9% of the time defending a verdict that your office has won, correct?
I don't know that it's 99% of the time, but most of the time, yes,
Frequently,
yes, yes,
frequently,
Yes.
more often than not.
yes.
So in those instances, have you ever had to argue or drafted a brief on appeal defending a verdict that you think a defendant was actually wrongly convicted on?
No,
Never. Okay.
no. And I will say I have drafted briefs carefully sometimes. So there have been occasions where, for example, there's a challenge to an evidentiary ruling. And we feel like the evidence was properly admitted. But I've refused to put in a harmless error argument because I think, look, if the court disagrees with us and on this, this was a key piece of our evidence. We can't say this was harmless, and so it should just be reversed. But I have never defended a conviction where I felt like somebody was wrongly convicted.
Have you ever been asked to?
No.
Okay. So I'm turning specifically to your to the questionnaire that we do have. By the way, just quickly following up, you answered Representative Fishbein that you did recall that the application that you signed that the Judicial Selection Committee reviews has something in it that releases that application to us here. But they apparently did not release it to the committee. So did you not sign that release?
So I did sign a release.
Did you subsequently revoke it?
No, and can I just be clear? I don't remember what that release said. That sounds vaguely familiar, but I mean, I read it at the time, but this has been a couple months ago, and I don't know what.
So it's not through any fault of your or any cause on your part to not have it released to us.
No, I have no, I don't
Okay.
understand their procedures.
And
Or
if you
no.
had your druthers, you would be happy to have us review that as well.
If I had to recall, my recollection would have been that I assumed they gave them to you
Okay.
because of that release, but I don't,
All right, thank you very much.
I'm not in control of their procedures.
And just in general, I want to talk about stare decisis, about
Mhm.
precedent. You understand why. And it sort of runs through a number of your questions, but I'll pull up two questions in particular. Do you have your application in front of you there? Or
I
your
do.
questionnaire, your Supreme Court?
Which the Supreme Court ones?
Yes. So just right off the bat, number 3, you answered in response to the question, how do you feel about the statement that judges should interpret the Constitution to enforce the original intent of the drafters? You gave us some answer and you said, I would also consider the text precedent and stare decisis. And then if I flip over to question 11, the question was specifically, do you believe affirmative action is proper to remedy discrimination? Do you feel hiring quotas are a legitimate tool in implementing affirmative action? And you answered, the U.S. Supreme Court is currently considering the constitutionality of affirmative action in educational settings. If such issues should come before the court in an educational or other context, I would apply governing law to resolve the matter. And that raises a number of questions for me because, what is governing law? Are you referring to the Supreme Court case that's about to be made? What if the current Supreme Court that comes down ignores stare decisis or precedent? What if the Connecticut Constitution might require a different outcome? And more importantly, this was a question about, do you believe affirmative action is proper? And do you feel hiring quotas are legitimate? And those are really important questions that I don't think quite got answered in your response. And they're more important to us here today because we don't have prior decisions. And this gets to, we need to understand your gut. We need to know you and how you do feel and how you view things. So I think thinking about precedent as well, but we want to hear from you about your beliefs and your gut. So I'd ask you to expand on question 11 and not expand, to answer question 11 specifically. Do you believe in affirmative action as an appropriate or a proper remedy? And do you feel hiring quotas are a legitimate tool?
There's a lot in that question, so let me
There
try.
is. Oh, I'm sorry. I gave you a lot. Go for it.
You did. So let me try and unpack it by saying, I think there are two separate questions.
Mhm.
Is affirmative action constitutional? Meaning is
That's
it
not what this question is.
right? And so the second part
Right.
is it something that would be a good idea? Is it something that is it a good tool? That's a policy question. Let me tell you what I see.
And as I said before, policy gets made by the Supreme Court all the time, and we want to understand who you are and what your gut instinct is on this. Understanding that sometimes you may not be able to follow your gut, and I get that.
Before-
Again,
Before you answer, just going to caution you, Representative, to allow her to answer the question, then follow up and clarify so that we can all follow the exchange. Thank you.
certainly, thank you, Mr. Chair.
So the separate question of, is it a good idea and is it a policy? Quite frankly, I think that's your job. I can tell you what I think in my experience. Our public institutions, in my belief, our public institutions, our leadership should reflect the diversity of our communities for a variety of reasons. But one, because I think our communities need to know that when they look up and see the people who are making decisions about their future and about issues that affect them, that their perspective in their community is being heard and represented. I also have found in my experience that decision-making bodies at any level and in any organization, whether it's a legislature, whether it's a multi-member court, whether it's a U.S. Attorney's office, make better decisions when they have a lot of different views, when they have different perspectives, when they have diverse views. And by hearing different perspectives and hearing from those views, you make better decisions. So how do you get there? That's, that's a devil in the details kind of question. And I think that's a policy question that I would leave to you. But I want to address sort of the policy, the like Supreme Court justices address policy, right? And make policy. I break it down into three things, three different categories. One is statutory interpretation, where the policy is implemented and written into statute. And this is where I think the Connecticut Supreme Court or any court is really at its most narrow, right? You're not supposed to be importing policy. You're supposed to be implementing and applying and enforcing the statute as written to the best of your ability. And if a court gets it wrong, this body or the legislature can change that and say, well, we didn't mean that, or we don't mean that now, we're going to change it. That's one category. There's the common law, which is really judge-made law, and which is where courts are, in fact, properly supposed to be making decisions about policy. And I think one of the classic areas is going to be tort law, where you're looking at, is there, for example, in a negligence case, is there a duty for this party to have taken care in this context? In that case, yet again, if the legislature disagrees, if the Connecticut Supreme Court were to say, in this context, there was no duty for this entity to have this entity didn't have a duty of care in this context, the legislature can enact that. And then you get to the constitutional, like where you've got, where there are, a court is interpreting broad and deliberately broad pronouncements. What is equal protection? What is due process? And that's where we see what some would call policy beliefs. But this is where I feel like, and to answer what I look at in question 3, I don't see judges as unconstrained. The text is there. The original public meaning is important, because if there was a word that had some particular meaning at the time, even of a statute but even a constitution, the original public meaning is important to understand, but it's not going to be dispositive, because of course, we're going to have the prior cases and the precedent and the wisdom from those prior cases that have defined what those words mean in new contexts over time, and building on those precedents. What are the principles that we derive from that? And looking at those principles derived, how do those principles apply in this slightly new context? So I'm not going to fight your suggestion that there is room for policymaking. I just see it as very constrained.
So I'm going to push back on that a little bit again. Because some of the broadest policies, some of the most culture shifting policies in this country have come from our Supreme Court, from the US Supreme Court. Think about something that seems innocuous, like the Commerce Clause. If US Supreme Court had not found an expansive interpretation, we would have a completely different economic strata in this country. But less innocuously, the right to privacy. If the US Supreme Court had not found that a right to privacy exists embedded in the Constitution, which doesn't actually talk about that, we would not have had Casey, we would not have had Roe v. Wade. And if the US Supreme Court had not, unconstrained apparently, decided to shift policy, we would not have had Dobbs. So I'm going to come back to the question that was asked of you, number 11. Do you believe affirmative action is proper to remedy discrimination?
And I'm going to tell you that I think that's a policy call.
But we need to know your policy instincts, because
Representative Osborne, let her finish answering.
my apologies.
And if she doesn't want to give you a yes or no answer, you've asked her a couple times. If she doesn't want to give you a yes or no answer, then
Then I'll move on.
yes, thank you.
I'll just, finish my answer. And since that, different bodies and the equities and the wisdom or the pros and cons of affirmative action are tough calls. And I think they're tough policy calls, and different bodies have taken different positions on those. Different states have said, we're not going to allow affirmative action in certain contexts, or we are in different contexts. I think those are policy calls, and I would not, my view of that is not something that would control, because I would be looking at what are the, and also the wisdom of a policy is not the issue when you're talking about the constitutionality. The question is, what do the precedents allow in this context? So that's how I would approach that question.
And if I may, through you, Mr. Chair, so that means that you would be guided by precedent in your analysis of affirmative action, not your personal beliefs?
Correct.
And you're not sharing your personal beliefs with us here. Moving on to question 12 in the application, or in the questionnaire. Again, I apologize for calling it an application. And I believe Representative Fishbein touched on this a little bit. The question was, do you believe the balance may have begun to tip too far in favor of criminal defendants? And you spoke a little bit with Representative Fishbein, and I see your answer here talking about the fact that police and prosecutors work within the existing legal framework. But again, I don't believe we heard from you either in your response here or in response to Representative Fishbein. Do you believe the balance has begun to tip too far?
I actually think I did answer that question, but maybe I wasn't clear. I don't personally think so, but it's also never been something that I've, sat and thought about, because whether these constraints are here or not, it's just a system that we work within. There are rules for how we conduct criminal cases. For example, the federal rules of discovery for criminal cases, there are all kinds of constraints. And, whether I like them or not, or whether I think they're a good idea or not, they are what they are. They're the rules that we follow when we are, enforcing criminal laws. And I defer to the wisdom of those who have adopted those and have thought about the pros and cons of those policies and how they balance a defendant's rights and the rights of the community to effective prosecutions. So I don't, it is a system that we work within. I don't see it as something, and over time that, those balances shift. And it's something that I have always worked within.
So I was speaking less to, and I believe the question was speaking less to the, the civil procedure rules than it was to, the Equal Rights Amendment, to a more expansive view, trying to get away from, practice book minutia, and wondering about your gut again on this.
So I didn't read question 12 to be about practice book minutia, and I apologize if that's how my answer came off. I was actually talking about sort of broader perspectives. My view as a prosecutor at the U.S. Attorney's Office has always been that our job is to seek justice, and that involves considering all of the stakeholders in the criminal justice system, the interest of the United States, but also the interest of the defendants. Are their rights being protected? Are they getting adequate discovery? Do they have adequate counsel? Are they, are they being informed of everything that's happening before them? Do they understand what's going on? But we also consider public safety in the community, and we also consider victims. And so all of those are stakeholders in the criminal justice system. And I understood question 12 to be about that. And that the last question, how is society served by protecting the rights of criminal defendants? I think it's core to protecting society, because one of my core beliefs is in the rule of law, meaning that we all are subject to the same rules and we're all subject to the same standards, and that we're protected when everybody has access to those same protections, regardless of their station in life, their quality of representation, or what they are accused of doing.
Okay. Getting back to the constitutional right to privacy, I know that you spoke very eloquently earlier today about your personal belief that Dobbs was incorrectly decided, and that it's not a state rights issue. Do you think that the U.S. the U.S. Constitution does contain a right to privacy?
Yes, it does.
And isn't that a policy decision on your part?
No, that's a reading of decided cases and what the U.S. Supreme Court has said about a right to privacy.
But not a reading of the Constitution or the statute, correct?
Well, it is a reading of the Constitution, right? I mean, we have in our legal system common law interpretations, right? And the right to privacy is something that has developed over time from generations of judges or justices reading the Constitution and reading those broad guarantees that are in the U.S. Constitution of due process of law, and saying that's what this means in different contexts. So it's not a policy, it is a reading of the prior cases and the principles that are derived from those cases.
So now that we have a couple of, we have one precedent that you and I both agree is incorrect. And we may very well be dealing with a couple of precedents that are about to be made that I know I will disagree with, that I consider unconstitutional. Where do you fall on respecting stare decisis, or respecting precedent that has not itself respected precedent? This is a tough one.
No, it's a really good question, because I feel like we're in something of a singular historic moment. I really do. I found Dobbs to be a gut punch as a lawyer and as a woman, right? Because you and I are different today than we were a year ago, right?
Mhm.
And I found that hard. I also found it hard as a lawyer because I actually really believe in stare decisis. And so what do I do with a case like Dobbs that says this is what the US Constitution means now? Well, what do I do is this. I don't get to change what they say the US Constitution means, right? But what it has done for me, it has emphasized the significance and the importance of state courts that can come to their own conclusions about what state constitutions mean and the significance and the importance of having a strong and independent judiciary at all levels of our system that can make independent evaluations of separate documents that are not controlled by that.
Are you aware that Connecticut has a Religious Freedom Restoration Act?
I'm not specifically familiar with that act, no.
So you may recall Employment Division v. Smith, the peyote case, right?
Mhm.
Laws of general applicability
Right.
don't have strict scrutiny applied to them at the federal level anymore. But Connecticut, in response to that, in 1993 or 94, reinstated strict scrutiny through one of our statutes. So we do have to apply strict scrutiny to laws of general applicability that touch religious freedom or the exercise of religion in Connecticut right now. How would you balance that with the right to privacy that we just discussed?
That's a pretty abstract question. I just want to clarify also that federal law, the after Employment Division v. Smith, and I don't remember the timing, also enacted. There are, there are pretty significant protections for religious freedoms in the federal side as well. And we deal with those. I see them most often in the prison context where prisoners want their religious rights protected. I have a hard time answering that in sort of an abstract point without understanding specific facts or arguments. And I would just say that without predicting how I would rule in any particular case, especially without briefing or understanding what the issues would be, I understand the US Constitution to be a floor and the Connecticut Constitution to provide greater protections for civil rights, certainly. And I would have to look at the precedent and how those cases have been applied and how that statute has been interpreted before I could understand how it would apply in this context.
Right, thank you. Just look at my notes from my prior thing. I guess it comes back to me, for me, the ultimate question comes back to precedent and stare decisis these days. And I know that, there's a laundry list practically of current US Supreme Court justices. It's Gorsuch, Kavanaugh, Alito, Barrett. They've all answered that they would follow the rule of law and they would follow precedent. And I guess I'm looking for some greater comfort since we don't have decisions of yours. Since we don't have any examples of decisions you've made and issued. I'm looking for some comfort because we now know that not every justice on the Supreme Court who's sitting today has told other inquisitors, I guess, the truth when they've been asked that question. So I really do appreciate the exchange and thank you for your time. Mr. Chair.
Thank you. Representative Dillon.
Thank you very much. And is it afternoon? Good afternoon. Yep. I congratulate you on your nomination. And I don't know you at all. I mean, you're a black box to me. So at the risk of being repetitive, I have a couple of questions. One of which would just be, I think, reciting what I think we know about you, because I have a notion of what you may face if your nomination is successful, but we really don't know. We don't know. And obviously everything is being tainted by what's happening with our Supreme Court. And maybe that isn't obvious, but it is to me. That there are some very dramatic things happening in Washington that that put a lot at risk. And if I could quote Justice Kagan, actually, the stakes could not be higher at the state level. Because that may be the thread we have when it comes to some issues. So this is pedestrian and I apologize. Well, I don't apologize. That's a girly thing. You were born in Columbus, true?
I was.
Columbus itself, not Worthington, not Bexley, Columbus.
You'd have to ask my mother. I left Ohio when I was 3, but I think I was born in Columbus. My father was at Ohio State University at the time, and I think they lived. in the
Right,
city.
yeah, I went there too. So, and you grew up, you didn't grow up in Ohio?
No, my father got a job at Texas A&M University.
Okay,
And he moved us there when I was 3. And so I grew up in Texas.
so you went to a lot of good schools, or where I would consider, anyway, Duke, whatever, but you also went to University of Chicago Law School, which is a choice. It wasn't as unique by the time you went there. But even so, the whole issue of law and economics was still a big deal, was it not?
It was, I will say that most of that choice turned on my then fiance, now husband, who was already moving back to Chicago. And so that was my geographic pull.
But was Richard Posner faculty at the law school when you studied there?
Yes, I think he was on the faculty until he retired.
And did you study with him?
I never took any classes with him, no.
But when you left, you went to clerk for him.
I did.
Okay, and was there any particular reason that you were interested in his? I know he has a lot of opinions. And separating his popular writing sometimes from his opinions is another issue. But was there any particular reason that you chose to clerk with him?
You know, he is, well, he's still alive, but he's no longer on the bench.
Well, he has dementia, I think, yeah, but
I'm sorry?
I think he's not well. He's-
Right, no,
yes,
exactly.
right.
He was a brilliant jurist. And one of the most cited legal scholars, probably still to this day, and most cited in opinions. It was actually a phenomenal experience to clerk for him. His academic writings, he really carried on 2 full-time jobs. He was a full-time appellate court judge, and at the same time was doing all of his outside writing, which we weren't involved with because he had research assistants and people with his publishers. So we weren't involved in that. We were involved in his judicial work. And what I remember about him and what I learned from him is not so much the substance of his decisions, because quite frankly, you know, as a law clerk, your job is not to adopt and agree with everything that the judge that you clerked for.
But you do research.
You do research, and what he wanted us to do was to challenge him. And the reason that I said it was a phenomenal experience as a lawyer is because he is, I mean, to this day, one of the people who I've worked with who is most open to criticism. You could say anything to him, and he wanted you to say anything to him. And he wanted you to say, no, you missed this fact. No, you missed this part of the law. He wasn't necessarily always going to agree with you or going to change his mind, but he wanted to hear different perspectives, and he wanted to hear challenges to what he thought. So what I remember about that experience and what I learned from that was the real importance of humility in making decisions, and knowing that you need to be able to hear people who disagree with you and hear different perspectives. Even if it doesn't end up changing your mind, sometimes it does change your mind because you just didn't know something, but it might change your perspective or how you think about a case.
And then you went to Kellogg. Yes, which was a pretty new firm.
After my clerkship with Justice O'Connor, yes.
Right. And was Justice Gorsuch there then?
He was there at the time.
Uh-huh. So it was a pretty small firm at that time, wasn't it? Or no? I think it was brand new when you
It was,
were.
well, I was a few years old. I don't recall exactly when they were formed. Peter Huber, who was, I think he's now deceased, but he was one of the founders. He had been an O'Connor clerk many years before. That was sort of my introduction to the firm. I didn't work with now Justice Gorsuch. Most of my work was with an attorney named Reed Feigl.
Mhm.
In doing corporate criminal investigations
Okay.
and some civil work, but I didn't work with, I mean, it was a relatively small firm, but it wasn't that small. There were a lot of people who did a lot of other different kinds of work.
You went from Kellogg to Justice, right?
Correct.
When that, and this isn't, that it may be not matter at all. I assume, does that mean that you worked on the political campaign of President Bush?
Oh, no. I was actually hired by the Clinton administration.
By the Clinton
Yeah.
administration? That's a hoot. Okay.
The Department of Justice has a long tradition. There are of apolitical career appointees in the Justice Department at the U.S. Attorney's Office level. In my office, for example, there's only one person who's a political appointee, and that's the United States Attorney. Everybody else is a career employee. At the Department of Justice in the Environment and Natural Resources Division, I was hired as a career employee under the Clinton administration. But that means that I worked for the Department of Justice as a career employee during that time.
Well, one of the reasons I'm asking you these questions is that your brief in justice was environment. And
Correct.
right, and having never worked at justice, I don't really necessarily know what your role was. You weren't in interior, you were in justice. But you were there at a time of intense concern to me, and that was when President Bush came in and pulled out of the Kyoto Protocol and challenged the science of the protocol, which in some ways was as damaging as pulling out itself. Were you involved in those events at all? Did your office or the office where you worked for play any role?
I was not involved in those, and I wouldn't be able to tell you whether anybody in my office. I was in the appellate section. We defended the role of the Department of Justice in the litigating divisions, and putting aside sort of the U.S. Attorney's offices, which do a little bit of this as well. But the litigating divisions defend the United States and its agencies. So we weren't a policymaking body. The Department of the Interior would make policy or adopt a rule. And then our job was to either defend it or not defend it, depending on, the law as it applied. I don't recall that specific policy.
So you had said that you were not involved, and I'm trying to figure you out. I really don't know you at all. And as I said, I'm concerned that the stakes are very high. We have, and if I could, on climate alone, if you look at the West Virginia case, which is why I was quoting Justice Sackett. Her dissent in that is outstanding. I didn't think anyone could get me standing on a chair excited about administrative law, which I studied. But she was, it sounded like a new verse for solidarity forever, talking about, she was challenging the dismantling of some of the regulations. And if we're looking at a scenario where the Supreme Court is looking at the FDA, the EPA, and let's say with the FDA, we could say it goes back to Teddy Roosevelt, but it goes back to, probably the 10th century too. It was to protect an honest miller from a dishonest miller who filled his flour bag with sawdust. So that the roots of that are, in English common law, well before, the Americans in their litigation jumped all over it. the consequences to us could be very, very grave of what they are doing. And it may well be that the Connecticut Supreme Court for us in our little world here could be the firewall on and climate, could be the firewall on race, and we'll get to that, on education, which is in our Constitution. So it much matters that we know who you are when we're voting, and partly because of what they're doing elsewhere, we may not have anywhere else to go, and that puts a very heavy responsibility on this committee, and going forward in the General Assembly. So I do want to get to, and it sounds political, and it really isn't, the letter that you signed for Justice Barrett. Were you aware that another woman had been nominated for that position?
I guess I'm not sure what you're talking about.
Okay, Myra Sibley had been nominated to that position, and Mitch McConnell refused to take it up. She was, I would say that, well, there were 10 nominees of color that were not taken up by the Senate that year. One of them was Myra Selby, who had been, I believe, on the appellate court in Indiana, had written many independent opinions. At that time, she was nominated for the 7th appellate. Amy Barrett, I'm sure, had a lot of potential, and certainly, sharp, whatever, but was a part-time lecturer at Notre Dame and had done some civil work. Without having met either one of them at the time, I was astounded. There was no way, it seemed to me, that Amy Barrett was as qualified as Justice Selby. There was just no way, and I just want to mention that that's one of the things that concerns me about that letter. Not because sometimes things happen in ways that don't look that clear, or maybe you're just being friendly to someone that you work with, but you may be, and maybe that wouldn't be the hill that you're going to die on. And I have to make that decision in this building every time I walk in the door. Which hill am I going to die on? How am I going to marginalize any ability to make an argument that's principled if I'm complaining all the time? And yet here I am saying, it bothers me a bit that the Mitch McConnell people held up 10 nominees of color for the courts, and one of them was Myra Selby, and every one of them was replaced by the Trump administration with a white person. And I don't know if you'd call that affirmative action. I think some people think affirmative action means you're elevating someone who isn't qualified, who's a person of color, and which is, kind of the 1950s notion of it. But what we saw happen was people screaming, they're going to replace us. And they pushed out more qualified people of color. And that was very, very troubling. And I don't know if you knew about that when you signed that letter. You worked there, so maybe you would have, but I wanted to hear your views on that.
So I don't understand that last part. I worked there. I worked with then Professor Barrett for 1 year when she worked with is sort of a misnomer, but we were clerks at the same time at the Supreme Court, and that's my knowledge of her. And that letter reflected my assessment in 2017 based on what I knew about her from 1998 to 1999, that she had the qualifications for a lower court nominee. I've certainly learned a lot more about her in the last 6 years than I knew in 2017 or even knew in 1998 or 1999. And both I learned about her personally and having watched her voting record, I guess I would say two things. I'm not going to demonize her. But when I look at that letter now, I can't stand by. I'm no longer comfortable with some of those statements. And I also, what I will, in 2017, I was scared like everybody else. I mean, more so today, but I was scared, right? I went to Washington the day after the inauguration for the Women's March, got in a car with two of my friends and we drove down because I was scared. But I also believed, you know, clearly naively at this point, I thought there were guardrails and I thought they would hold. And I thought that lower court judges were constrained. I thought the Supreme Court was constrained, and I was wrong. And looking back and knowing what I now know, I shouldn't have signed it.
Well, I'm not concerned with demonizing her. I think she's doing a good job herself. And I think there will be a record. I think people overlooked her because Kavanaugh drew so much attention, but he has roots in New Haven, by the way. But I am concerned about your judgment. That is, if you're asked to sign something, can you look outside the four corners of that letter and say, well, she has great manners, but how did she come to us? Well, they're pushing out a woman of color who's more qualified than she is, or at least as qualified. You know, that I would want to know, would you have the judgment to look at the larger picture of something that you're asked to do? And in some ways, because the letter is signed, she's on the court, you know. And she and her friends from, you know, the Brooks brothers, you know, Mr. Roberts and, you know, Mr. Kavanaugh, they're like, they can frolic, whatever, that's done. But I'm concerned about you and whether you're going, how much you're going to look around the corner at situations like that and have the mindfulness to really see that there may be another way to look at things.
You know, the world has changed a lot in the last 6 years. Those kinds of letters don't circulate and aren't signed anymore. At that time, I really, like I said, I thought the guardrails would hold. I thought there were constraints. I thought there were limits, and I was wrong.
Right, but I'm not asking, and I know I'm getting, I don't mean to perseverate. Well, of course I do, but I'm concerned about your judgment at the time. So not about what Amy Barrett did later, but your judgment at the time about the events of holding up all those nominees and then shoving in others. Would you have been aware of that, or would you even asked?
We were, you know, the letter reflects it was not a letter about anything beyond our experience with her at the court. I don't recall being aware of that specifically. It's hard for me now to look back and know exactly what I knew in 2017. I don't recall that specifically. It's possible I did know, but the letter was not an endorsement of her political views, her jurisprudential views, or of anything beyond saying, when we worked with her, our experience was this. And based on that experience, she had the qualifications.
Okay, well, I would just invite you to reflect, and I'm thinking of your response to Representative Osborne's question, that sometimes these issues don't come to us with a big bow on them saying, this is the choice you're making. Sometimes they're a little muddy. Sometimes you have to ask to find out how something happened. And I was trying to find out if you had known, for example, that you were writing a letter to support someone who was really replacing another woman who was more qualified than she was. And you didn't know it, it appears. and I don't know what you would have done under those circumstances, and it is a hypothetical, but I did want to mention that. So I guess my other questions would be, I am very concerned about, as I mentioned, about the West Virginia decision in Washington, which appears, and with the waters of the US, the Sackett case, which is going forward. So have you looked at if there's any potential for dismantling the current framework of water regulation? And there may well be. It may be that Connecticut law, which is a little bit stronger anyway, will be our only bulwark, as it were. Have you looked at all at the Supreme, because your own experience is criminal, from what I can see, and federal. Have you looked at all at some of the administrative actions taking place in Washington in the court, and what the implications would be for our own going forward for the cases that might come before us?
So just to clarify, my experience at the U.S. Attorney's Office is both civil and criminal. And we, the current Supreme Court has expressed concern in various ways with various parts of the administrative state and various types of regulation. I have not studied how that would play out in Connecticut. My view is that whatever happens at the federal level, Connecticut can go its own way. And Connecticut has a separate constitution and separate laws, and I would uphold those. I can't control what they do on the US Supreme Court. It's certainly something that is an attorney who has represented agencies and represented challenges to agency conduct. Most of those are handled by Washington, but there's a lot of concern about that because as a practical matter, the federal government operates through agencies. And so that's it makes it harder for the federal government to do its job and what it's been set up to do. But I think that, focusing on Connecticut, as in so many areas, the Connecticut Constitution is different, and this state can choose a different path. And I would, I think that's one of the things, as I said, I think it was to Representative Osborne, that, I think these last several years have emphasized to me the importance of having a strong and independent judiciary at the state level for that very reason, because we're in a situation now where the federal constitution may not be as robust in protecting some things or the framework that we want. And so we have a strong and independent judiciary that could do that here if appropriate.
Thank you very much.
Representative Blumenthal.
Thank you, Mr. Chair, and it's nice to meet you in person, Attorney Glover. And thank you for answering our questions so far. I have a few questions for you. Some of them have already been addressed by some of my colleagues. You said in your opening statement and in answer to some of my colleagues' questions that you believe Dobbs was wrongly decided and that there is a right to reproductive autonomy in the federal constitution. That's correct?
Yes.
Okay. And I believe I heard it in your opening statement, but I would love some clarity. Do you believe that the Connecticut Constitution is at least as protective of that right as the federal Constitution?
Yes.
Are you aware of Connecticut's 1990 statute essentially codifying the Roe versus Wade decision into state law?
Yes.
Are you aware, as you sit here today, of any reason to doubt that law's constitutionality?
No.
Are you aware also of several protections that Connecticut passed into law in the past year to protect reproductive freedom here in the state of Connecticut?
I'm generally aware. I'm not going to say I'm familiar with every single one, but I'm generally aware. Yes.
Okay. As you sit here today, are you aware of any reason to doubt that law's constitutionality?
As I sit here today, and I have to be careful, as you know, as a judicial candidate, but I I think I can state the two principles that we started with, which are, I think the federal Constitution contains a right to bodily autonomy, because I think Dobbs was wrong and wrongly decided. The Connecticut Supreme Court has always interpreted the Connecticut Constitution to be at least as protective, if not more protective in some areas than the federal Constitution. And so those are the principles that I would take forward. And so sitting here today, I can't think of any reason why this would be the one area where all of a sudden the Connecticut Constitution would be even less protective, and I don't even know how that would work. But I don't see any reason to doubt that today.
Okay, appreciate that answer. And more specifically, I'll address this question at a relatively high level of generality, because I do want to be sensitive to your rightful hesitation to avoid the appearance that you're prejudging any case. The law we passed last year, writ large, took a number of measures to protect people here in the state of Connecticut against out-of-state attack based on reproductive health care that they either provided, obtained, or assisted others in obtaining or providing here in the state of Connecticut. Are you aware of any reason, as you see here today, to doubt Connecticut's ability as a sovereign to protect its residents or people who have come here or participate in activities here that are protected here under our law from out-of-state legal attack?
That's a pretty broad challenge. And even, I know that you were trying to do it at a high level of generality. I can't sitting here today, but I obviously don't have a facts of a case or the arguments before me. And I wouldn't want to suggest that I have prejudged anything, but I can't sort of at that broad level of generality imagine a problem with interpreting the Connecticut Constitution to provide broader rights.
You, in your role as, well, actually, I'll stick with this for the moment. You addressed the letter that you wrote in support of now Justice Amy Coney Barrett in a number of answers to questions asked by my colleagues. Why in 2017 did you choose to sign it?
The letter in 2017 was a request on behalf of a colleague, someone that I had worked with over, in 1 year, many, many years ago. And it reflected my experience with her and reflected, quite frankly, I know it's only been 6 years, but a different era where there was a recognition, certainly in the legal community, that we work with people who we disagree with. The governor has nominated me for a position on a multi-member court. And if I were to be confirmed, I would expect that I will disagree with people. And I hope to be able to work with people that I disagree with. But in 2017, I was in a culture and in a belief that the law and the rule of law still meant something in this country. And that there were guardrails on a lower court judge that would prevent wholesale changes to protections that we all took for granted. And so I take it that you thought that in the first place, as a lower court judge, she would be bound by existing precedent? Of course. And are you saying also that you thought that she would bind herself, whatever the circumstances, by principles of stare decisis and other precedential principles? That was my, that was my experience of her, and that was what I expected. I'm going to ask you a couple questions about your role working for the federal government and how you view it in comparison to the potential role as being a state Supreme Court justice. What did you view your role as an assistant U.S. attorney for the state of Connecticut, or excuse me, for the District of Connecticut? I've always seen my role as seeking to do justice. And I stated that in my opening, and I believe that to the core of my being. We I have often told people we're not going to take some action, even though it means that somebody who probably committed a crime isn't going to be prosecuted because we don't have the evidence because the search was unlawful. But that's part of my job, is to do justice in every case, balancing the interests of the United States, the defendant and the defendant's rights, the public's interest in safety, which is something we take very seriously, as well as the victims' rights. A lot of our cases, not all of them, but a lot of our cases involve victims who've been harmed by the breach of the social compact that is a criminal law violation. And I take that seriously. And so our job, and my job, as I have always understood it, is to seek justice and to tell people within my office what I think and how we get to that point.
Okay, and how do you, in what ways do you view it as similar and perhaps different than the role of a judge, particularly a state Supreme Court judge?
You know, as I understand the role of a Supreme Court judge, I would say it's, and on some levels, it's very similar, because your job is, with obvious distinctions, but I think that the obligation to weigh all kinds of interests, not just the interest of one party, but the interests of the public, the interest of the victims, the interest of the defendants, and keeping those and applying the laws that structure those considerations. So I consider it, in some ways very analogous, but just from the other side of the bench.
How do you view the role of the jury in our system of justice here in the United States?
The jury is, it's the conscience of the community, whether in civil or criminal cases. It allows, the finder of fact in cases where we have juries, and allow the community to voice its, bring its common sense, bring its experience to the criminal justice system. And so, we have a system that the legislature or the General Assembly in Connecticut sets the statutes and identifies what we consider a breach. The executive decides whether to bring a case, but we still involve the community, and it's valuable and crucial to have that role in our system.
And how do you view the role of the jury compared to the role of the judge?
Well, in a judge is supposed to just be the person who is deciding legal questions and framing the case, but the jury is deciding factual questions. Within the legal framework, did the government prove that all of these elements were met? Did the government prove that the defendant actually had this intent? And they're supposed to bring their wisdom and their experience to that question within the framework that's set by the judge, the legal framework that's set by the judge.
And, obviously there's a right to jury trial on both the civil and criminal side in both the federal and the state constitutions. I'm sure you're aware
Correct.
of that.
Yes.
How important do you view that right to be, and how do you think it protects individuals in society?
I do think it's crucial, and, it's obviously something that we protect and we ensure on the federal system and certainly in the state as well. And by bringing in an outside group of people, of your peers, hopefully that reflects a cross-section of your community, you are bringing in, for lack of a better word, a check on the system, that if you come to a point where the executive has maybe overreached, maybe not, you have the wisdom of the community brought to bear on that system. In the civil case, you're going to have, a decision about whether this is negligence and bringing, those kinds of questions. But I think here, in a criminal case in particular, it brings the wisdom of the community and provides an outside perspective on the decisions that are being made by the executive branch within the framework set by the legislative branch.
And how do you view what steps or what level of error do you think, well, I'll reframe it. What do you think it should take for a judge to overrule a factual decision made by a jury?
There's very little room for a judge to overturn a factual decision made by a jury. There are, there are some standards for if a judge were to determine, for example, that there was just absolutely no evidence for a particular element, and there was absolutely nothing that a jury could have based a verdict on, for example, a judge could overturn that. But that's a pretty narrow limit, because for the most part, once a jury decides a fact, that fact is conclusive, and we don't look behind it, even if you think, wow, I'm not sure I would have reached that. The jury gets to make those decisions, and we don't, as judges, the judges at different levels don't look behind those absent a finding that there has been for example, a complete absence of evidence.
And do you view that prerogative of the jury as tied to the right to jury under our state and federal constitutions?
Yes.
I'm not sure. Representative Dillon kind of had a back and forth with you about now Justice Barrett's nomination. Were you, I'm not sure if you answered this question already, but you may have. Were you aware at that time of the previous history of nominations for that seat in the way that Representative Dillon was describing?
I don't recall being aware.
And obviously, no judge wants to be overruled ever. If you were to be confirmed, you would be overruled really only possibly by the United States Supreme Court. Is that right?
That's correct.
You would essentially be the final word, absent amendments made by us or the people to the Constitution or state law on Connecticut law, fair to say. If you were confirmed and in a position to be a state Supreme Court justice, would you have any hesitation to make a decision that you thought was right because of the prospect of potentially being overruled by the United States Supreme Court?
No. That's one of the things I learned from Judge Posner. He was willing to do what he thought was right, even if he thought that the U.S. Supreme Court might disagree.
Well, thank you very much for your answers to my questions and to my colleagues' questions today. Appreciate it. Thank you, Mr. Chair.
Senator Kissel.
Thank you very much, Chairman Stafford.
Actually, before you start, Senator Kissel, are you doing okay?
It might be a good time to take a break just to get a little food.
All right. Let's.
That's okay. I mean, if you would like to go on, I'm.
Nope,
Not at all.
that's
That's
totally fine. How long do you,
It's up to
20 minutes, half an hour? How long?
Sure.
Does that work? All right. So it's 12:35. Let's take a recess until 1 o'clock.
Perfect. Thank you.
here. I know when I'm not lying. You think we're meeting now? Yeah, the only reason I keep bugging you about Henry is he keeps bugging. Oh, yes. The fact that it is.
I've got you on the list. It's, so the order is John, Jillian, Johnson, Porter. All right.
I'm not gonna be long. Well, that's my goal.
All right, I'd like to call meeting back to order. Senator Kissel, I believe you have the floor.
Thank you very much, Chairman Staffstrom. Attorney Glover, congratulations on your nomination to our state's highest court. Have you had a chance to go across the street and walk through the building and size it up?
No, sir, that I feel like that would be quite presumptuous.
Well, I don't think it would be presumptuous. I think it's good to at least see the setting where you will, assuming that all goes well for your nomination, the setting where you'll be spending the largest amount of your working time. I've had an opportunity to go over there. Actually argued one case over there, lost, but Judge T. Clark Hull wrote a very nice decision. He was actually the lead when there was questioning also, and was very fair and gentle and even-handed. But I've also had opportunities to go over there. In fact, I would share with my fellow committee leadership that there was a period of time where the chairs and ranking members were over there once a year to have informal discussions about relationship with the Judiciary Committee and the judicial branch. Predominantly when the Chief Justice was Chase Rogers. I actually had opportunities to meet with her in her office over there as well. So I guess my first question is, would you be open to reinstating that collegial atmosphere where we would be invited over just to discuss the relationship between the legislature and the judicial branch, especially as this committee has cognizance over the judicial branch?
I certainly see no objection at this point, but I obviously would, assuming I got to that point, would want to consult with my colleagues and the Chief Justice. But I think more collaboration and collegiality is always a good thing.
Good. Now, your answer though, and I'm a little concerned because if you try to make everybody happy, you might sometimes make nobody happy. And so just be yourself and stand up for what you believe. But you keep talking about working with the other members of the Supreme Court. And yes, it's more than just one individual. But when Justice McDonald first became a member of the highest court, I had opportunity to go and visit with him. I was familiar with the territory as far as the rooms. We revisited one of the rooms where the justices all get together and discuss their opinions on a matter after the hearing. And he said sometimes it's a knockdown, drag out fight. So to the outside world, it looks like it's all collegial and congenial. And although that too has not always been the case. I remember there was a period of time where there was some sniping, but luckily that those years have gone by. But in your answers, you say, well, I'll look to the other members on the court, but there's going to come a time very early on where you're going to have to really dig in your heels and believe in what you believe the law should be and what justice dictates and what the facts are to you. And the notion that it's just going to be this monolithic group that just reaches this very friendly decision all the time, that's not the case. I can tell you that absolutely God's honest truth from speaking to not just Justice McDonald, but to others over the years. I've been lucky enough, you may not know, that to be in the legislature for 31 years. I've been lucky enough to be on this committee for 29. And so I've seen pretty much every single judge or justice that's out there come through here at least once, if not more. And so what can you tell us to assure us that you've got that backbone and that you will stand strong for what you believe is the just determination, even if you might be one and alone?
So, your question was about collegiality and collaboration across branches, which is to me a different question than standing firm on principles.
It wasn't a lead-in. They were unrelated. I apologize.
Okay, but you repeated it, so I just wanted to make sure I was clarifying. I have always considered it my duty in the U.S. Attorney's Office and in really any position that I've held to tell people what I think and to give my advice, even if I don't think it's what the decision maker wants to hear or is even kind of leaning that way. The decision maker is leaning one way, and my job is to tell them what I think is right and what I think, what my position is, even if it's not something that they want to hear. And I think that's my reputation in my office, certainly. I think the suggestion is one colleague who said to me, well, Sandy, we always know where you stand. I tell people what I think. I try to be respectful, and I try to make sure I'm hearing what other people are saying as well, because usually it is a decision-making process, and you're trying to persuade others. You can't just come out and be a jerk and say, this is the way it is, and I'm not going to, brook any other positions, but it's a matter of understanding what the legal issues are, understanding what the positions are, coming to a position, hearing the opposing views, trying to persuade others, and if not, then standing firm and saying, no, this is what I'm going to do. And I think the story that I told, I think it was Representative Osborne, but I don't remember exactly, of, where everybody in my office was of the view that we had to appeal this adverse decision. And I said, no. And I said, I'm not going to do that. And I'm not going to put my name on that. And we're not going, it's not going to go forward under my name, because my name means something to me. Now, that case ended up getting resolved in a different way. So nobody ended up putting a name on a brief, but I think that my ability to stand firm and say my name means something and I'm going to either take this position or not take this position is something that I value. And I think my office values, that they know they're getting my independent advice and that I'm going to tell people what I think. So I'm trying to think if there's another example that I could give that would be sort of something in public, but I have served on nationwide committees and have been reappointed to those committees because my voice is valued as independent, and I speak with integrity and I follow through on what I believe. After the Supreme Court's decision that I mentioned earlier that invalidated part of the Armed Career Criminal Act, there was a lot of internal debate within the Department of Justice about how to handle that decision, because it had ramifications not just for the Armed Career Criminal Act, but it had ramifications for other statutes, other sentencing guidelines that used similar language. And we were trying to decide as the Department of Justice how to implement that in other cases around the country. And I was the person who represented the views of the U.S. attorney community. There were divergent views within the department with people who were very smart and held, positions where they could actually make the decision. And I was the person who was selected to present the views on behalf of the U.S. attorney community about where we came down on some of these complex issues. And I think that reflected an assessment that I had a lot of legal background and I had the experience and grasp of the issues, but also that I was a forceful voice when I needed to be.
Well, that's really reassuring. And I guess people might look at the term shrinking violet as maybe not gender neutral, but I do, because I could be a shrinking violet depending on the circumstance just as well as anybody else. But it sounds to me that you would have that backbone. And even though that you might not have the breadth of Connecticut specific experience, that you'd hit the ground running and not be afraid to assert your position. And again, that's extremely reassuring.
Shrinking violet is not something that has ever been applied to me.
Well, that's good. But we've never met before, so
Right.
it's my opportunity to try to explore.
Right.
I also think that your education background is just sterling. University of Virginia, Thomas Jefferson School, Bill Anaskovich, one of my dear friends, went there and did an excellent job. Duke, by the way, what'd you get your master's in it? And Duke?
It was in political science, foreign affairs, effectively.
Okay.
I thought I was going to be a professor and discovered that I really didn't want to be a professor.
Well, you're young. You never
I
know
was
what the
young
future holds.
and
can always like wind up your,
And I-
you know,
well.
at some beautiful ivory tower school. And of course, the University of Chicago, where our current Attorney General, William Tong, went and had an opportunity to meet with, talking about Comey's, the FBI, former FBI director, I think went there or we met with him and had some information regarding that. So that's just another really impressive school. So but Supreme Court, all those folks are really smart. So as far as intellectual acumen, just a group of really, really intelligent people. But sometimes what we do can be interpreted different ways. And sometimes even following the most precise stare decisis, people can look at something. Being an attorney, from the first day in law school, the professors used to like use the Socratic dialogue and get us to take both sides of an issue. One of the things I think, and I hope I don't know if I misheard, but in response to one of the questions posited by Representative Blumenthal, and I know it was in respect to reproductive rights, but I think that you said I would have no problem looking at the Connecticut Constitution and reading into it broader rights. Did I get that wrong, or what exactly were you trying to state when you said that?
It's my understanding based on that the Connecticut Constitution has been read in a variety of different contexts to provide broader protections than are in the federal Constitution. And the way it is usually described is that the federal Constitution is a floor with respect to protecting those rights, and the Connecticut Constitution can protect more rights than are protected in the federal Constitution.
See, I guess I look at it as it depends on the plain language of the document, not that just one is a different document. So I would look at it if whatever provision was being looked at in its exact mirror between the US and Connecticut, I would hope that the interpretation would be exactly or as close to similar as possible. If our language is different, depending on the provision, it may have wider rights that could be rightfully read from that, or our Constitution might be broader regarding another area that might not be as politically correct at that moment. Let me take a step back because I'm sort of teasing around the edges, but I really want to get to your judicial philosophy. For example, when we had former Justice Palmer before us a few years back when he was up for renomination, he said, let's look at the provision regarding cruel and unusual punishment. He said back when the framers, the founding fathers, drafted those provisions, whether it's federal or state, we had the stocks, we had capital punishment, we had things that we would look back and call forms of torture. And so the criminal justice system 250 years ago was completely different than it is now. And we really don't have any problem with, we've had both Chairman Winfield and I would duke it out regarding capital punishment issues. And that's only been recently resolved. Recently in my world is like last decade or more. But over that historical period of time, there's been, if you looked at it, huge changes. When you look at a document, do you feel that it's important to bring our perspective today to it? Or, and again, these are generalized terms, strict scrutiny. Would you say that we really shouldn't try to be expansionist with that language, despite the changes that may have occurred in society? What is your judicial philosophy when it comes to interpreting black letter law or the black letters on the paper?
So there's a lot in that. So let me try and break it out. My philosophy is, I think, can be described by two different pillars: integrity to the rule of law and humility. And when that comes to interpreting texts, that's one thing. When it comes to interpreting a constitutional provision, it's slightly different because they're enacted by different bodies. So let me talk about text first, just to give you a feel for what I think about when you're talking about your words. And I talked a little bit about Justice Kagan earlier. And it's funny that you brought up the Socratic method because she was one of my law professors. And so I have this memory of her asking me questions in Civ Pro and being terrified that I didn't know the answer. And so when I hear her asking questions at the Supreme Court, I always kind of freeze up a little bit and I have to stop and think, oh, wait, I don't have to answer that question. Somebody else gets to answer it. But what I love about her approach to judging is the humility. And let me talk about a case where she was in dissent a few years ago called Yates. I think it was Yates versus United States or United States versus Yates. And it was an obstruction of justice statute where the statute said it was unlawful to destroy, modify, alter, or amend a bunch of things or a tangible object. And the question in that case, the guy in that case had was on a boat and he had run into a fisheries inspector who said, okay, I think your fish, I think they were too big or maybe too small. And I forget which way was bad. But anyway, they didn't meet the appropriate standards. And he said, hold on to those fish and I'll meet you on shore. The guy dumped him overboard. And he's prosecuted for obstruction of justice by destroying a tangible object. And the question before the court was, is a fish a tangible object? And you and I had the same reaction. I can tell from your face because the same reaction that actually Justice Kagan did, which was, yes, this doesn't seem hard, right? A fish is a tangible object. The majority said no, and went through, what they described as their textual analysis. And Justice Kagan, in dissent, said, look, this is my textual analysis. And she went through how she looked at the text, how the text fit with the other obstruction of justice statutes, and how, how she applied, how she considered, the other positions that have been taken by the majority. And at the end, she said, look, I think the reason that we came to different conclusions is this. The majority is concerned because they think the penalties for this conduct were too high. The possible penalty was 20 years, I think. The guy who dumped the fish overboard didn't get 20 years. I think he got probation, but the potential penalties were high. And there's a concern about over-criminalization, over-federalization of criminal law. Too much conduct is criminalized. And she said, you know what? I may agree with those. I may think the penalties for this statute are too high. And I may think that we criminalize too much conduct. That's not my job. My job is to enforce the statute, to interpret the statute as Congress has written it. And if I think that they have gone too far, if I think they have criminalized too much conduct, if I think they have put the penalties too high, I can write a letter. I can write something about it in an opinion, but my job is to enforce the statute. And so, for me, that is the essence of judging, is trying to take yourself out of it and do your job, leaving room for the policymaking branches to legislate.
That's an extremely reassuring. You're bringing me back because I was really worried with some of your other responses. And that one makes me feel much better about your nomination because that's what you're going to have to do. And I feel better. And again, we may not like the end result and it may not appear to be just to us. And there is some latitude as far as equity is concerned, but going awry of what the law dictates, it's the policymaker's fault. And quite often in dicta or in footnotes or wherever, justices or judges will put in their decisions. This ends up in a bad result, but this is something for the policymakers to revisit. And actually, we've had discussions here on the committee where, and I would give Representative Howard a lot of credit. We actually talked about a nominee and he scoured some of the decisions she was involved in bringing appellate matters and for the public defender's office here in Connecticut. She was a nominee to be a superior court judge. And he read some of those footnotes and gathered information from that. I agree with you. You read my face completely correctly. By the way, loaves and fishes, when they get multiplied, it's called a miracle because people view them as substantive and not some sort of amorphic thing. Let me switch gears a little bit here. Oh, and by the way, along those lines, it caused me to recall talking about law school, where I think because of the net result, they determined that a tomato was a vegetable as opposed to a fruit. Whereas if you really figure it out biologically, it's a fruit. But the Dobbs decision. A lot of people like the state Supreme Court occasionally will get a matter that's reviewed on some sort of United States Supreme Court. I think my good friend and colleague, Representative Fishbein, said the Bushmaster case recently regarding gun issues, but very rarely does that happen. So I hate to say it, but it may seem a little pedestrian going to our state Supreme Court. But that being the case, with the Dobbs decision, one of the things that concerned me was the fact that it was leaked well in advance. And to this moment, apparently, our illustrious FBI or whoever else is conducting the investigation, I think this is, you know better than I, that there's probably special Supreme Court investigators. It boggles my mind that in such a small universe, they can't pin it on somebody. But what did you think about that, given the fact that you were a clerk? And I guess that I mean, I would think that on day one, they're giving you the rules of the building and the traditions. And I think that did our country a great disservice, no matter the altruistic beliefs of whoever did it. So I'm just wondering your take on that, which is not on the substance, but on what actually took place.
I think that on the leak itself, as somebody who used to work there, I found it really pretty shocking just because it was such a huge breach of decorum, and not just decorum, but of traditions. When I clerked, it was a few years after there had been another book, and I'm blanking on the name of the book, that had revealed some inner workings of the Supreme Court. Oh, I wish I could remember the name. And so we got this very severe lecture at the beginning of the term about how you shall never speak of, anything here, much less divulge. And I think the hard part about that, putting aside the substance of the decision, it has to affect decision-making mores at the court and the way the justices interact and the way they interact with the staff and the court. I know nothing about it beyond public reporting, but I think that's had to have made the job at the court more difficult, which is unfortunate because, they do have to do the business of the court. And I think it's a shame, but I think the bigger problem is the substance from my perspective, but the leak is a matter of procedure, troubling too.
Well, since that was your answer and you've gone down that road a couple of times, I just want to plumb into that just a little bit. My understanding is that fundamentally the Dobbs decision didn't say that reproductive rights are illegal or unconstitutional. They said that they're not protected by the United States Constitution. And essentially it's a matter for each individual state to determine how that plays out. Clearly through questioning from, in particular, Representative Blumenthal, but many others on this committee. Not only did Connecticut enshrine all our laws by sort of reaffirming them in one big law last year, but also added in the fact that nurse practitioners could perform abortions, which was a little different than what we had in statute prior thereto. That was a reason why I actually voted against that, because it wasn't just freezing where we were and making sure it's all in one spot, but it slightly expanded it. Although since that time, I've talked to a lot of women and they said they actually have a better relationship with the nurses than with their own physician. That's an interesting point. And again, it just leads me to believe that you can never research anything too much. But given the fact that that was the decision, why do you feel that turning that matter over to the states was such an egregiously wrong decision?
Because by removing that protection of women's right to control their bodies, you are leaving to states to decide to not protect that, which we are seeing across this country already, not in Connecticut, of course, because our legislature has taken a different road, but in other states across the country, women aren't protected. And we as a country have never removed protection of a constitutional right. And we have never, and the whole point of the protection of constitutional rights is that they are not subject to the whims of the legislators. That's why I'm concerned. it hit me really personally. You know, I look around and I think I don't have the same rights that I did last year. I live in a state where my legislature has protected my rights. But if I had to move to a different state, my rights wouldn't be protected.
So let me just follow along those lines, because this is an interesting conundrum and I haven't figured it out at all. But there are folks that say the Second Amendment, the right to bear arms, is clearly articulated in the Constitution, but it's been treated as sort of the fourth stepchild of the Constitution, and only recently has gotten attention through broad brush decisions. On the other hand, with abortion and reproductive rights, you know, the right to privacy, it's not spelled out. It's not clear at all. It's sort of read into certain language and expanded thereon. There's the words that we're looking for are not right there, but there was a decision and said, well, we're going to read into these words, these rights. And one can disagree on, you know, whether it was a step back, either as a society or jurisprudentially. But how is there a way to reconcile those two things, the Second Amendment and this privacy right that had heretofore reproductive rights emanating from it? I won't even get into the whole penumbra and I love constitutional law, but I'm
that's
just
a-
wondering this is going to help me flesh out your philosophy.
That's a pretty hard, try to reconcile those two. What I will say is this: constitutions, the federal constitution and also the state constitution, are written with broad general terms because they're written to stand the test of time, and they are written to address issues and fact patterns that we don't yet know about. And that was, you know, one of the things I learned from Justice O'Connor was make small decisions, decide the case before you, because you don't know what's coming down the road and you don't know how that's going to be. And so what we do in our common law tradition is we decide the case in front of us and we build on the cases before. And we're constrained by that. So even though they're broad terms in a constitution, we're constrained in how we interpret them by what has come before us. Or in my view, we should be constrained by what has come before us. And so, you know, taking the right to privacy out of the Constitution, that's been built on a series of decisions that reflected a right to autonomy into a personal sphere of life. That even though those words aren't in the Constitution, the principles are there and they have been fleshed out in application over time. And it's just the way, you know, thinking about the Ganias case that I think I spoke about briefly, you know, unreasonable search and seizure is in the language and those words is in the Constitution. Those words are still there. But it means something different today when we're talking, or it doesn't mean something different. We have to apply it to new fact patterns. And so we apply it to new fact patterns like how do you search, or what is a reasonable search of a computer or a hard drive, when the founders didn't have computers or hard drives. And so when I can carry as much data on my phone as Thomas Jefferson had in his entire library, right? And probably a lot more, what does it mean to say, what is an unreasonable search and seizure? So we have to take our Constitution and those broad principles that are written into those documents and think about them, think about those principles and apply them to new fact patterns. I'm not sure if that's, I know it doesn't, you know, quite pull together everything, but that's the way I approach it.
No, it makes complete sense to me, which could be a scary thing, may not be a good thing for you. And it's complicated. And, you know, some of my colleagues on this committee might find it unusual, but once upon a time when I was actually college, before I even thought about law school, I reached out to one of our Supreme Court justices because I was doing an independent study on Watergate. And I was concerned about the direction of the court and should I feel reassured? And I got a very nice personalized letter back from Justice Brennan, which doesn't really fit up with a sort of moderate to conservative Republican, but I still have it somewhere in my attic with the rest of the messy historical detritus of my life as it spins forward. But always admired Justice Brennan and thought there was a lot to be said for that. One of the things that I think is sort of fun to do once in a while is look and see if I can find my name in the databases as far as legislative history.
Oh,
And it amazes me that actually some of my floor speeches are quoted, especially regarding some oddbally things that don't make the headlines by any stretch. Do you think it's appropriate to dig into legislative history when coming up with a decision? Or should you stay clear and just try to figure it out from the statutes themselves?
well, Connecticut has a statute that addresses this topic that says that, section 1-2Z says that when interpreting a statute, you're to look at the text and the plain meaning of those words and the surrounding text. And only then, if there is resulting ambiguity or there is an unworkable or absurd result to that meaning, would you look outside the text? And so I think, for the most part, that would be my approach, even without a statute, that you're going to start with the words. And especially when you're talking about a statute, as I've said, I think the obligation of a judge is to enforce and apply the words as written. And if this body disagrees with something that the Connecticut Supreme Court has done, you can change it. Or if they've misread it, or maybe a different body down the road thinks, oh, we want to go in a different direction, that is always open to change. But that's the rule of the judiciary, is to stick close to the words. And, legislative history, I don't often find it all that helpful, even if you're going to get to that point. But I don't envision getting there very often, because usually you should start with just the text.
Well, we try to make it helpful if you ever go down that pathway. And with myself, it was back when one of the my majority colleagues was hesitant to bring out bills on the second injury fund. So somehow it devolved to me to talk about that. And those are a lot of the things that are quoted. And I was here when we did that statute. I believe the co-chair was Justice McDonald, then Senator McDonald from Stanford. And we were just blown away by the fact that decisions were coming out directly counter to what we thought was the clear language. And to this day, I don't know how may can be shall and shall can be may. I mean, to me, those are clearly two different things. And how can you look at may and say, no, that means shall? And how can you look at shall and say, no, that means may? Justice Kagan would probably roll her eyes, just like the fish issue. One other area, when we had, I think it was Justice Gorsuch had threat, or maybe there was an attempted assault on his life. I'm not exactly sure. But then Congress recently passed some legislation or some laws tightening up security for the justices. And one of the reps, Justice Ocasio-Cortez, voted no. And I think it was based on the decisions of the court. And I just shake my head at that kind of nonsense. But do you feel that the security, and by the way, this may sound abstract, but we actually had the Chief Justice here this session saying that there was concerns by some folks in the judicial branch regarding perceived or implied threats. And they're in difficult situations, whether it's a Superior Court judge or someone sitting on the Supreme Court or appellate court. And so regarding issues of security, do you have any opinions regarding that?
No, I mean, I have worked in the U.S. Attorney's Office where we are dealing with people who are accused of crimes. And, thankfully, we don't have regular issues with security, but every once in a while there are threats. So I'm, somewhat mindful of it but I'm not overly concerned. I have not spoken to anybody in the state system about specific concerns or specific issues. It's not, it's not something that I worry about. I try to be discreet in my public face anyway, because I have worked for the U.S. Attorney's Office. And occasionally you get people who are very upset about things that our office has done and seek out individuals. And we've handled those professionally and appropriately at the time. But we had one of our bankruptcy judge had threats against her in the federal system a few years ago. And, and it resulted in prosecution of the individual. He was arrested and prosecuted because if our judges are threatened, if there's a suggestion that their work is going to lead to threats to their life, you worry about the integrity of those decisions or about whether people will take those positions.
And sort of one last question, and I know people say that all the time and then they follow up, but it's my intention to make that the last question. It's sort of unusual. Well, it happens more often in recent years than in the past. But the fact that you got called up and asked, do you want to be a Supreme Court justice? And you were interviewed in March, and here you are before us in May. And this is all powers outside of you, right? But there's people that have applied to be on that list, and there's two sets of forms, one Superior Court judge, one is appellate and Supreme Court. Sort of have to fill out the right one and then go through this process. It's usually a very time-consuming process. So you've hugely been fast-tracked, you've been plucked out, and it doesn't sound like you were sitting there, you know, in January and February saying, gee, I really want to get on the Connecticut Supreme Court. That this sort of landed in your lap, and being an astute individual said, yeah, that sounds awesome. Who can blame you? I don't blame you for that, but how can I justify supporting you when so many other people have gone through this torturous process? There are superior court judges waiting decades to be considered to move up the ladder, if one looks at it that way. And you know, what's the assurance to the other folks in the judicial branch that you deserve this position and you're just an outstanding candidate and you'll be nothing but a benefit to the good people of the state of Connecticut when it happens so lightning fast? And again, I'm not saying this to be against you. You've answered my questions completely adequately and forthrightly. And I feel very much more reassured about your nomination now than I did a half hour ago. But I just want to sort of balance it in my heart and sort of have some rough justice that, yeah, okay, this is the right thing for the people of the state of Connecticut with Attorney Glover moving to the Supreme Court.
You know, I wouldn't presume to suggest that there aren't a lot of other qualified people for this position. And I won't presume to speak for the governor. But I can tell you, or this body, you know, the governor has determined that I have the qualifications for this position, and it's now this body's job to decide whether you agree. I can tell you what I think I bring to the table, and I think that's perhaps the best way that I can answer that question. I bring my independence and my commitment to the rule of law. I bring my commitment to a strong and independent judiciary, and I bring my expertise and my experience in analyzing and interpreting the law and legal questions over my career.
Thank you very much, Attorney Glover. Congratulations. And thank you, Chairman Stafford.
Representative Gilchrist.
Thank you, Mr. Chair. Good to see you, Ms. Glover. I'm going to go back to some questions that others have asked, because when Dobbs was ruled, after that, we've just seen across this country, you know, women actually die, families be torn apart, and the Dobbs decision made it clear that that was just the start. That those on the Supreme Court appear to want to overturn some other important decisions in our country. So that brings me, you know, in this position, my role is to try and pass policies that can protect individuals here in our state. And in particular, I focus on women's access to healthcare, abortion, birth control, emergency contraception. And so to bring you on to the Supreme Court, in my mind, makes you part of this team. We talk about it here in Connecticut, that Connecticut is the firewall. Because truly at this point in our country's history, each state needs to protect their people. And we actually have people coming here, you know, for protection. So I know it might feel like we've talked about this letter ad nauseum at this point, but going back to the 2017 letter that you signed for Amy Berry Coney's nomination to the 7th Circuit Court of Appeals, at the time that you signed the letter, did you know that she was a member of the Federalist Society or had been a member?
I don't know what I knew at the time. I probably would have guessed, but I can't I've learned a lot about her in the last 6 years. So it's hard to put in my mind what I knew then, but I probably would have guessed if I did.
And today you shared that you attended the Women's March in Washington, as did I, because I too was scared and angry. And as you've said, thought it would get bad, but didn't think it'd get as bad as it did. And it got really bad. What makes me concerned about you sharing that and then with the letter is that that was in January of 2017. And by May of 2017, when you signed the letter, things had already gotten pretty bad. And it was also pretty clear to many of us, and I'm a non-lawyer, that Trump was appointing judges, excuse me, to all different courts, federal courts across our country, in his path to overturn Roe. As far back as October 2016, he said that in a debate, that was his plan, was to overturn Roe. And so when you signed that letter in May of 2017, you're saying you didn't know, maybe, or you did, about the Federalist Society. Did you consider when you were signing the letter that the Trump administration, that he was pushing for judges that were part of the Federalist Society, which interprets the Constitution according to its original meaning, and who were opposed to Roe?
What I considered was what I knew about then Professor Barrett from my work with her in 1998 and 1999. And my belief at that time that we had guardrails and institutions that would limit the ability of a lower court judge to take actions when we have Roe, which is the law of the land.
Thank you. Earlier today, one of my colleagues was asking about your willingness to disagree with your colleagues. And I suppose what this brings up for me, this is my own take on you signing the letter and how it was kind of a piece of like you would all work together. And so you were going to sign this letter in support of her as a former colleague. Because for me personally, by May of 2017, I would have wanted, maybe it would have been nice if you went counter to what everyone else might have been doing, knowing where the path was going by that point in May. And so you earlier did speak to how you've been looked at as an individual who speaks their mind. Can you give an example of a time when you've disagreed with a colleague or a superior and what you did?
I talked about this earlier case where I disagreed with what everybody in my office had recommended about whether we should appeal this decision. And what I did was refuse to put my name on it. And what that meant is that it's a practical matter within the Department of Justice that I've been the appellate chief since 2010. I'm well known in the department. When our office sends an appeal recommendation to the Department of Justice, to the main justice in Washington to be approved by the Solicitor General, it goes through a process. But the people down there know me and knew that when our office submitted a recommendation that I refused to sign, that reflected a judgment about the merits or lack thereof. But I think that, that's sort of an internal case, but I think there have been other occasions where I have said, I don't think we should do this, or I don't think we, that's not the best course of action. And sometimes those decisions or those recommendations are in the course of, there's a range of 3 options. Only one of them is really viable. This is the only one that really is lawful or consistent with the facts. But sometimes it's like, well, you could do either one. I would do this one. And so I'm trying to think of an example that I can give without, sort of revealing internal deliberations about cases, because I've always considered that my duty. And I still do consider it my responsibility to tell people what I think. We had another case just very recently about an appeal where a judge had thrown out part of a a jury verdict. And everybody wanted to move forward. And I said, these are my concerns. I want to hear what you have to say about it, but this is my concern. And I listened to what they said and I said, okay, I hear what you've said, but I am still over here. And we ended up, deciding not to go forward. And the lead attorney on the trial team called me afterwards and she said, I really appreciate the way you handled that because I disagreed with you, but I feel like you heard us and you explained why you disagreed with us. And, I really appreciate that. And that's where I have always tried to be. I'm going to try and be respectful, but I'm going to tell people what I think and make sure that I have explained the basis for my disagreement because, if I was wrong, and that's where we started one of our meetings about, I said, if I'm wrong, I want you to tell me, am I missing some piece of evidence that is crucial, that might change my analysis. And, after hearing from them and hearing their arguments, I was able to say, look, this is why I'm here and this is where I would go.
Thank you. My final questions today have to do, there's been a lot of conversation on privacy as it relates to abortion. And the Connecticut Supreme Court, as was mentioned earlier, has held that our state constitutional privacy protections extend more broadly than the protections in the US Constitution. But what I'm more interested in focusing on is Connecticut's Equal Rights Amendment, which we did pass in 1974. And in Doe versus Marr in 86, Connecticut determined that the state should no longer be permitted to disadvantage women because of their sex, which includes their reproductive capabilities. And then in 2008, in Kerrigan versus Commissioner of Public Health, the Connecticut Supreme Court held that the state's ERA protected marriage equality. Do you agree or disagree that the ERA, the Connecticut Equal Rights Amendment, applies to women's reproductive capabilities, in particular access to abortion, and marriage equality?
So I know that I was not familiar with the first case you mentioned, but I am familiar with Kerrigan. And, as I understand it, that is settled law. And I think, I think that's a fine interpretation of the Constitution, and it is a settled question. And so if those are settled questions, then they are part of Connecticut constitutional law. And I have no reason, I have no reason to disagree with them, at this point.
It's, I'm triggered by settled law because
I know,
there's
and
no
I apologize
thing
it's
anymore.
It's law speak, but so,
Okay.
Folks, I know we're getting a little late in the day here, but we do have to keep a transcript of this, much like a court.
Sorry.
So we need somebody to ask a question, somebody to answer. Thanks.
I guess my response is there such a thing as settled law anymore? And when you say that, I guess I just want to know, do you agree that Connecticut's Equal Rights Amendment protects access to abortion here in the state and marriage equality? Since we just saw at the federal level that settled law is up for debate.
right. And I certainly didn't mean to trigger you with that language, because for me, it actually means something. And I don't know, and I know that may not seem, because other people have said that, right? But I see that as a constraint. And so I would take those decisions as what the Connecticut Constitution means. And when I talk about judicial humility, a large part of that is saying wise people have gone before me and have interpreted this document. And before I say it means something else, I've got to take a look at myself and say, why do I think that? And that's what I think they missed in Dobbs is, that decision had been interpreted and reinterpreted by generations of justices. And the, for lack of a better word, arrogance of saying, oh, we know better than what all of those other people did before. So for me, settled law actually means something because it is an actual constraint on what the judicial function is. And that's why I think it's so important that Connecticut is able to interpret our Constitution to provide broader protections. And like I said, I'm not familiar with that case. I am familiar with Kerrigan. And, but obviously if Connecticut has already resolved this issue, and I certainly was not aware, but if we've already resolved that issue, that is part of the landscape of our law.
Thank you. Thank you, Mr. Chair.
Thank you. Representative Johnson.
Thank you very much, Mr. Chair. Appreciate it. And thank you for being here today. Attorney Glover, good to see you and I appreciate you coming for us. We can have some of these very important questions answered. Many of my colleagues have touched on things that I also had questions about, but now I can kind of take some threads from what they have asked to push further. And I'll start with your response on the nomination questionnaire for number 3. You just said, I think in response to the good ranking member, Senator Kissel, that the job of a justice or a judge is to apply the words as written. So to me, non-lawyer, however, I in my professional life, I have encountered, legal theories. And so that sounds like originalism or textualism to me. Do you, because of your answer number 3 is unclear to me, would you describe yourself as being either or a little bit of both?
No. I try to avoid labels like that because I worry about what somebody, if I say the word textualist, what does that mean, to you? And I know Justice Kagan famously said once, we're all textualists now, and she's now walked that back and said, well, maybe not. Because the people who used to claim they were textualists sometimes really aren't. So what I can do is just tell you how I approach interpretation, which is you start with the words. Because especially when you're talking about statutes, that's how the policy is passed out of the legislature into the public, that's the only way we have of accessing the policy. Whatever compromises you make, whatever decisions you make, the public needs to be able to look at the statute to determine what the words mean. Now, I wouldn't call myself an originalist because for some people, for example, in Dobbs, that would mean looking at what did that right mean at the time that the enactment of the 14th Amendment, or maybe the founding, right? Which I think they consider that sort of an originalist way, which I don't find all that helpful, because why should we be tied to what a bunch of men thought women should be allowed to do in the 1860s? So it can be helpful to understand sometimes if, and this is an example, and I think it's the easiest one to understand, sometimes in the legislative process, you use words that have a specific meaning, like you maybe adopt a legal term of art and you put it into a statute. And so sometimes it's helpful to know what that legal term of art meant at the time the statute was passed. And I would call that kind of original meaning. And that's why you see sometimes judges or justices looking at dictionaries from the time. Is there something special about that time, especially if the statute's been around for a while, that these words meant something? But that's rarely going to be the end of the analysis, because most of the time, especially with constitutional provisions, those words are really broad, right? Due process of law, equal protection. Those words aren't capable of just immediate, it doesn't answer the question to just look at the words. You have to look at the cases, and you have to look at the precedent. You have to look at the body of law that has grown up interpreting those words and identify what are the principles that come from that body of law, and then how would I apply those principles to this new fact pattern? Does that make sense? Instead of characterizing it as textualist or.
Well, I appreciate that. The reason I'm asking is I think the question number 3 is literally trying to ask in the first sentence, are you an originalist? In the second section, do you abide by the living constitution theory? And as you said, right now, especially, there are some folks I think who are self-described originalists on the federal Supreme Court that have signaled that, particularly in terms of the 14th Amendment and those enumerated rights, that something as fundamental to American democracy and freedom as Brown v. Board is incorrectly decided according to that theory, right? So that's why I think that's why I'm asking the question to piece that out, because I think, especially since you've never been a judge, and as my other colleagues have said, we don't have any record to go off of. This, how you view that, is so important, I think, for me, among some other things that I'll get to in a little bit. But I appreciate your trying to piece that out a little further. And I will say that I know you describe yourself as being very influenced by Justice Kagan. And I came across a quote of hers, knowing that, and Kagan herself describes that it should come as no surprise by now that many of the votes a Supreme Court justice casts have little to do with technical legal ability and much to do with conceptions of value. So I think that that's something that's kind of staying with me. I want to pivot to something that I think is really important. It's been in the news a little bit, and it's in ethics, code of ethics for our Connecticut State Supreme Court, which we do have one. But what is your perspective on the current code of ethics for our Connecticut Supreme Court since you seek to join it? And then the second part of that question I'll give you now, which is, well, does it need to be strengthened in any way based on your views?
So I haven't studied that question, and I, obviously, if I were confirmed, would spend a lot of time looking at that. I don't know if there needs to be, if there are issues and if they need to be strengthened, and I apologize, I'm just not familiar with that.
No, I appreciate
And
your
I wouldn't want to hazard an opinion about whether it needs to be strengthened or not. And, to the extent that is a question for this body, I would leave it to that body. A lot of those decisions, certainly at the federal level, there's a view that the US Supreme Court gets to make their own rules. But, I don't know enough to offer an opinion here.
Have you read our Connecticut Supreme Court Code of Ethics yet?
I've skimmed through it, yes.
Thank you for that answer. I'll pivot now to this notion of rights, as I mentioned, the 14th Amendment underpinning so many of our enumerated rights, civil rights. And so you mentioned you believe that our state constitutions come up a lot today, has more expansive rights than our US Constitution. You've even suggested that's a good thing, I think. I'm inferring that. So which specific rights are you referring to in our state constitution
That are,
more expansive than from our federal constitution?
well, I can think of a few that the Connecticut Supreme Court has already identified, and I'm certainly not going to be able to identify all of them.
Right, no, that's not like. a
But just a few, that struck me. So one of the ones that I was familiar with in the beginning was that the Connecticut Supreme Court does not, or the Connecticut Constitution does not include an exception, a good faith exception to the exclusionary rule. In Fourth Amendment cases, if there is a violation, the evidence is excluded, but in the federal Constitution, there is a good faith exception to that. If the officers relied on a good faith issuance of a warrant, if the warrant was issued by a magistrate judge, then the evidence can still come in. In Connecticut, under Connecticut law, that is not true. And it's considered more protective because it keeps out more evidence and provides better protections and better incentives for everybody in the law enforcement in that process to protect defendant rights. The Santiago decision eliminated the death penalty in Connecticut. And I know that was controversial, but that is a difference from what the US Constitution has. And obviously Kerrigan, it's right now it's coextensive in the sense that there is gay marriage that is recognized, but Kerrigan was years before the US Supreme Court recognized that. And so those are some of the examples of, of rights that are at least, if not more, in those cases, more protective than the federal Constitution.
Okay, thank you. So just to pick up from what you mentioned, since you mentioned marriage equality, and obviously I think, legal scholars would, I assume, agree that it all hinges on a right to privacy basis, or can, and that has been the path that's been taken there. In your view, what LGBTQ plus rights are protected in our state constitution?
I would hesitate to try and enunciate them all, but because I don't want to suggest that I have an encyclopedic knowledge. The federal Constitution protects, some. The Connecticut Constitution protects more. Marriage equality, there was an equal right. That decision was based on the Equal Rights Amendment, in part, and I think that the right to privacy is also broader in the Connecticut Constitution. It certainly was at least at the time of pre-Dobbs, was at least as broad, and probably now is much broader. And, on that topic, I know that this body, the General Assembly, has been very active in that regard and, providing protections for the LGBTQ community. And, and I know you, one of the things that I've been trying to do is to let you know a little bit about me individually. And That's hard because we're here talking about law and those kinds of things. But, you know, the values embodied in that decision in Kerrigan and the values embodied in protections for the LGBTQ community, I'm sorry, are important and personal to me. My husband's brother is gay, and he and his partner are my children's uncles and have been for 24, I may be wrong, 25 years. So those values and the significance of those protections is really important to me. And I can't tell you exactly what those protections are in the Constitution at this moment because I haven't spent the time studying. And one of the things that I do as a lawyer is study and look and make sure I'm saying things that are accurate and fully supported. I can tell you that it's my understanding and my belief that the Connecticut Constitution protects at least as much, and perhaps a lot more in some areas.
One thing I'll offer to that is I believe there are protections based in statute. But frankly, we are not a protected class in the state constitution of Connecticut. LGBTQ people are not a protected class. So, and I think one of the reasons in the legislature we've been working so hard on safe harbor provisions on reproductive health care and gender affirming healthcare is that sometimes statute has to help people and defend their liberties in light of not being seen as a protected class. And we know at the federal level, that's been an ongoing conversation as well. So frankly, I think this is where, for me in particular, with this particular constituency of mine, there's a lot of concern because we know that we're not a protected class. And so it's up to the state Supreme Court justices to be the firewall, as Representative Gilchrist said, to, you know, look to the statutes that we as a body are adopting and know that in these ways, these rights will be defended. They will be maintained in a sense that people's lives and liberties will not be in jeopardy living in this state as they are going to be and already are in other states. So I would encourage you to certainly talk to advocates in this community and many other communities that are concerned about this, because I guess I'll lead into a question that would be great to have like a yes or no answer on, but I think that this is why the right to privacy has come up so much today, to be honest. Because as you know, but I think there's under the surface even more for you to explore with our communities as to why this is so urgent. So on that note, I know that we've talked about some resolutions, amendments to the Constitution in our state. Do you think it'd be advantageous to amend our state constitution to ensure a vibrant right to privacy? As a yes or no question.
I'm a lawyer, so I have a hard time with yes
I'm
or no
not, so-
questions. I know. To the extent that those are not already there, as a citizen of the state, I would think it would be a good thing to do if they are not already able to be protected. Does that make sense? If the right to privacy doesn't already protect them and hasn't been interpreted in that way, I think, you know, in one level, the right to privacy hasn't been addressed by the Connecticut Constitution, by the Connecticut Supreme Court, because it hasn't had to be in some ways, because Roe was there and Casey, and there were already some protections that gave a floor. And I'm not saying that those are sufficient, but I'm not sure. I don't know enough about how the Connecticut right to privacy has been interpreted to make a broad statement, but certainly, you know, those values, and to the extent that was, you know, up for constitutional amendment, I would support that personally. In terms of a legal question, is it already there? Is it necessary to protect what isn't all there? I'm not comfortable answering that because I just don't know enough about those provisions yet of Connecticut law. And I also wouldn't want to presume to be suggesting how I rule on a particular case.
I can appreciate that response about.
And I know it was more than a yes or no. Sorry.
It was. I'll pivot just to the last few questions that are kind of related. I think an important one, given especially about the timeline that Senator Kissel mentioned, why do you want this job?
I have dedicated my career to public service and to the rule of law and to promoting the rule of law. I love the law. I love the research and the writing part. And I believe very firmly in the significance and the importance of having a strong and independent state judiciary. And I think that I would have something to offer. I think I could bring my commitments and my independence and my commitment to being a strong and independent voice to continue my public service for the people of Connecticut.
And then bringing it back to something you mentioned in your opening statement, two questions I promise are related, so I won't belabor, but so you talked about justice being central for you. So specifically with regard to civil rights that are enumerated by the 14th Amendment, what is doing justice to you with regard to those rights? What is doing justice?
So for me, justice has sort of a procedural and a substantive component. Because I'm a lawyer, that's the way I think. But I think procedural is about treating people fairly and making sure that people are being held to the same standards and have access to the same processes and procedures. But substantively, it also means taking into account the actual result of the outcome and making sure that different communities have access to the same opportunities and the same benefits without discrimination and without, and I'm speaking broadly because your question is rather broad, but making sure that the end result reflects everybody's interests, and that it is also, when you're talking about civil rights, it's also about ensuring a floor underneath that, because I was talking with, I think it was Senator Kissel, but I could be wrong. And I've just lost my train of thought by looking at him. I apologize, but we don't send civil rights to states. We don't just let the majority make decisions about some civil rights, right? That was kind of the impetus behind protection of some of these rights. Just because Connecticut wanted to prohibit sale of contraception, the Supreme Court eventually said, no, those aren't up for legislation. We have a baseline of what is considered to be available to the citizens, everybody. And that to me is a core component of justice.
And so my last question would be, how do you square defining justice in that way when it has often been denied or delayed for some groups of Americans, even since our founding? Like, how do you square that, knowing that in this role in particular, you might have to make decisions that may frankly come into a little bit of conflict with some of your notions of justice being like good for the whole, when oftentimes minority communities have had this denied, delayed, and it may not be popular. Maybe it's popular here, but it may not be popular federally. How would you square that?
So, the history of our country has been expanding the members of our political community and recognizing that we have not been, that women were not part of the political community, that African Americans were not part of the political community, and that we have expanded that, and that we have learned from that experience, and that we can look back and say, what we were doing originally isn't where we are today, and we have learned as a society. And so I think about it in terms of being in order to form a more perfect union. We're trying to do better all the time. And even if we haven't been perfect, we're still moving forward and trying to do better and perhaps expanding the political community.
And I think that I appreciate your answer, because for me, that gets at the idea of how can we, knowing we have limited information to go off of with respect your sense of values, but also your sense of what you think, who should be part of the beloved community, who should be part of access to these rights. And especially since you're a prosecutor, it seems as though you haven't had a lot of work in civil rights, right? So will you take the same care and the same knowledge with you over to this area that you as you even said, you want to learn more about? And unfortunately, in our country's history right now, this is going to be perhaps some of the major cases that will be coming before you, which is why I think it's of such urgency. that we get to know as much as possible from you about what you think about these issues of our time. Because I think it would be naive to say that, you know, at some point our court may not be called upon to defend these rights as a firewall, as we've heard today. So thank you very much for your answers. Appreciate that. Thank you, Chair.
Senator Mark.
Thank you, Mr. Chairman. Nice to see you again. We had a chance to talk last week, and unfortunately I had to run out to vote, so I didn't get to hear your answer. When I came back, you'd all moved on. I do want to go back to the letter that everyone keeps referencing, because I also was at the march in Washington, although it's just kind of silly to call it a march because none of us could move. It was so many
That
people
was my
there.
recollection too.
Right. You have said today that you've never been pressured into taking a position you disagreed with. You also said that the letter was a request by a colleague that I worked with. And you said my name means something. It was a known fact that Amy Coney Barrett had come out strongly against reproductive rights. She had written a letter in 2012. You worked with her in 1997, you said?
1999.
1999. In 1999, you wrote this letter after President Trump was in office, after we saw the way things were going, the fear that we had leading up to that. That letter that she had written about reproductive rights was done in 2012. You wrote this letter in May of 2017. I cannot get past being appalled that you, as someone who speaks to the importance to you of reproductive freedom and your values, that you would have added your name to a letter supporting someone who had made herself known in her belief systems about reproductive rights. So when we spoke the other day, I asked you, I said, you know, we've all done things in our lives that were a mistake in retrospect. And you said earlier to my colleague, Representative Johnson, that you wanted us to know more about who you were. So given that, I'm going to ask you again, and I'm leaving the door wide open. Is this something that you would do again? To write a letter supporting someone who took away the rights of every woman in this country?
No,
I'm sorry, could you say that for the mic?
I'm sorry. Turning. No. As I've said before, I've learned a lot in the last 6 years about our country and about now Justice Barrett. And, you know, knowing what I know now, I shouldn't have signed it. I thought the guardrails were stronger. I thought the institutions would hold. I was pretty naive.
Thank you for that. I'm hoping that you bring that level. I mean, clearly you're a very smart person. Clearly you've worked hard to be where you are right now. And I can't begin to talk to the process of exec noms or how that whole thing works, so I'm not going to go there. But I hope that should you be sworn in as a Supreme Court justice, that you will look deeply at decisions that you make and think about everything that we have all asked you today and bear that in mind, because we are representing people in Connecticut who will question why we have nominated someone or signed off on someone who wrote a letter supporting. So I'm asking you to make a promise that you will look deeply into the decisions that you make going forward.
I will, thank you.
Thank you. Thanks, Alex. Thank you.
Representative
Chair.
Porter.
Thank you, Mr. Chair, and good afternoon, everyone, and good afternoon to you, and congratulations on your nomination.
Thank you.
I want to start with talking about the power and the discretion of prosecutors, right? It said that prosecutors have the most power in the courtroom, even more power than the judge. So I wanted to ask you, is that something that you believe is true, or would you agree with that?
That, and I just want to make sure I heard you correctly, that do I agree that prosecutors have more power in the courtroom than the judge?
Yes, I mean, it's always been said to me and other folks that, prosecutors have all the power, even more power than the judge. So I'm asking, is that something that you agree with as a prosecutor?
No, there are certainly areas where the different branches have different roles, and certainly in a charging decision where the decision is what kind of charges to bring, those decisions are committed by law and under Supreme Court precedent to the executive branch, that is the way that the decisions are separated out. But after that decision is made, the executive branch operates within the judicial branch and is subject to the rules and power of the court to control how those charges are processed.
Thank you for that response. And just to piggyback off of that, I want to know, with your lengthy experience as a prosecutor here in the state of Connecticut, how will your experience as a prosecutor impact or influence your deliberations as a Supreme Court justice if you are sworn in?
So, when I think about that question, I think about Justice Sotomayor, who is currently the only former prosecutor on the U.S. Supreme Court. And I appeared before her a number of times when she was on the Second Circuit. And what she did was hold us to a high standard. I never thought she was unfair to us, but she put us through our paces and required us to be at the top of our game. And I don't think anybody would think that she was ever pro-government or pro-prosecutor. She expected a lot from the people who, and appropriately expected a lot from us because we were exercising the prosecutorial power of the state. So what I would take is a recognition to the bench. I would take the recognition that it is an awesome power. And I would expect the people exercising that power to exercise that power responsibly and appropriately. I would put them through their paces and hold them to account. But I also feel like my experience as a prosecutor at the U.S. Attorney's Office has been one of seeking to ensure that we are balancing all of the interests in the criminal justice system, both the interest of the defendant in obtaining a fair trial or a fair proceeding if he doesn't go to trial, the interest of the victims in obtaining redress for the harm, and the interest of the community in obtaining safety.
Thank you. The other question that came up for me as I was listening to my colleagues and you go back and forth, you responded earlier to a question that police and prosecutors work within the framework of the law. It immediately triggered the thought in my mind that it's a legal framework that has and continues to disproportionately prosecute Black and brown people. So with that being said, my question to you now is, what is your understanding of structural and systemic racism and how it impacts liberty and justice for all?
That is something that the federal system has struggled with a lot over the years. And the most obvious place where that has shown has been in the penalties for different types of drug crimes. So the Drug Control Act, I think it was 1986, and I'm going to get the history wrong because it's changed so much over time, but the penalties for certain types of drugs, specifically crack cocaine, were significantly higher than the penalties for powder cocaine, even though there was and there is they're pharmacologically identical substances. And the impact of that was a racially disproportionate impact, quite frankly, and that became clear. I don't know how quickly that became clear, but once it did, the Sentencing Commission over the years has reduced the penalties for crack cocaine. Congress eventually stepped in and changed the penalties for crack cocaine offenses to reduce them. It is something that, our office has been, very attuned to and very aware that these are significant issues, and following the law and making, what's the word I'm looking for? Reasonable and responsible charging decisions, such that, making charging decisions that reflect the real impact of the conduct as opposed to what the extra penalties might be for crack cocaine offenses over the years. But I think it's something that any criminal justice system has to be attuned to, that there can be, unintentional impacts that are having, a racially disproportionate impact, and that the criminal justice system should respond to those and change those when they're identified.
Okay, and I just want you to be a little more specific for me, because it is what's been stated to you throughout the hours you've been sitting before us, is that we really don't have anything to go on when it comes to decisions, because you've never sat on the bench before. So I'm just trying to get from you, personally, as an individual who might be very well sitting on our Supreme Court soon, what is it that you will do? And what you're understanding, okay, the drug part, yes. But I mean, if we're going to be honest about systemic and structural racism, that goes straight across the board: housing, employment, you name it. There is not one intersection in my life as a Black woman that I haven't faced some level of implicit or explicit, I would say implicit bias or explicit racism. So if someone's sitting on the bench, right, hypothetically, in the highest court of this state, knowing what you know as serving as a prosecutor, and you have to know this because these are the stats in Connecticut as well. The majority of the people that are locked up look like me. What is it that you will do as a justice on the bench in the highest court in the state to address that issue, especially coming from the field of prosecution?
Well, so a couple of responses. At the end of the Obama administration, one of the things that we tried to do and couldn't get it done, but we're trying to do, was implement implicit bias training for all prosecutors across the country. Because, whatever the structures, the research shows that all of us have implicit biases that are, effectively mental shortcuts. And we tried to get that implemented, didn't get it done. I believe it's being rolled out now. So that was something that I was involved in with the Department of Justice, with the Appellate Chiefs Working Group and the Attorney General's Advisory Committee. Working in the Connecticut system, I know that the Connecticut Judiciary has recently been focused on racial disparities and potential discrimination or discriminatory impacts of the jury selection system, and has been considering changes to state law or to procedures for rooting out racial discrimination in that system. And I would be very in favor of working on that system and working to identify sources of racism. How are we identifying places where it may be coming in? And one place might be in reasons why the response rate for jury summonses are so low, or looking at the amount of money that jurors are paid, because it can be a financial hardship to have to serve on a jury, and that may have a racial impact in some particular cases. So I think there's a lot of different ways, and I know the judiciary is already looking at some of these, and I would be very interested in working on those initiatives to ensure that our justice system isn't compounding issues that are already there.
Okay, and I take that into consideration, but I would also ask you to take into consideration that many of the trials that I'm talking about are actually plea bargain, right? Folks aren't even going before juries nowadays. The majority of the cases are resolved through plea bargaining, so I don't know how much that would help. Are there any other ways that you can think of or share with us that you said you would be interested in being a part of this? How would you what would be your suggestions or the things that you think would be effective in addressing the structural and systemic racism especially in our judicial system?
As I described earlier, I think having people with different and diverse views and diverse backgrounds and diverse races and in positions of authority and decision-making roles is an important start. And I think, I don't know if the state has implicit bias training for its prosecutors, but that would be one thought to think about. I hesitate to offer specific suggestions that, you want to talk to people about where the fault lines are in the system. But I think making sure that the judiciary represents diverse races and genders and perspectives and communities, making sure that prosecutors also reflect the diversity of our communities is certainly a good place to start.
I would absolutely agree with you on that. So thank you for that answer. And it is the perfect segue because I was going to go to what you had stated earlier. I had actually written it down. You said better decisions are made from many different perspectives. I couldn't agree with you more. So my next question would be around, is there anyone that you personally, and not just anyone, but do you personally know any women of color that would qualify for the nomination before?
Qualify for, I'm sorry, I didn't hear the last part.
That would qualify for the nomination before us, for the Supreme Court.
For this position right here?
Yes.
Yes, I know. I know several people, so I'm not sure that's my place to identify nominees, but I know several people. I mean, I guess I could, I don't want to name individuals.
No, I'm not asking you to name anyone. I'm just curious because Representative Dillon had actually asked you a question earlier about, did you know of the women of color that were actually qualified and up that could be nominated for the position that you wrote the letter for? And it just kind of triggered that for me. I'm like, that's a good question. I wonder if you personally
Yes.
know anyone that would qualify to be seated in this nomination as well as yourself. And you responded yes. So thank you for that. The other thing that I wanted to bring up, Governor Lamont actually, and I'm quoting him, said Sandra has the qualities that meet the high standards that the residents of Connecticut deserve from the highest court. So could you tell us what those high standards are?
I wouldn't presume to speak for the governor, but I can tell you what I think I bring, which is my expertise and my experience in analyzing legal questions, my commitment to the rule of law, and my deep commitment to public service.
Okay, thank you for that response. And I think it echoed something that you had said earlier. And there was nothing else you wanted to add to that. Is that correct?
No, thank you.
So I think the last thing, and I mean, this is really, it's not a question, it's just really a statement because we talked about, different perspectives. I think about diversity, equity, and inclusion. There are certainly things that I think we should be looking at that could level the playing field and bring the kind of equity that we desire when we talk about what's going on in our judicial system here in Connecticut. We see a lot of things come before this committee, and I think it's quite obvious what's going on. And I actually think it's quite obvious what the solutions are as well. And this is no slight at all on your nomination. I am proud that you sit before us first as a woman. And I think that we definitely need more women in positions of power. But I also believe that the diversity and the equity and inclusion part needs to include, not just prosecutors. And I understand that this is Governor Lamont's second nomination. This is the second prosecutor that has come before us. And my concern in us answering the call for diversity, equity, and inclusion is that we really should be looking at folks outside of prosecutors to sit on these benches. So it leaves me to question, and this is not a question to you, but actually to our governor, where are the public defenders? Where are the legal aid people? Where are the folks that are on the ground dealing with people from a totally different perspective than that of a prosecutor? And I will close with that, Mr. Chair. And I thank you again for your patience and endurance in answering all the questions that we have put before you. And I wish you all the best going forward. Ms. Glover.
Thank you.
You're welcome.
Senator Lester.
Thank you, Mr. Chair, and thank you, Attorney Glover, for your endurance today and for taking time to talk to us about some of these big issues, as well as your priorities and interests. Just following up on some questions that Senator Kissel asked, but also some comment or a question that Representative Porter just asked. I noticed from your biography that you had a couple years that you spent on the Attorney General's Advisory Committee. And that's interesting to me because I think in that particular context, as I understand it, you were a policymaker, not just a prosecutor, but you were providing advice to the Attorney General about some of the issues in the U.S. Department of Justice. And that was a time when Attorney General Lynch was addressing the Pulse nightclub shooting, the death of Eric Garner, interference in the 2016 election, and the investigation of Secretary Clinton's emails. Can you talk to us about that experience, and specifically how it might, if it might inform, your role as a policymaker with oversight over the judicial branch?
Right. So the last two issues that you mentioned actually never came before us. Those were more investigative things that were not part of the Attorney General's Advisory Committee. But you are right. That committee it's a leadership committee of U.S. attorneys. I wasn't a U.S. attorney, but I was chair of the appellate chiefs working group. And so the chair of the appellate chiefs, the chair of the criminal chiefs, and the chair of the civil chiefs sit on that committee to help them understand how these issues are going to impact. But we did hit a lot of the big issues. And I think what that committee taught me was how important it is to hear different perspectives and to hear all of the different stakeholders in a system. And I'm trying to remember some of the issues. One of the issues that we were addressing with Attorney General Lynch, it was at the beginning, there were questions about whether police were going to be using body-worn cameras or whether federal law enforcement were going to be using body-worn cameras, right? And that's a big policy decision because whatever your belief is, you think, well, this is a good idea because it's going to make police more accountable. And she was certainly in favor of that. But it also imposed a lot of costs on the law enforcement system. And so we're talking about, balancing how we address those. That was one issue, but I think what it really impressed upon me was, the complexity of a lot of these policy decisions, and how the Department of Justice response can provide leadership in some of those situations. But that also you have to hear different perspectives on those. I can't remember what the specific incident was, but there was an incident in the Western states, and I want to say it was, somebody had taken over. It wasn't the really high profile taking over of a national wildlife refuge, but it was a smaller facility. And, we all had our reactions about how the Attorney General should react to that, should she make a public statement. And it was really helpful to hear the perspectives of the people from the Western part of the country and saying this is how that's going to land out there. I know she wants to achieve this goal. Let's find a way to achieve this goal in a different way. And that was really helpful to just hear, what, we think we all have the answers, but let's hear different perspectives as we're trying to make a decision. And that's where I got this view that hearing people with different backgrounds, different perspectives really does inform your decisions.
Thank you. And did I understand from your colloquy with Representative Porter that that the recommendation that U.S. attorneys receive implicit bias training, was that something that came out of that advisory group and it was frustrated, didn't go into effect?
It was part of that advisory group. We were certainly involved with that, trying to identify the right way to do that training and trying to identify a provider who could do a good job, because at the time, there were a lot of law enforcement departments and law enforcement agencies that had implicit bias training, but some of that was more geared towards law enforcement. And we were trying to identify a good program for prosecutors. And I would have to go back and look, but I recall that the policy was adopted, but then it was revoked. And so I don't think anybody was actually trained or most people weren't trained under that policy because it was revoked with the introduction of the new administration.
So when you clerked for Justice O'Connor, she issued an opinion in Department of Commerce versus U.S. House of Representatives that prohibited statistical sampling in the 2000 census. That decision led to a significant undercount in the census of communities of color. And on the one hand, that decision was, simply a question of statutory interpretation. And I'm not going to ask you whether she got it right or wrong in that specific question. But as you serve as a judge or as a justice, I imagine you're going to be asked to sort of look at either narrow questions or sort of broader questions of what constitutes justice. And I just wanted to see there's been some discussion of this previously, but if you could just sort of talk about that balancing test about statutory interpretation versus, the bigger questions of what is in fact fair.
I'm sorry, I didn't hear the last part.
What is in fact fair? What is
Oh.
what is just, and what we were intending to do in our Constitution and our statutes.
A lot of times, especially in the criminal justice context, holding people to the same standards, making sure that everybody is held to the same standards is a good start for justice. It doesn't always get to the end result. And, I don't recall that case that you identified from that term. But, neither here nor there. The statutory interpretation cases, I'm not saying it didn't happen. I just don't recall it. That was a long time ago, and I don't recall all the cases. In fact, most of them that I worked with her on, or that were even there that term. But I think the understanding that applying the same rules to everybody is it's sometimes not going to be sufficient, but it is a good start. And that trying to introduce, there are places for the introduction of equity and introduction of fairness into our system. And part of that is recognizing those places and making sure we're exercising them. So like, for example, in our office, when we are dealing with sentencing recommendations, right, there's a list of factors that a judge has to consider. And they're the kind of factors that you would think would have to be considered, but they're actually a list. But the offense conduct, the impact on the victims, the possibility for deterrence, and thinking about all those factors allows consideration of fairness. Because one of the other factors that you also have to consider is the offender's history and characteristics. How did we get from his history to this crime? Are there things that we can do within the system or maybe adjacent to the system to help solve some of those problems? Because sometimes we can't solve all the problems through a justice system. We can do a little bit to fix the breach of the social compact, but we can't solve all the problems that led to that breach.
Okay. Thank you. And I don't have any more questions. I'll just very briefly just express, frustration along the lines of what I heard Senator Marr say a few minutes ago, which is, look, I've talked to some folks, your colleagues at the U.S. Attorney's Office, I think the world of you, but I share frustration on, with regard to that letter that you wrote on behalf of now Justice Barrett. And I just think it indicates a selective clubbiness in the legal profession. It's not about you, it's about sort of a general issue out there at a time when I think a lot of folks in the profession are not adhering to traditional respect for the rule of law, to respect for precedent, et cetera. And yet, we still have this perhaps unseemly chumminess that I think has led to, a real erosion of civil liberties and, basic legal protections for a lot of folks in this country. So, we'll keep that discussion going, but it is a frustration that I have, and I know it's a frustration that others on the committee have as well, and appreciate your words, expressing regret for that decision. And I think that, that means a lot to me, and I appreciate hearing that. Thank you, Mr. Chair. That's all I have.
Representative Godfrey.
Thank you, Mr. Chairman. I appreciate it. Just in full disclosure, I did have a chance to meet with the nominee last week. It was quite a mind-opening experience because there were about 15 of us in the room together, many of my colleagues, and I was the only man, and it was just unusual. But I certainly learned a lot from that experience. It is rare that someone is nominated to the Supreme Court not having had any courtroom experience as a judge. I can only think of a couple of instances when Governor Grasso first appointed Ellen Ash Peters to the Supreme Court here in Connecticut, and a few years later nominated her to be Chief Justice. And of course, we didn't have courtroom experience for her when we were looking at that nomination, but we had a lot of writing and public speaking. She was an academic. She was on the faculty at Yale. So we kind of knew her background there, and we certainly appreciated that she had been born in Germany just before the rise of Hitler, and her family were one of the few Jewish families who lucked out and was able to emigrate to the United States and save the family's lives. And then the second one, of course, was Justice McDonald. He had no judicial experience as a judge, but we certainly knew him. As a member of the General Assembly, we knew his positions, we knew what he thought, we knew what he championed, and we knew his work as a chief counsel to Governor Malloy. But here you are without those alternative kinds of background that allow us to delve into your judicial temperament and thinking, like we were able to do with those, or with the justices that served on the Superior Court or the Appellate Court. And you come to us, as Representative Porter discussed, as a prosecutor. I think I said to you when we met, the problem with people who are hammers, they see the world and everything in it as nails, and it kind of skews their worldview. And we already have, I think, enough prosecutors on the Supreme Court and on the bench in general. I'm hoping that you can kind of repeat your discussion with me on how being a prosecutor, having been a prosecutor, is not a hindrance but a help.
Sure, and you touched on a lot of topics, so I'll start with the last part of your question, which was about my experience as a prosecutor. I first would point out that my experience has been both civil and criminal, and my experience has been mostly as appellate chief, which is providing sort of a different perspective on criminal prosecutions, providing a different perspective, sometimes saying no to people, we are not going to appeal this decision, or sometimes even saying, the trial court ruled against us and the other party has appealed, but we're not going to defend that decision on appeal. We're going to do what's called confess error and send it back to the trial court. And so, I think my perspective, having had that experience, is somewhat unique. But also, I think the way that we have practiced law with a focus on the interest of the United States, the defendant, the community, and also the victims is something that I have really taken to heart. And I think it'd be helpful to tell a story about a case that I handled a few years ago that, I don't see myself as a hammer. I see myself as someone committed to doing justice. And we had a case where a case was on appeal. A defendant had been sentenced for simplicity, I'll call it parole violations. And his attorney filed a motion for bail pending appeal and said, we think that the record is that there isn't a strong enough record to support these findings. And when I took a look at it, I agreed with her. And I went through the process of going to Washington, because when I'm going to confess error on appeal, I have to get approval from Washington. But I went through the process of getting that approval and filing a motion saying, we agree, the record is insufficient to support the findings that he violated probation. And so it needs to go back for another proceeding. And he should be let out of prison. Now, the court didn't enter an order on that motion until a Friday afternoon, close to 5 o'clock, if not, after 5 o'clock. I don't recall the exact timing. But what I do know is their normal processes for reporting that decision to the Bureau of Prisons were too late for the Bureau of Prisons to act. And so they called me and said, can you get him out of prison tonight? For those of you with any familiarity with prisons, you can't just call a prison and say, hey, I think this guy ought to get out, like for good reason. It's actually very hard to find a phone number. So it took me all night of working with the defense attorney, working with Bureau of Prisons personnel across the country to make sure that we could get Mr. Priest out of prison that evening. And after a lot of work, we were able to do it. I also had to coordinate with his attorney because, of course, by releasing him on a Friday night, there was no release plan. There was no way to arrange for his transportation. So we had to coordinate getting somebody to drive from Bridgeport to pick him up in New York, where he was going to be released. But it was important to me that we had come to the conclusion that he should be released from prison. The court had entered that order, and it was important to me that we get that done, because that's what I understood my job to be. My job wasn't just to sit on that. My job was to make sure that he was released from prison. And I did that. And I'm really proud of the work that we did in that case.
Thank you. Pretty much like the same answer you gave me last week. I'm glad we have had the opportunity to share that with everyone here in public. I want to turn to the state of Connecticut's constitution. I do agree that states can provide, that the federal constitution is the floor. States can provide more rights explicitly or implicitly than the U.S. Constitution. And interestingly, and I'm a lawyer, some of the rights famously, the Connecticut Constitution famously begins with the Declaration of Rights and lists a bunch of rights explicitly, some in a broader context, some more specific. I note the exercise and enjoyment of religious profession and worship is an absolute. The Constitution says it shall not be so construed as to excuse acts of licentiousness or to justify practices inconsistent with the peace and safety of the state. Similarly, the liberty of speech in the press is constrained in the Constitution with the words, every citizen may speak, being responsible for the abuse of that liberty. I find that comforting somehow, because we're trying to do the balance. I don't think free speech protects lies, for example, but there are other pieces of the Declaration of Rights that don't have the exceptions built into them. And I want to go back to a case that the Connecticut Supreme Court dealt with. I think it was in about 1944. Now, our state constitution specifically provides the, I think it's section 11. I'm looking at it. And I'm wrong about the number. Every citizen has the right to bear arms in defense of himself and the state. Back in 1993 or 4, the legislature said civilians can't own or possess or buy or use military style assault weapons. And this isn't a question about gun rights. This is the question. There was a court case because the state was taken to the Connecticut court over whether or not we were reaching too far. And the court said, no, this particular right enumerated in our Constitution, like the others, is subject to the police power of the state. So in my mind, the court said the rights enumerated are not absolute. They are subject to legislation, subject to state law. leading me to ask, do you think there are any of those rights that are absolute, or are they all, or are the checks and balances built into the constitutional system something that apply?
That's a very broad question.
Yeah.
Without having studied those, I certainly think the differences in language are something that I would have to consider and look at how each one of those rights is interpreted and how those words have been understood. Even, very broad rights, for instance, in the federal constitution that don't have any exceptions have been understood to have exceptions, even if they are not written into that language, right? So I don't know that I could make a blanket statement that there are exceptions or limits on broad rights, or that there are no exceptions, or that the exceptions listed are the only ones. It would, turn on a specific and careful analysis of those terms, as well as how those terms have been interpreted over time.
What would be the kind of issues you would have be considering in making that kind of a making that kind of a decision? I'm trying to get at how you think.
Right. So if I were looking at a constitutional provision, I would want to look at the text, the actual text, what that text meant at the time. And then I would want to look at precedent, how that has been interpreted over time. The state of Connecticut, the Supreme Court has identified factors they call the Geisler factors that help identify what kinds of information to look at when interpreting the Connecticut Constitution. And I would be guided by those in an analysis. So that would be looking at precedent from the Connecticut Supreme and Appellate Courts, as well as sister courts, looking at the history of the provision and looking at economic and historical circumstances.
I'll give you a second. Thank you.
Sorry.
So we've been talking about the enumerated rights. Some of them are very broad. And certainly we've seen recently on the federal level with Dobbs, which I think has only been the only two worse cases than that one I can think of are Dred Scott and Plessy versus Ferguson. That there are rights that are not necessarily enumerated, although they can be brought into, as I think Justice Douglas once said, the penumbra of rights that are expressed. In fact, I think that's how they got at the decision in Griswold versus Connecticut. And I'm not expecting in this question what you're thinking or what your decision would be, but I'm hoping you watch the news and read newspapers like most of the rest of us. Where do you think what unenumerated rights do you think continue to face all three branches of government in the current day?
What unenumerated rights? Is that what?
Yeah.
Okay.
But again, I'm trying to judge how your judicial temperament, how you think.
Right. Well, I think the right to privacy is clearly the core one. That is not enumerated in the Connecticut Constitution or the federal Constitution, but it's been found in the Due Process Clause in terms of a substantive right to be left alone by the government. And that has come out in a variety of different contexts, whether it's in the right to marry someone of your choice, the right to use contraception. And so that is one of those unenumerated rights that is in a constitution that has been developed and divined from prior decisions and from the prior decisions of various courts.
Thank you. I couldn't agree with you more on the right to privacy. Believe it or not, about 30 years ago, I actually proposed a constitutional amendment enshrining the right to privacy explicitly in the Constitution, and it never got past the public hearing stage because frankly, the people I thought were crawling out from under rocks, explicitly saying, no, we can tell women how to use their bodies or not. It will be interesting to see how we deal with that in a future session of the General Assembly. So an attempt was made, and it just didn't really work. I thank you. I thank you for that. I was interested when Representative Blumenthal talked about juries because they're not used as much as people think, I think, in this state. Plea bargaining and other state prosecutors use other tools in their toolkit. And by the way, the death penalty in Connecticut was done away with, was abolished by the legislature. I was here for that debate. I voted no, but I understand what it's like to lose on important issues. One issue we talk about, actually, it's usually Tom O'Day who asked the question. I'm going to preempt him. When we're talking to nominees for the Superior Court, is the issue of robitis, where not often, but every once in a while, we come across a judge who gets so enamored of their position and their power that they begin to annoy practitioners, lawyers, attorneys who have been around for a long year, and I have to take their complaints. How would you avoid that kind of robitis that we talk about as a Supreme Court justice?
So I'll start with the simplest answer, which is it's just not in my personality, and I don't see a major personality change at this point in my life. But I think my guess is that almost everyone who comes before you says that. So let me take it another step further. I would certainly hope, and I would ask my colleagues, if I'm confirmed to the Connecticut Supreme Court, it's a multi-member court. Those are the people who see you in interaction in a workplace and would have the best access to information about how you treat people around you and whether you are respectful and have an appropriate judicial temperament. I would ask those colleagues to tell me if they thought there was a problem, if they thought I was not acting appropriately. And that's something that I have seen judges in my career do, or, you know, they will ask people around them to help give them a check. I think the other thing about the Connecticut Supreme Court, certainly with respect to litigants, is that many of their proceedings are available on CTN. You can go back and watch. This committee can watch and see how justices are, comporting themselves in the courtroom where they are interacting with the public most often.
I try not to watch ourselves, but I can understand watching at the court and court arguments we love because they're limited to half an hour. What would your thinking be like if you felt you had to recuse yourself from a case? How would you arrive at that kind of a decision?
I would recuse myself. I mean, I would first study what the standards in law or the practice book, but I would recuse myself broadly in any case in which I had a personal, financial, or professional interest, whether it was a, prior relationship to the case, which seems somewhat unlikely here, but possibly a relationship to the attorneys, that the general public watching would think, I'm not sure that this person could be fair. And if there's the appearance that I couldn't be partial, then I would recuse myself.
Thank you. I mean, we've had this question probably before. I remember years ago, a professor at UConn Law, who I knew, came before the Judiciary Committee because he had been nominated to be a judge of the Superior Court. And he had, at that time, expressed publicly for some years his opposition to the death penalty. And the question was asked, so this wasn't about a personal, financial, or family issue, what he would do if a murder case came up before him. And he said, I just wouldn't sit on any case where at that time the death penalty would have been a possible punishment for it. So it's more than just the financial, and I understand that. And we certainly have a better code of judicial ethics in Connecticut than obviously we do on the federal level. Thank you so much. You've been very frank and candid in answering my questions. I think I have gotten to understand your way of thinking and your approach to the law much more than I did even a week ago. So best wishes. Thank you. Thank you,
Thank-
Mr. Chairman.
Representative Dubitzky.
Thank you, Mr. Chairman. Thank you for coming in and spending all this time with us. It's been very enlightening. The equal justice under the law and the equal application of the law are bedrock foundational concepts in our jurisprudence and have been since this nation was formed. So I was a little surprised in your opening statements, you didn't use the word equal or equality, you used the word equity. Tell me what that means to you.
I used the word equity because and I perhaps was thinking about it almost as a synonym, but I think about treating, I think in my opening, I was referring to implementation of various statutes in a way that treats like cases alike and makes sure that everybody is being held to the same standard and being given access to the same areas or potential for relief, and that like cases are being treated alike. And I think about it this way, you know, many years ago, I had an attorney call us and ask, he said, well, can't you just agree to relief in my case? I won't tell anybody. Nobody will know that the U.S. Attorney's Office agreed to this. And my response was no, because I need to be able to explain to the public and make sure that I'm treating like cases alike. I need to be able to defend it. I need to be able to stand up in court and say, I agreed to relief in this case because this defendant had these characteristics that under governing law entitled him to relief. This next case is different because the factors are different. And these are the factors that I'm seeing as different. And so for me, equality is sort of baked into the law, and it's never done perfectly, certainly, but it is something that I strive for, that it's important to me that we are treating like cases alike and that we are doing our best to treat everyone fairly and equally in our system.
Okay. That, at least to me, sounds like it is in conflict with the word equity. Around here, from my experience of being in the legislature, equity is used when there is a limited resource. Equity is used to allocate more of that resource to people who have traditionally not had access to that resource, to the exclusion or the diminishment of those who have had it in the past. So the classic example is people looking over a fence. The tall guy can see over the fence. He doesn't need a box. The short guy can't see over. He needs a box. So we give the short guy the box. We don't give the tall guy a box. When it comes to the law, one would think that everybody would get the same amount to the same degree, equally, as opposed to equitably. Am I reading too much into that?
I think perhaps then I was not using equity in the same way that you were understanding it, because I wasn't suggesting that. I will say there is one situation where I do feel like the law requires a little bit more. And this is something that we see occasionally in our practice, and I understand it's much more in state courts, in that there are a lot of pro se litigants and people in the federal system, that's what we call the self-represented parties. And so if they're held to the same standards, it's possible their claims are not going to actually be heard, because self-represented parties don't always know the procedures. They don't know how to format their papers. They don't know how to put their arguments into a legal framework, or phrase them as legal arguments. They may just phrase them as, this is what happened to me and this is wrong. And I feel like it's our obligation, it has been our obligation at the U.S. Attorney's Office, and it's part of the obligation of the justice system more broadly, to make sure that people who either can't afford or don't want an attorney still get their claims heard. So our obligation is to read those generously and to try and identify what those claims are and what their best claims are from what they have said. And we may not do that for someone who is represented by an attorney, because in that case, this person has chosen this attorney and they have presented these arguments, and maybe we think that they could come up with a better argument, but they didn't, but this is what they've chosen to present. But for the self-represented parties, in some ways, we do provide that box in the sense of construing their pleadings and construing whatever they file generously, and making sure that whatever those arguments are, we are presenting them fairly and giving them a hearing. It doesn't mean we're going to say, yes, they win, but it is saying, okay, this is what we understand this person to be saying, and this is our response to that.
Okay, other than pro se litigants, can you identify any other instances where equity, as I described it, would come into play?
Not equity as you describe it, but I would think justice comes into play, that we often make charging decisions based or sentencing recommendations based on our assessment of what we think would be just in a case. And I'm not saying we get it right in every case, but we often consider factors like a defendant's background. If we get to the point of understanding, this individual has pled guilty to a crime, and now we've learned a lot about them in the sentencing process. And we know that there was a lot going on that led this person to this place. And perhaps, that would suggest he would get a reduced sentence. And so we wouldn't argue for a higher sentence. So I'm not saying it's not equity in the sense that I think you're talking about it, but it is taking a little bit of humanity and justice and understanding that people are complicated and histories are complicated, and taking that into account as we are doing our jobs, while also taking into account that sometimes, that a lot of our crimes have victims. And so we need to take into account the victims' interests as well. So we're trying to balance all those and take into account and bring a little bit of humanity to it, but I wouldn't call it equity in the sense that you are, but I hope I'm not just missing the terminology here.
Now, that's as a prosecutor. And I certainly understand a prosecutor using their prosecutorial discretion in those manners. Makes perfect sense. As a Supreme Court jurist, how would that play?
I think it would be taking that perspective of making sure I'm taking into account the views of all of the stakeholders in the system, understanding all of the different perspectives, and understanding that people are complicated and these results are, the cases are very meaningful to the litigants before you. Being humble and making sure that I'm listening and getting everybody's perspective. So I think that's the way I would take it to that context.
I will, I've been on the Judiciary Committee now, I guess it's about 9 years. I don't think I have ever heard a nominee for any judgeship come in and in their opening statement say that the Supreme Court, a Supreme Court decision, US Supreme Court decision was wrong. New one on me. Perhaps those that have been on this committee longer than me have heard that, but I don't think I've ever heard anybody come in and say, especially in their opening statement, the Supreme Court was wrong. What other Supreme Court decisions do you believe were wrongly decided?
I could probably identify several others, like I talked about the Yates case.
I'm sorry, which case?
The Yates case. I'm not sure if you were here earlier. I talked about an obstruction of justice case where I felt like they misinterpreted statute. I talked about Dobbs because this is the first time in our history. I feel like this is a singular moment in our history. And as a woman, I feel it very personally. This is the first time that a right has been taken away from over half. I think women are over half the population in this country. And I'm talking about a decided case, and I'm talking about my disagreement with that case. And I feel like I owe it to you to tell you what I think. About that case and my disagreement with its analysis and its result.
Okay, what about analysis? Or do you object to?
Principally, as I've described, they overruled 50 years of precedent without good reason. And in fact, by applying standard factors for stare decisis and the times in which a court would overturn a prior precedent, they blew right past all of those factors. They didn't identify unworkability in the standard. They ignored the reliance interests of women who have relied on the ability to control their bodies and control when and if they're going to get pregnant. And the other part of the analysis that I thought they got wrong was tying the content of a right to the time of enactment. And that did two things. First of all, it ignored the development of precedent over time. It ignored the way that we interpret constitutions to give effect to new principles that are developed in our cases. But it also tied it to a time when the very people who are being subjected to this had absolutely no right to speak about the laws that govern them. And so to say we're going to ask whether women had a right to an abortion, putting aside whether you think they actually got it right about what the content of those rules are, because I'm not completely confident that they were right about what the content of abortion laws were, but women weren't allowed to have a voice in that. And to say that now we're going to tie our rights to a time when I wasn't even part of the polity, strikes me as wrong.
Well, don't we do that with all laws? The statute against murder was created generations ago. So we're tying criminal law to statutes that were created long before any of us were born. And we do that all the time.
And that the legislature can change.
They can change it, but they have not changed.
But, you know, but I think when you're talking about a constitutional provision and refusing to recognize the development in the law over that time, since that time, that is just not a way that I find persuasive as a matter of constitutional interpretation. Statutory interpretation is different because the legislature can respond and can change, but as a matter of constitutional interpretation, you know, overturning a right and tying it to something in the far distant past is wrong.
So is the Constitution, the US Constitution, supposed to be interpreted, or would you interpret it based on the meaning of the words as written, when it was written, or as modern society and culture have amended those words over time?
As I explained earlier, I would interpret constitutions are written with broad protections. And those broad protections, those broad words are given content over time. And so I would interpret the words of a constitution in line with and consistent with the prior interpretations of those words, because the original meaning of search and seizure and unreasonable search and seizure did not have any, there was no understanding that this could apply to the search of a cell phone. And yet, what does that mean? And we have new rules for what an unreasonable search or seizure of a cell phone is. Because we have a new situation, we have a new fact pattern. And so what we have is the application of timeless principles to new fact patterns that provides new ways of understanding those principles.
Right, but doesn't that confuse application and interpretation? The unreasonable search and seizure is still the same, it's just applied to a new set of facts. We're not reinterpreting the Constitution, we're just applying it to a new set of facts and a new circumstance that came up before when the Constitution was written. That they didn't have computers, but they did have paper. And the unreasonable search and seizure applies the same to paper and computers with just technical changes. Isn't that right?
I'm not sure I completely agree with you, and I don't want to quibble with interpretation versus application. I think there are a lot of really hard questions that have led to really new rules about the searches of computers. And that, just using that as an example. And, you know, the Supreme Court decided a case a few years ago, because it used to be that if you were stopped, if you were arrested, the police could search anything on your person, right? If you had a date book or an address book in your pocket, they could look through the address book. They could look through your diary if you were carrying it around, because it was seized pursuant to your arrest. And after, but that same rule does not apply to cell phones. If you are arrested and you have your cell phone on your person, which most people do, law enforcement can't search. It would be unreasonable, according to the Supreme Court, to search that cell phone. They can seize the cell phone, especially if they're going to put you into custody and they have to take all of your belongings from you. But they can't search that cell phone in the same way they might have been able to flip through your address book that was in your pocket at the time of the founding. So to me, that strikes me as a difference, and we can call it a difference of interpretation, a difference of application, but it is applying timeless principles and new fact patterns that give those they give those meaning.
Right. Well, I guess that particular example isn't the best one for this discussion, because using the word reasonable could change over time. But things like Congress shall pass no law abridging the freedom of the press, for example, or freedom of speech. Those words meant something when they were written. Do you feel that those words, that the meaning of them has changed, and therefore the interpretation of the Constitution needs to change as well?
I don't think the meaning of the words has changed, but I think our understanding about how they apply in new situations has changed.
Okay. So for example, in the and I don't believe that in the Constitution the word woman even exists. But if it did, then it was written at a certain point and it meant a certain thing. These days, the definition of woman has been changing. Do we use the definition that was meant in the Constitution or in the law or in a statute? Or do we look at the new definition that has changed based on culture?
You know, you're going to be looking at the original public meaning to understand what that word originally meant, but you're going to apply it in light of the principles that have been applied over time. If you're talking about a statute, it may very well be helpful to understand what the legislature meant by a term at the time that it enacted that word, because it may be that that word, I mean, words evolve over time. Some words mean something different than they did 50 years ago. And so it's helpful sometimes to know, and that's why we look at dictionaries, what did this word mean to the people who were using it when they put it into the statute? And, you know, I think that that is usually in textual analysis, that can often be a really good place to end. And, you know, this body has enacted a statute that tells us to look at the plain meaning of the words. And if it doesn't present an unworkable standard, we don't go beyond. But, you know, if a statute, if a court interprets a statute in a way that is inconsistent with what the legislature intended or wanted, the legislature can always change that. And that is the branches working in concert with each other, and the checks and balances that are built into the state constitution as well as the federal constitution.
And in that, you say that the legislature can always change it. If they've written a statute that they believe is clear, and they believe should be interpreted in a given way. And the court interprets it wrongly or in a way that is not consistent with the statute that was written by the legislature. You're suggesting that the legislature can come back and change the statute?
If the interpretation is incorrect, yes.
Okay, why would they change the statute if they created a statute that they believe is proper and clear?
I'm sorry, I thought I understood your question to be that the legislature enacted a statute and the court interpreted it in a way inconsistent with what they thought they had done.
Correct.
So then you have a judicial interpretation of a statute that would control that statute unless and until the legislature changes that. It's part of the process of checks and balances, you know, the interaction between the judiciary and the General Assembly.
And to what extent is the court's belief that the legislature got it wrong? How does that play into that type of situation?
You know, when you say the court's got it, the court believes the legislature got it wrong, I'm not sure what that means, because my view of a judicial role in interpreting statutes is to apply and interpret the words that the legislature adopted, even if you disagree, or even if you think they could have written a better statute or should have written a different statute. I'm not sure if you were here for my earlier discussion about the Yates case and about how a judge's policy preferences really shouldn't bear on that. That if a judge believes, you know what, I think this statute, I don't think the General Assembly should have written a statute with such high penalties, or I don't think they should have criminalized this conduct, or I don't think they should have done that. That's not the judicial role, in my perspective, for a statutory analysis. The job is to interpret and apply the statutes as written and do your best. And, you know, sometimes there are hard cases because the language is hard, or because it's ambiguous, or it has some sort of, you know, unintended meaning, you know, whatever the hard cases are. The courts do their best to interpret and imply, and certainly I would do my best to interpret and apply the words as written by the legislature. Even if I thought,
I'm sure if you've been paying attention over the last few years, you've seen some disputes between this committee, especially in the legislature on one hand, and some of the Supreme Court justices on the other, when they have taken it upon themselves to advocate for certain policies in their decisions. And we have at times worked on laws that would rein them back in. We have also had justices in that seat saying, you know, we're considering not confirming you or not reconfirming you because of our concern that you are essentially usurping our power here. And that, you know, I feel that is a big issue with, you know, my statement at the time was, you know, we each have our own side of the street. And sometimes it gets a little mixed up, and thankfully this committee straightens it out when that happens. Should race, sex, sexual orientation, or other immutable characteristics be used as a factor in the selection of judges?
you know, I think that is a consideration for the governor and for this committee. I tend to think it's good to have a judiciary and a judicial system that reflects the diversity of our community, including along all of those statistics, all of those variables that you have just described. And I think it's important because we all bring those things to our professional lives. We bring our experiences, we bring our perspectives. And I'm thinking back to a case that was just argued at the US Supreme Court, and it was a stalking case. And it was an individual who had sent thousands of text messages and messages of other sorts to a woman over the course of several years, and she had done her best to block him and to change her address and to find a way away from him. But his comments were always of the sort of, don't you want to go get coffee? Or they, you know, in isolation were rather innocuous in some level, but the volume of them was phenomenal and quite alarming. And as a woman, I was listening to that and hearing this argument and thinking, wow, you know, like that would scare the living daylights out of me. And I was kind of scared by it. And I was struck by some of the male justices who were really sort of dismissive of this conduct. And it struck me that part of this was just a difference in perspective of knowing what it is to be a woman in this world and knowing, you know, how threatening messages can seem, even if they sound innocuous, and especially when you're talking about thousands of messages. So I say that the other example that I would bring from the US Supreme Court, there was another recent argument where Justice Sotomayor piped up. There was a lot of discussion about different levels of government, and everybody kept talking about certain levels. And she finally said, well, let's not forget about the territories. And so when she says that, what she's saying is, I'm bringing my background as someone from a territory, and I'm familiar to this, and I am aware of these. And that's a good way to make sure that those voices are heard and that the community can look up and say, that court, here's my community, here's me.
Okay, well, I appreciate the benefit of having a diverse judiciary. That wasn't my question. My question is, should race, sex, sexual orientation, and other immutable characteristics be used as a factor in the selection of judges?
You know, I think that is something that the Judicial Selection Commission pays attention to and tries to ensure a diverse bench. I think it is something that, you know, it sort of is a high-level policy matter, is something for the governor and this body to consider. If I were governor, I would do that. I would consider that because I would want to make sure the judiciary reflected the diversity of this community.
Okay, what about in the selection of doctors?
In selection of doctors?
Yeah.
I'm not sure I understand the context of like who should be my doctor or who, I just,
Yeah,
No.
Representative Trubisky, where does this go to her qualifications to be a justice? Report?
My next questions would be, is it legal under Connecticut law?
All right, proceed.
Thank you.
I don't know what you mean by selection of doctors. I apologize. Perhaps you could,
Okay, so
for a hospital.
let's
or-
say selection of students to be doctors.
So students to be doctors, that's a question about sort of affirmative action in the hiring context or in the educational context. That is a question that is at the US Supreme Court right now. And whether it is a good idea as a policy matter or whether it would be good as a policy matter is a separate question. And whether I think it's a good thing, which I tend to think it's a good idea to have doctors from all walks of life. But whether it's a good idea is a different question than is it constitutional and is it allowed? I'm certainly not aware of anything under the Connecticut Constitution. I haven't studied this issue under the Connecticut Constitution. Because it is an issue that could come up, especially depending on what the US Supreme Court does, I just need to probably end my answer there with, it'll kind of depend.
Okay. You didn't seem to have any concern about abortion cases that might come up. Why would you talk about those but not this?
So I was very careful in my responses because I thought a lot about this. I'm talking to you about my views as a woman and as a lawyer about whether Dobbs was correctly decided.
Okay.
And I'm going to tell you that Dobbs was incorrectly decided. I gave you my view, and I stand by this, that the US Constitution should include a right to abortion. It does include a right to privacy. Analogous provisions of the Connecticut Constitution and the Connecticut Supreme Court has historically, and as I understand it, always interpreted the Connecticut Constitution to be at least as protective, if not more protective, than the federal Constitution. So I am not telling you how I would rule in any particular case. I'm telling you the way I would approach those. I can't see any way, for example, that the Connecticut's Roe statute from 1990 would be unconstitutional under the federal Constitution. I mean, Dobbs said states can do whatever they want in terms of protecting, weighing those balances. And I don't know how the newer provisions of law would shake out in potential challenges. But what I am telling you is my belief that the federal Constitution should and does contain a right to privacy and should contain a right to abortion. The Connecticut Constitution has always been interpreted to protect at least as much or more.
Okay. Where in the US Constitution is the right to privacy
It's been found in the Due Process Clause,
of
the 5th and 14th Amendments.
both?
I think so, but perhaps I'm wrong. It's the substantive due process clause, but it's, the 14th Amendment is the one obviously that applies to the states.
Okay. But clearly it's not in the text of either one of those amendments.
Correct.
Now you said that states can enhance the rights of the people under the state constitution, and that the federal constitution constitutes a floor. Is that do I correctly get your testimony?
Yes, that's my understanding of how it has been interpreted by the Connecticut Supreme Court repeatedly.
Okay. Can the state create rights that conflict with the federal rights?
Those would be case by case analysis. I'm trying to figure out how that analysis would be done. There are well-established standards for evaluating conflicts between federal law and federal constitutional law and state laws. So that's sort of a hard question to answer in the abstract.
Okay, so I'll be a little more specific. Let's say the state of Connecticut passed a constitutional amendment that people have the right to be free from offensive speech that is protected under the federal constitution. How would you approach that issue?
If the claim were that this provision conflicted with a federal constitutional provision,
Well, we know there is a right to free speech in the Constitution, First Amendment, right?
correct.
So the state of Connecticut creates a right to be protected from offensive speech. That would clearly, that in my view, at least, it would be in conflict with the federal Constitution. How would you as a justice look at an issue like that and analyze how the Connecticut law and the federal law could either be in conflict or how they could be looked at together?
So the jurisprudence under the Supremacy Clause is well established. I haven't spent a long time doing it, but I would look at that jurisprudence to determine how closely. I would imagine there is a question of, is there a real conflict? Is there a way to read these in congruity? But the federal Constitution controls is supreme, and the state can't pass a law that would violate the federal Constitution. And so I would be looking to apply the standards of the First Amendment. Does this violate the First Amendment as it has been interpreted by the U.S. Supreme Court?
Okay, and so you're saying that if it did, then the excuse me, chair just fell. So if it did violate the First Amendment, then the Connecticut law or Connecticut constitutional provision would have to take a backseat to the federal provision?
That's my understanding, that Connecticut can't enforce unconstitutional laws under the federal constitution.
Okay. To what extent do the opinions of other people have a role in the interpretation of a person's rights? So for example, if 99% of the people in Connecticut say they want a law that restricts the speech of the other 1%, to what degree or how would you take into account this overwhelming popular demand to limit this speech?
I'm not aware of First Amendment, the popularity of a particular law, if it infringes on somebody's rights, being a factor that is considered. If a statute is passed, whether it's passed by 50% or 99% of a legislature is kind of beside the point, as long as it is passed according to the state procedures. But I'm not aware of the relative popularity being a factor to consider in what is this, does this violate an individual's civil rights or an individual's First Amendment rights?
Okay, so evidence of surveys showing that people want these restrictions, that wouldn't be something that you'd consider?
I don't see it as relevant most of the time. And if you wanted to show me a line of cases that said it is relevant to some purpose, I would say, okay. But, the essence of civil rights and the protection of those rights is that sometimes the majority wants to do things and our constitutions say you can't do those things, even if a majority wants to do them, right? That's the essence of the civil rights. That's the essence of protecting civil liberties and civil rights, that we're protecting from a tyranny of the majority, even if it is 99%.
You answered a number of questions today with regard to stare decisis. What is stare decisis in your mind?
Stare decisis is respect for precedent and respect for the prior decisions on a court. And to me, it's one of the crucial foundations of the rule of law. It promotes respect for the judiciary and for the judicial process, respect for the law. And it is, to me, a doctrine of judicial humility, of recognizing that a lot of people possibly came before you and have reached this decision. And so a respect for the wisdom of the people who came before you. And that's sort of one of the inherent parts of it to me. But it's also a recognition that court decisions have consequences and people rely on them and people order their lives around those decisions sometimes, especially sort of the larger ones where the public or lawyers, but public more at large really order their lives around, this is how we're going to organize based on our understanding of the law. And if the court comes in and changes the law every few years, that's very, very disruptive. So for me, stare decisis is really core to the rule of law.
Okay, and in what way does stare decisis constrain the judiciary?
Because there are standards, and I think appropriately stringent standards for when you may or should overrule a prior precedent. In the absence of that, the mere fact that you disagree with a prior case isn't good enough, doesn't get you to, okay, well, I think I figured this out better, so I'm just going to change the law. That's not what stare decisis is. And so that constraint is there. I think I might have come to a different conclusion, but I'm going to hold to what the original judges did. So if you look at the Casey decision, for example, the justices who issued that decision said, we might not have come to this conclusion originally. This might not have been what we wanted. Roe might not be something that we agree with, but we're going to stick with it. for stare decisis reasons. That's a constraint.
What about if it's just wrong?
That's the first part of the analysis. Is it wrong? And that's, not to be ignored, but is it wrong? And sometimes there are really wrong things that need to be changed, right? But is it wrong is just the first part. Then you also need to ask, let's look at, is it producing some sort of absurd or unworkable result? Are there major factual or legal developments since that decision that have demonstrated how wrong this was? And then also, what are the reliance interests? What have people relied on about that decision?
Who created those rules?
Those rules about stare decisis?
Yeah.
They've been developed over time by judges over time.
Okay, is the Supreme Court bound by them?
The Supreme Court is bound by them to the same extent that they're bound by the principles of stare decisis. Yes.
Okay, so the court, so you're saying that the Supreme Court, the state Supreme Court and or the excuse me, federal Supreme Court, they must go through that analysis?
I mean, I guess they should, is the way I should phrase it. That is, those are the standards. And in a system of laws, we expect the courts, the courts have said these are the standards that we're going to apply when we're considering whether to change our minds on a topic. And so respect for law says that's what you would do. The Connecticut Supreme Court actually just changed an interpretation of a statute. And they ran through this process and said, we think the original decision was wrong, but let's look at all of these factors. Has it proved to be unworkable? What kind of reliance interests are there? And so to promote respect for the law and to actually evince that as respect, you should follow those standards.
Okay, so something like Plessy versus Ferguson, you know that case, right?
Yes.
Okay, that's the case, the 1896 case that found that separate accommodations for the different races was constitutional.
Mhm.
That was overturned by Brown versus Board of Education in 1954, 56, something like that.
Mhm.
So if you were on that court, on the Brown versus Board of Education court, and you were looking at a case, the case of Plessy versus Ferguson, and determining whether or not to lean on stare decisis in upholding that decision, how would you handle that?
It's been a while since I've read Brown. I don't remember if they went through all of the stare decisis factors, but I would look at those factors and I would say, you know what, we've learned a lot since Plessy v. Ferguson. Perhaps we should have known it at the time, but we have demonstrated how harmful this system is. The social facts on the ground have demonstrated to us how bad this system is and that there are actual systemic and hard facts and that separate but equal isn't actually separate but equal. So I think you can look at those factors and still come to the conclusion that Brown versus Board was correct to overrule Plessy v. Ferguson. And like I said, there are cases that need to be overruled. But I think a careful attention to those factors is going to get you to the right result most of the time.
How long does a case need, does a law need to be on the books before the meaning of the words that the legislature gave it becomes subject to revision by the court?
I don't think the words of a statute become subject to revision ever. I mean, I'm not sure. I don't see that as the job of the judiciary.
Well, if there is a statute with, and the words, or a constitutional provision, and the words have certain meaning at the time they're written, and those words, the meaning of those words change over time, and the court looks at it and says, well, the words mean this now, we'll interpret it the way the words mean now. How long does that have to be? Is there a set time, or is it based on societal norms? How does that work?
You know, as I've said before, it is a process of iterative interpretation in our common law process of judges relying on the prior precedents. When you have constitutional interpretation, constitutional provisions that are deliberately vague and deliberately broad, they are to be given meaning over time. And so you look at those interpretations over time. Statutes are a little bit different because you can identify what a statute meant, and even if perhaps what it meant at the time, and do your best to interpret the text as written by the legislature. But because constitutional provisions can't be changed by the legislature as easily, of course, or even solely, you know, you have to be more careful. And they're also written broader. Statutes tend to be much more narrow and much more targeted. And so the language is something that you can identify for a particular purpose. I don't see a length of time. It's not a time issue. It is about an interpretation issue. And also, you know, I go back to my commitment to judicial humility, that there is a real importance to decide the case in front of you and not try and decide more, not try and see down the road to understand what the facts are, what the cases might be coming forward. Decide this case. I mean, that was something that Justice O'Connor was really adamant about. You know, she could see some of the corners coming. Corners, that's probably the wrong analogy here, but she could see some of the cases coming down the road, but she couldn't see all of them. And she knew that she needed to be able to say, look, that next case is different, and it's different for this reason. That is a process of iterative interpretation that we follow in our common law system.
But you may be called upon, or will likely be called upon, to rule on cases of first impression, where there is no long history of other court decisions and other interpretations. You will see this for the first time. And it may not have, there may not be a decision or a case for years or decades or generations between when the statute or constitutional provision is created and when you need to interpret it. So you may not have the benefit of all those iterative decisions. So in that case, where do you go?
You start with the text, and it would be always helpful to understand the original meaning of the text, of what those words might have meant to the legislators at the time. Did those words have a specific meaning? Were they a term of art in a particular area? If you're talking about a healthcare statute, is this a term of art in the healthcare world? Was it a term of art at the time? And maybe that meaning has changed over time. So it's always important to understand, when you're trying to interpret the text of a statute, what did this legislature likely mean by using this word? And if it's a question of first impression, you apply traditional tools of statutory construction. You look at the text, you look at the structure, you look at the ways that this provision interacts with other provisions around it. You look at its likely impact. And sometimes it's really helpful, especially if you're in a world of ambiguity and you can't get there, to understand sort of the purpose behind the statute. You know, there was a federal statute years ago, that was in direct reaction to a Supreme Court case. The Supreme Court decided that the federal statute meant X. Congress didn't like it. They added, you know, language to specifically respond to that. And so it's helpful to kind of understand, okay, this was the context in which this statute was enacted. So let's understand the context and the purpose behind it to help us understand what these words might have meant. That could be really helpful to understanding. And then I would look to, you know, traditional factors of statutory interpretation to help flesh out those answers.
Okay, so once you determined what the legislature meant by the words, do you then factor in societal conditions and other issues to determine whether or not justice is done, or do you just take the words as written by the legislature?
As I've said before, you take the words as written by the legislature.
Where do people's inalienable rights come from?
You know, they're guaranteed in our founding documents. And, you know, I look to our founding documents for those.
Okay, they're guaranteed by the founding documents. Are they granted by the founding documents?
Sort of a metaphysical question. I don't know that.
It is.
So, haven't thought about that in a long time, but I don't see them as being granted. They, pre-exist. They're sort of the rights of individuals. But I don't want to.
Are there any inalienable rights in the Connecticut Constitution?
I don't remember that language off the top of my head, but but I could be proved wrong.
You talked as a prosecutor about seeking justice. Is that also the role of a justice?
I think it is. I think it is the obligation to do justice and do the right thing in the cases that come before you. Yes.
Okay, and what happens when the interpretation and application of the law conflicts with your concepts of justice?
That's a very broad question because I'm trying to figure out how that would happen in a concrete case. I would apply the law. My job is to apply the law. And then in most cases, applying the law is going to be doing justice. And I really and firmly believe that if we are applying the laws as enacted by the General Assembly and as guaranteed by our Constitution, we are going to be doing justice. And so I have a hard time picturing how my vision of justice is going to conflict with an outcome in a case.
Well, you had said that you would do the right thing even if you thought you would be overturned. Did I listen? Did I hear it right? Because I thought that's what you said.
I don't remember exactly what I said. I should have been more careful in saying I would do the right thing by the law and interpret the law as I understood it in my best obligation to follow the law, even if I thought that might be overturned. Not do the right thing separate and apart from the law. It would be doing the right thing, meaning interpreting the law to the best of my ability.
Okay. So when I heard you say that originally, this question came to mind. Would you go against the higher court precedent if you thought it was wrongly decided?
So perhaps the example you're thinking about is Dobbs. I can't.
I was just thinking based on the statement that you made.
So higher court precedent controls that we have a vertical system in our country with respect to federal constitutional questions. The US Supreme Court gets to decide what they mean, even if I disagree. They get to decide, for example, what the federal obstruction of justice statute means, even if I disagree. And that's just what it is. I follow that precedent on those issues, but that doesn't constrain the interpretation of different issues or the construction of the Connecticut Constitution.
Okay. In your nominee questionnaire, question 3, how do you feel about the statement that judges should interpret the Constitution to enforce the original intent of the drafters? Do you believe that the interpretation of the Constitution must evolve with history? And the portion I'd like to ask you about is the last sentence that you wrote, which is the interpretation of any provision will not be static because the text will be applied to new situations. Could you, I know we talked a little about this, but can you explain what you meant by that?
I think it's a repeat of some of the discussions that we've already had, that I believe that the meaning of constitutional provisions is given content over time. And so the due process clause, including, for instance, a right to contraception, that principle helps inform a right to bodily autonomy. And so it's given content as it over time. And it's not that the meaning changes, but it the same with the Fourth Amendment, when you're talking about what is an unreasonable search and seizure, that is going to be given content as applied to new situations. And so what might seem reasonable or unreasonable is something that is going to be understood based on changing technology.
Okay. And that change would be in the that change would be contrary to, or could be contrary to stare decisis. Right?
I don't see the conflict that you're seeing there. I mean, it's, as you're saying it, I mean,
Well, if the law is developing, it's changing, and it's changing away from what previous rulings have indicated. So, it may be heading in the same trajectory, but it is still different from what previous courts have done. So this new interpretation essentially, although it may be going in the same direction, it is not the same decision. So it would be, from my view, in contrast to stare decisis.
I guess I don't see it that way. I see it that more as just the general development of the law through our common law iterative process.
All right. Well, thank you very much. I appreciate your answers. Thank you, Mr. Chairman.
Attorney Glover, do you need?
I
yeah,
need to break it.
Sounds like a good idea. Let's take a 10-minute recess.
Thank you.
All right, I'd like to call us back to order. Representative Callahan, you have the floor, sir.
Thank you, Mr. Chairman, and I'll be very brief. Please assure your family sitting behind you, I'll be very brief. I know you've had a tough day today, and I appreciate your stamina. A couple of quick questions. I've heard all the testimony today, and I guess a couple of clarification questions for me to bring it together for myself. Based on what I'm hearing today, can I be assured that should you be confirmed, your decisions on the Supreme Court would only be based on Connecticut law and have nothing to do with your personal ideology, your personal opinion, or current popular opinion?
Yes.
I appreciate that. And I've read in the background information we were provided a lot of your legal experience. Can you give me some other work experience and life experience that influences would influence your decision making?
Beyond my professional experience?
Beyond before you became a lawyer, even if it was part-time job, something that could help relate to the people of Connecticut.
You know, I spent before law school, I spent several months after graduate school working as a secretary for various temp agencies. And it was, you know, it was great experience to understand, you know, the inner workings of different businesses. But, you know, I think that was, you know, I knew I was going to law school, so I knew it was time limited. You know, I think the other experience that has really informed me and informed my decision-making is my role as a parent. I have 2 children, and, you know, the role of a parent, you never feel like you're doing enough or doing it right, or at least I don't. Maybe other people are more confident in it. And, you know, you also learn how to deal with disappointment and scary situations, and you learn how to recognize that people make mistakes. Everybody makes mistakes. And how do we address those mistakes in a supportive environment? And, you know, I think that is something that I certainly, you know, take to my job, that we're never as, you know, we are more than just our worst day or whatever brought us to the criminal justice system, for example, that we are all very complicated people. And I think that's something that I bring from, you know, that has really stood out to me in my work at the U.S. Attorney's Office, but also my role as a parent. And I'm not saying my kids have done anything that would be really worse, but I'm just sort of speaking in generalities, as they're going to grill me later about what I meant by that.
I won't ask them to chime in.
Thank you.
And my last question is, having worked for judicial for almost 30 years, I watched people work their way up through the ranks. I watched judges who started off a little shaky on the bench become some of the best jurists I've ever seen. Knowing that there are some of those judges who've waited a long time in the selection committee to get on the Supreme Court, and you have a very distinguished career in the federal court as a prosecutor, and I've talked to some of your colleagues who confirmed that for me. But you have been, you're a recent nominee, and you've stepped in front of some of those judges who worked their whole careers for a shot at the Supreme Court. I guess I'm looking for assurance that you are the right pick, and I'm asking you, assure me that you are the right pick.
You know, sorry. I'm certainly not the only pick. What I can tell you is that the governor has made the decision that he thinks I have the qualifications. I think I bring a lot to this job. I think coming to, and so I can tell you what I think about me. And I don't think it reflects on anything of anybody else, because I think there's certainly other qualified people for this position. But I can tell you, I bring my longstanding commitment to the rule of law, my longstanding love of the law, my commitment to a strong and independent judiciary, and my reputation as an excellent lawyer with expertise and experience in construing statutory and constitutional provisions. You know, I think that's what makes me qualified. People come to the Supreme Court with all kinds of positions, with all kinds of backgrounds. And I think it's good to have diverse backgrounds and to have diverse perspectives. And I hope I would be able to add something to that on the court.
Well, I appreciate your answers, Attorney Glover, and I know you had a long day, and so that will end my questioning there. And I thank you for the answers, and I thank you, Mr. Chair.
Thank you, Representative Callahan. Attorney Glover, I promise you we're getting to the end here. I've got a couple brief questions, and then I think
Sure.
Senator Winfield does, and then we're gonna let you go after that. But I just kind of picking up on what Representative Callahan was just asking about. I think one of the questions I've heard from folks about your nomination is, and I know we had a chance to talk a little bit about this last week, but somebody who doesn't have experience as a judge in our state court system and really doesn't have a lot of practice or experience in practice in our state court system. You know, you talked a little bit about the substantive law and, you know, that we're lawyers, right? I don't have a concern on that. You know, we're trained to do legal research. You'll have, I'm sure, you know, excellent law clerks and the like to help you on that. And you know, even on practice book rules and the rules of evidence, you know, some of that kind of matches up with the federal system. I guess what I would like you to address, if you could, is the concern that's out there by some about you not having a background in some of the unwritten rules of our state court system, right? You know, we talk often about you know, in a federal practice, you know, things tend to happen a lot slower, right? I mean, I practice in both systems. I'm a civil litigator. I've got federal court cases. I've got state court cases, right? In the federal system, judges tend to have more time on particular cases. You don't have a calendar call where you show up with multiple cases on a Monday morning. Judges are typically dealing just with civil cases and criminal cases. They're not dealing with juvenile matters. Generally, they're not dealing with family court cases. They're not dealing with probate appeals. You know, they're often not, they're very rarely dealing with pro se or underrepresented litigants. And the practice is different as a result of that, right? You know, I'm reminded of, you know, old Joe Mursky trekking through the GA in his sneakers type of lawyering. And so both, if you could address sort of what you think the learning curve will be for you, not just in dealing with litigants, but in dealing with a lot of members of our bar in Connecticut who do no federal practice and, you know, make a living on volume processing and helping clients process a lot of cases in our state court system, be that criminal cases or you know, low-level civil cases or family cases, and how you think you're going to be able to adjust to that overseeing and being at the top of that type of a court system.
So I'm certainly aware that there will be a learning curve. And as you point out, there's a difference between the substantive law and sort of the unwritten practice and sort of the way things actually operate in practice. And that's where I would really expect to be doing a lot of learning, especially at the beginning, right? I expect that I can learn I feel confident that I can get into the substantive law, but I would expect to learn from my colleagues on the bench, if I'm confirmed, the people who have that deep practice, either as judges or prior practitioners. I would expect to learn from people who I know are current Superior Court judges about what kinds of issues they're seeing, people who have a deep familiarity with the family court system, or people who have, you know, familiarity with the juvenile system. And what are the issues and what are, you know, what's the impact? Because I feel, you know, very strongly for an appellate court or the Connecticut Supreme Court, it's really important to be able to provide guidance to lower courts, to judges, to litigants, to the public. And a large part of that is understanding the sort of how things actually operate in practice. And so I would expect to do a lot of talking and listening and making sure that I'm in a position through committees or conversations with people in the system. What do I need to know about this? What am I not getting? To help, you know, let me spend some time watching your courtroom and see what it's like. Let me see what this is. Talk to me about what I need to understand when I'm deciding cases that are coming up through here. So I really see it as a large part of what I would consider to be my job, to learn, to get up to speed on those issues, and then to learn from those around me.
You've been asked bunch of questions today about the interplay between the state constitution, the federal constitution, and certain rights being, being stronger in one than the other. One of the issues we've not talked about, I think, at all today is gun rights and the right to own and possess a firearm. And at least some scholars have suggested that the right of an individual to own a firearm is stronger under the Connecticut Constitution than it is even under the federal Constitution. So my question to you is, do you agree with that assessment, just generally? Well, let me stop there. Do you agree with that assessment generally?
I'm uncomfortable making that statement generally because I know that there was a difference in language, and it's my understanding that language has not been definitively interpreted in the Connecticut Constitution. If I'm wrong, I just haven't studied that issue. But I am aware that there's a difference in language, and that the U.S. Constitution may well change the way that the Connecticut laws can be considered under the Connecticut Constitution as well. So I'm a little bit wary of making a broad pronouncement.
So obviously you've talked a lot about Dobbs today,
Right.
And you've been asked about other decisions that were wrongly decided.
Mhm.
What about Bruin?
I think Bruin was wrong for similar reasons to Dobbs, in that it tied rights or the content of a constitutional provision to the time of the founding. And so now that according to the U.S. Supreme Court, we have to identify appropriate or constitutional gun legislation or gun restrictions by looking at, is there a historical analog to what was going on at the time of the founding? And the devil's in the details on that analysis, because how do you evaluate what is a historical analog, and deciding what is an analog or not leaves a lot of room. I think, in my review of the cases so far, and I haven't looked at all of them, but I'm sort of broadly aware of the cases post Bruin. Courts have done a lot of work in trying to uphold reasonable gun regulations, and Bruin itself offered some pathways. The issue in Bruin was about a New York statute that appeared to give too much discretion to the permitting authorities, and specifically identified that there were states, and Connecticut was one of the states that was identified, that had a system that would, that might come out differently because it wasn't a discretionary system. But a lot of those details are going to be in the the application to specific cases. But I think tying it to that, the other thing about that I really have a hard, and part of the reason that it's hard to do, and I think it's improper, is that I'm a lawyer and I feel really confident in my ability to do law. I'm not a historian, and I worry about a U.S. Supreme Court that tells judges across the country, go be historians, or rely on the parties to be historians, because that's a really tough thing. I think history, which history do you look at? Who is included in that history? And what are these contested sources, or maybe snippets of contested sources, actually mean? So I think that's a really hard area. Bruin is what it is. It controls the interpretation of the Second Amendment. But I think that courts and legislatures have, you all can, do our best and hope that we can find historical analogs that, meet that test. But that is the test that we have to apply, given where the U.S. Supreme Court is.
So let me ask you then, because this has been because of this letter that's out there about Justice Barrett, in addition to the Dobbs issue. I just want to give you the opportunity then, if you want it. So Justice Barrett wrote a concurring opinion in the Bruin decision, as you may know, and that concurring opinion seems to suggest not just that we look at the historical tradition, but in fact, the historical tradition that we should be looking at is not 1868, which is when the 14th Amendment was adopted, because at that time, in just after the Civil War and post-Reconstruction, in fact, there was a lot of Western states, Texas being one of them, that actually did have and did put in place proper cause requirements for firearms. And one could draw the analogy to what New York was trying to effectuate to what Texas had at that time and in Reconstruction. And her concurring seems to suggest that actually the historical analysis we should be looking at is all the way back to 1791. You know, frankly, I sort of like that idea, because I think that back then we only had the single shot musket. So maybe we go back to the single shot musket being the only gun allowed in the state of Connecticut. But, you know, I think I offered that amendment a couple of years ago, but truth be, but in all seriousness, I just do want to give you the opportunity, because you've been asked a lot of questions about Barrett and this letter on the Dobbs issue. You know, do you repudiate her decision on Bruin as well?
I just want to be clear. Yes, I think the Bruin was wrongly decided for the reasons I've described. I'm trying to remember her concurrence, because I don't remember as definitively as I recall. She wrote it kind of like, but I could be wrong.
She raised the question.
She raised the question.
She was not definitive about it, but I think at least most of the commentary I've read on it seems to suggest what she was getting at is
right.
The more restrictive than the less restrictive view of the historical test.
Right, but I think that just goes to the question of why are we doing this in the first place? You know, that that prior to Heller, the Supreme Court had understood the Second Amendment in a different way, and this contingent question of let's go back to history and determine what gun regulations were done at a particular time requires a lot of pretty policy laden judgments about which history you're supposed to be looking at. And so that's one of the problems I have with those kinds of decisions. I'm not a legal historian. I'm not a historian. I'm a lawyer. And the other thing about the Bruin decision that is very difficult is I think, I forget the phrasing, but it was basically like, courts aren't going to do this. They're just going to leave it to the parties to bring this information forward. And they're just going to rule on what the parties say. And this is sort of a paraphrase, but that just puts the onus and the burden of litigation on people who, probably the state's trying to defend it, but still, we are all lawyers. We are not historians. How do we do that? How do we find that analysis? And that's just not the way that I would approach a constitution, and thinking that we are bound by what, bound forever by what they did in the 1790s, absent the single shot musket.
And I'm not going to ask about specific provisions because frankly, they could come before you, but I suspect this is not an academic question here in Connecticut. I mean, we are poised hopefully to enact one of the most significant rewrites of our gun laws in the last 10 years this year in Connecticut under Governor Lamont's leadership. So I do think it is a topic that is ripe and likely will be litigated, and I think it's important for us to understand sort of where you are in terms of the Connecticut Constitution and the federal Constitution on the right to own certain types of firearms. So I wanted to make sure I gave you that opportunity. If there's anything else you wanted to add to it.
Right. I mean, the hard part is the right to own firearms, as protected by the Second Amendment, may crowd out what this legislature would want to do. And, unfortunately, it may not allow room, because we would be bound by the Second Amendment and by the U.S. Supreme Court's interpretation of that amendment. But, to the extent the Connecticut Constitution would impose different restrictions or just allow different regulations. Unfortunately, those may not be, if they would be allowed under the Connecticut Constitution, but not under the Second Amendment, that's where the problem would come. But as I've said, I think Broome was wrongly decided. And I think that courts have done their best to try and find a balance, because I don't think it is perhaps it is disputed. I don't think it's disputed to say that we have a gun problem in this country. And, you can look around to other countries around the world who also have mental health issues, who also have video games or whatever the latest issue is, and not recognize that a large part of our problem is guns. And so the policy question, the policy judgment of this body, how do we try to address that significant societal problem consistent with what the US Supreme Court has said, I think is a hard one. And I can't, as you recognize, predict how I would consider each one of those provisions, but I do consider it a significant problem. My older child, we're in Guilford, and Ethan's Song was in the same grade as my older kid. I didn't know him well, but I knew him. And his family has made it their mission since he died. I'm not sure if you all know of Ethan's Song, but
There's a picture of me and him signing, or
Yeah.
me and his parents on the day the bill passed the state senate in my office.
And, and the thought that we have parents making a mission out of gun control legislation is heartbreaking to me.
Let me turn back real quick to question 12 on your questionnaire, which was the one about whether the balance has begun to tip too far for criminal defendants in our state system or not. And I heard you use a couple times today, either in response to this question or elsewhere, talking about the restraints on law enforcement. I guess the word restraint to me is a tough one, because I mean, I think it's less a restraint on law enforcement and more a safeguard on a wrongful conviction. And I guess I'm trying to get a sense from you of at what point does sort of our rules go from being a safeguard to a constraint in your mind, or are you using the word constraint the same way I'm thinking of a safeguard?
I mean, I'm probably using it the same way. I just, when I think about restraint, I think about, law enforcement at its best, and I'm not saying that's always where it is, but at its best is trying to serve public safety and trying to promote public safety. But we don't just let law enforcement do whatever they want to promote public safety, right? And so I think about it that way, that we have systems, we tell police officers in this state now that you can't ask for consent at an automobile stop. You can't ask for consent to search. I mean, to allow that would be perhaps lead to more public safety, question whether that's true or not, but some people could argue that allowing more searches would maybe take more guns off the street. Maybe it would lead to more bad interactions between police and individuals. That's a judgment for this body to make about, are there, what kinds of rules or limits or safeguards do we want to put in place on our interactions? We want our police to be serving the public, and we want police to be actually promoting public safety. And I think visions of what that means change over time. And people have different views over how best to promote public safety. For a long time, we thought that it promoted public safety to put people in prison for a long time, right? And we've kind of moved away from that. And we now think about, let's find a way to make sure that people re-enter society with actual job skills and with actual ability to find a place to live, and with treatment for whatever mental health or substance abuse issues they have. So those visions of how to balance public safety and the rights of individuals who have breached that public safety is it something that that changes over time, and which is why I said, you know, police and prosecutors work within that system. But it's a balance.
But in your 20 years and as a prosecutor, do you see a limit on consent searches as a net positive or a net negative?
You know, I guess it's probably a net, I would probably, you know, as a citizen, I would say net positive, because I think probably a lot of those interactions are, you know, aren't really all that helpful for law enforcement, probably not necessary, maybe lead to bad outcomes given what we know. But I really see it as we just work within that system, you know, like we don't spend a lot of time in our office thinking about, was this a bad idea or was this a good idea that police can't do consent searches? We just say, okay, well, we don't have that evidence because we can't get a search of that car, even if it's stopped. That's okay. And we just move on. And it changes the kinds of law enforcement maybe that you're going to get. And maybe there are going to be people who are going to have things hidden in their car that they're not going to be prosecuted for. That's a choice that this body has made about balancing public safety and in law enforcement. You know, so it just doesn't, I mean, I know that's, I work within the system, and if we often tell people, tell prosecutors, tell law enforcement that search was unconstitutional. We're not going to try and use the evidence that we got from there. And, you know, that's a balance, right? That's a constraint on law enforcement, but that's okay. That's what we do. We just move on. Sometimes we can't prosecute somebody because we don't have the evidence. Sometimes like, well, we have enough other evidence. We just won't use that. But sometimes it means we dismiss charges. And that's a choice that our constraints, for lack of a better word, use. Like that's a balance between the rights of the accused and the rights of the community to public safety.
Obviously, this legislature, back in the wake of the murder of George Floyd, passed a fairly robust police accountability bill. Provisions of that law, at least to my knowledge, have not yet been challenged to the Supreme Court. And in fact, one of the areas where we heard extensively during the debate on that bill, there was going to be this flood of litigation, was on so-called qualified immunity claim and, you know, this rollback of protection for police officers. Well, I'm not aware of a single case that's been brought against a police officer under that law since it's passed 3 years ago. But to the extent those cases, or a case someday arises, back to this recusal question, is how would you handle sort of dealing with a challenge to maybe aspects of the police accountability bill as they trickle up to the Supreme Court, given your prior work and experience with law enforcement in the state?
I don't see my prior work as requiring recusal from cases involving criminal justice. I don't think any of the current justices who have background as prosecutors see that as an issue that would require their recusal. And you know, we work closely with law enforcement, but we also understand the problems with, that, like all professions, not everybody in law enforcement is let me put it this way. We have prosecuted police officers in the past in our office for excessive force, we have refused to work with certain officers if we felt like we couldn't trust them. And that's just part of what we do. And I don't think that my background working with law enforcement would require my recusal. I intend to be fair to everybody who comes before me.
So what I take from that then is it would depend on who the actual plaintiff is in that case. Or I guess not the plaintiff, who the actual I guess would be defendant predominantly, right? So if it was a law enforcement official you worked closely with, that may be different than just generally anybody.
Correct.
One final question on question 15 on your questionnaire. It asks about personal liberties. And you say property rights and personal liberties both protected by the US and Connecticut Constitution and should be protected according to the dictates of those documents. When it comes to personal liberties, what are those dictates or limits?
Those are the ones protected in the Bill of Rights, Connecticut's, Declaration of Rights. Those are, established and, as we've discussed at length today, over time, the given content over time. And those were, those are the ones that I understood when people talk about personal liberties, those are the kinds of things that come to mind when I read that question.
Under those dictates, does government have the authority to mandate that kids wear masks in schools?
I certainly, I think that's an issue that the Connecticut Supreme Court has either considered or is considering, but I think that.
I think it's moot. I think they determined.
Right. I mean, that probably would be it. I think that public health authorities, personal liberties are often not absolute, right? Because we do live in a society that requires us to live and interact with other people. So we have all kinds of requirements that require us to curtail our personal liberties in the interest of public health. And for a while, mask mandates were certainly part of those limitations on personal liberty that were serving a different and common good.
Right. My question was, certainly we know mask mandates were instituted. My question was, were they lawful?
I see no reason why they weren't, but because they were a public health order entered to serve, to protect the public. And there are infringements on infringements is the wrong word. We accept some limitations on personal liberty for the greater good. And so when you think about, in the obvious example, and it seems a bit trite, but the obvious example are rules of the road. We don't just get to drive wherever we want. We have to follow rules of the road. Those are infringements of our personal liberty, but they are there for the greater good. And I saw mask mandates in the same way. And hopefully this is not something that's going to come back, hopefully, in our lifetimes. But public health authorities and I think most legal systems recognize that very few of our personal liberties are absolute, that they can, depending on the structure, the legal system and the kind of claim, what kind of claim it would be evaluated under. But, we have all kinds of public health measures that restrict our liberty in that sense.
Thank you. Senator Winfield.
Thank you, Mr. Chair. You're doing really great. We've had a lot of questions for you today. I am going to go back on some of the stuff that you've been asked. When this is over, we have to do some deliberation. I want to make sure that I'm clear on what you are telling us. Some of it is because you've gone back and forth with different folks has gotten a little muddled in my mind. So I'm going to start off with a question related to what a representative was asking you earlier about justice. And your answer was like the answer you gave me when we met, very much about procedure and things of that nature. And then you ended off saying, but we're making progress. And I guess my question is about that, because I'm known to be a fan of James Baldwin. And one of the things that Baldwin talked about was, or asked in the public forum was, how much time must be given for progress, because his mother, his father, his uncle's time had been eaten up. and your answer falls, whether you mean to or not, seems to fall in line with that question. It's a question he had. It's a question I have. What is your understanding of what justice is? And I will tell you, surprisingly, a lot of folks who have sat there, whether it be for the Superior Court or one of the other courts, Supreme Court, have failed on this question. So I'm interested in you clarifying for me what you perceive it to be and what it has to do with what you do.
So to me, I see our justice system, both the civil and the criminal justice system, as being part of our social compact. You know, we agree to be bound by laws as written for the common good. And there are breaches of those compacts. And when people breach those, we have a justice system to help repair that breach. It's not going to solve all the problems and it's not going to repair it completely, but we have a system that provides a way to provide a piece of that. And so it's procedural, yes, and I think that's crucial. I think it is foundational, but it's not just procedural. It is also a substantive outcome in the sense that it has to take into account all of the stakeholders in that system, because it is about the person who has offended the social compact, has offended the laws, but it's also about the community who feels less safe because there was a murder in their midst, or there was a shooting in their midst, or because there was somebody swindling their grandmother out of money. You know, that community safety is something we have to take into account. But justice also involves taking into account the interest of victims, and somebody who has lost money to someone who swindled them, or someone who has lost a loved one to a shooting, or suffered at the hands of you know, other violent conduct. And so to me, but when you also circle back to the offender, also understanding that, you know, the justice system isn't going to solve all of the problems that led somebody to that breach, whatever it was. Often, you know, one of the things that I do in my job is read a lot of the pre-sentence reports. So when somebody is ready for sentencing, the probation office prepares a pre-sentence report that goes through a detailed history of this person's life and how they got to this point. And those are often really tragic. And it is rare that sending someone to prison is going to actually solve any of those problems. Maybe it will. So it may not the problems that come from that, but our justice system serves all kinds of purposes. And part of it is balancing those interests and finding a way to provide some measure of maybe incapacitation, maybe redress to the victims, ensuring a victim gets restitution, maybe understanding the seriousness of the offense conduct, the impact on the community. Those are all factors that I think are important to take into account in a justice system. But I also, you know, I think it's also important to recognize that I think a justice system has to be aware that it can't solve all those problems, you know, and that understanding that when people come out of prison, because almost everybody's coming out of prison, if we're talking about a prison sentence, they're going to be part of our community again. And so what are we doing about ensuring that the community can heal? And sometimes the justice system can't do anything about that. Sometimes we can. And have we done what we can within the authorities that we have? Or are we referring people to the right sources to get help with those problems that the justice system can't solve?
Thank you. And I don't know that you feel this, but and maybe I shouldn't say this, but it feels like, and I get why that's a hot seat to be in, but it feels like you're trying to answer my question, and I'm just trying to figure out how you think. So your answer is what it is. It's correct in and of itself because it is your answer. And I also want to say that I'm not just thinking about what we traditionally talk about as the criminal justice system. I'm thinking about questions like Representative Johnson's questions about the LGBTQ community. I'm thinking about questions about some of the things that have happened in our history, because you very much seem to think that the rule of law is important, and it is, but the rule of law is also sometimes the way in which we have some very nasty things happen in our country. There was a conversation earlier about Plessy. When you take Dred Scott case, Plessy, and the Cummings case, the Board of Education case, a couple of years after Plessy, the rule of law would tell you that people like myself should not necessarily get what we now get out of these systems. And so I guess if you could talk to me a little bit about understanding that the rule of law is important, but that the rule of law itself, given who has dictated what the rule of law is, can very much be part of the problem as well. It might help me to understand your perspective better.
No, I think that's a really fair point, and something that I've thought about a lot over the last, 6 or 7 years. And let me give you an example, and I'll try to not say anything out of turn. In the prior administration, there was a policy adopted at the border of separating children from their families. And in a strict reading of the law, on one level, there was authorization for that policy. It was monstrous. And it's the kind of policy that, some good people objected to within the government, but not enough. That kind of, using the law to bad ends is something that I think we all have to be attuned to. Am I being asked to do something that, and its impact is monstrous or is bad, or as a substantive matter shouldn't exist? And those are questions that I think any justice system needs to continue to ask, and be open to hearing criticisms of the system, and be open to hearing, here's where we think you can do better. Here's where you think the law is being used to harm people or individuals or communities. And I think any justice system needs to be open to hearing those criticisms.
Thank you. And we're gonna walk into the letter, but just before we get there, in response to those who've asked you questions today, you talked about the guardrails, and I guess I want to understand your thinking about these guardrails. We just talked about how the rule of law can sometimes lead us to a space we never should have been in, and that's not just a sin of presentism. That's just, we should never have been there. When I think also about cases beyond the ones that I mentioned, when I think about Korematsu, when I think about Minor versus Happersett, when I think about, we could probably all go and list a number of cases. What I see is that human beings have issues and they're flawed. And ever since around the 14th century, when the notion of stare decisis came in, there's always been an out for it, which is bad law, which is interpreted by human beings. Given what we've done in terms of cases here in the United States of America, given the frailty of human beings, and given that loophole, the notion that guardrails were going to protect us, and maybe this is because I come from one of the communities of folks who the system has not worked for largely. The notion that guardrails would protect us, to me, just doesn't make a lot of sense, I guess. I was going to try to find a better way to put that, but it doesn't make a lot of sense. So I think people like myself would not necessarily believe that there were guardrails and would be hyper vigilant. Can you talk to me about your notion of guardrails and why you thought they would protect us?
My notion of guardrails was that courts were bound by prior decisions, that courts were bound by the decisions of the Supreme Court and couldn't take actions. And I think you're exactly right, Senator Winfield. I think my impression that guardrails would protect us reflects my experience with the criminal justice system and with the law more generally, that is probably not reflected by your practice. And probably you were probably more attuned to the dangers than I was. I admit to being naive and not seeing that danger and not understanding how the system sometimes doesn't work for communities, for certain people, and maybe that I'm in part of the community that it has historically worked for, and so I don't see the problems. And that's something that I have that's something that I've learned over the years. And so I see that as a clearly a blind spot that I had, but I just telling you where I was at the time and understanding what I know now, yeah, I had too much faith in those guardrails and thought that they were really working in a system that they clearly weren't.
And when we talked about Plessy ultimately changed because we have Brown versus the Board of Ed. As it relates to the conversation around the letter, Brown versus the Board of Ed is perhaps the jumping off point, which leads us into the whole conversation for political reasons around Roe versus Roe versus Wade and the peppering, if you will, of the federal judiciary for the last 40 plus years. That context existed prior to 2016. You said you went to Washington and you were concerned, and yet you did sign on the letter. I guess, as someone who has expressed that you wanted to be a judge in the federal system, are you unaware of what was going on in the system for the last 40 years of seating judges in order to get them to the Supreme, absent Amy Coney Barrett, right? Absent her for a second, were you not clued into that? Oh, I don't mean to be pejorative in the question. I just want to know, were you aware, or was it something you were aware of but not paying attention to? What is the case there?
I think I was part of a legal culture that saw the ability to work with people who you disagreed with that was just part of what was part about doing law. I think I was naive and didn't understand the full extent or how fast or how hard our institutions would fall. I believed, our courts did some really good things, but they didn't do all the good things and they didn't do enough. But, do I wish I hadn't signed it? Would I do it again? No,
And I appreciate that. You in the meeting with myself and my co-chair drew a distinction between the appellate court and the Supreme Court, and there is a distinction. I pushed back and said that the appellate court, kind of like what I just talked about with the peppering, the appellate court is how we get things to the Supreme Court. And I think that's why my emails have been full of people who are concerned about a vote in the positive for you. When you talked about the letter, you talked about it as if, well, we didn't agree with Amy Coney Barrett, but what the letter says at the end is that she's fully qualified and would be an excellent addition. I don't know how someone walks away understanding that you are putting her forward as anything other than somebody who's in the federal system, as somebody who likely is aware of what's going on, who says that this person, from their perspective, if you're a signee, thinks whatever opinion she holds is okay enough for her to be on that bench, which would actually be helping to send cases to the Supreme Court, having been judged a certain way. And that to me is concerning. It really is. But we've talked about that a lot. What we haven't talked about is, excuse me, in 2017, when this was going on, there were a lot of folks talking about Amy Coney Barrett. And those of us who are news nerds like myself were paying attention. People who are in the federal system were paying attention. And I haven't heard from you till today, including the meeting we had the other day, at least not as strong as you did today, that you said, I can't stand by some of the statements that were in the letter. So I would ask you first, what do you mean by that? What statements can't you stand by? And I'd ask you, I get the culture thing, but this is a person who you hadn't, well, actually you said to say that you worked together was a misnomer. And I get that, right? You were maybe proximate, but you weren't really working together. This is a person who you also hadn't seen in almost 20 years. Could you just, maybe I'm asking the same question. I'll just stop there and let you answer.
So this letter that was signed by everybody who clerked that year, including the clerks for the most liberal justices, reflected our experience with her in 1998 and 1999. Based on my observations of her over the last 6 years and her voting record, I can't stand by characterizations in the record that she's honorable and fair-minded, or that she has respect for the law. I don't see signing on to Dobbs as someone having respect for the law. And, I'll stop there.
Okay. I don't want to spend a lot more time on that. We've been here a lot today, and I think it's close to time for you to have some relief. I do want to touch on the issue of you sitting here. So I believe you have expressed both when we met before and today that you did have interest in becoming a federal judge, but what I walk away with, and I want to make sure I walk away with the correct impression, is that you weren't interested enough to pursue being a state judge and of some sort, whether it be a justice of the Supreme Court or a judge of the Superior Court or whatever the case may be. There's been a lot of conversation about folks who've been on the list and the way these things work. And the qualifications have been a part of this conversation. And as someone who sat on this committee for a very long time, for me, it is often difficult when someone gets through the system as quickly as you did. We've had people who, several of us have tried to figure out why we can't get them even through judicial selection. Why do you want to be here now? It didn't seem that you wanted to be here before being asked.
I love what I do. I love my job. I have been able to combine my love for the law with a commitment to public service. And while it was true that at various times I've thought about other ways to contribute to the public, the state court bench was really just not something that was on my radar screen or seemed like something that would match my skill set with my ability to serve at a particular time. And so, when I was contacted and asked if I was interested in being considered, I spent some time thinking about it and talking to my family and thinking about what it would mean and whether I felt like I could do the job, whether I could contribute to the people of Connecticut in that way. And I ultimately came to the conclusion that I could, and that this would be a way that I could serve the people of Connecticut and contribute my legal skills to what I consider to be a vital part of our state government, a strong and independent judiciary.
Earlier you spoke about humility being a part of who you are. Recently, in addition to the question, at least for the Superior Court judges on Robitis, where humility tends to come up, I've asked additionally, what are people's systems of accountability? And I know it's a little different between the Superior Court and the Supreme Court in terms of interactions and all of that. But I think the question of systems of accountability still remains an important question. What are your systems of accountability?
Well, you know, as I mentioned earlier, I think one of the core systems, aside from my personality, is that I would ask my colleagues to hold me accountable for my conduct and for making sure that I am treating people with dignity and respect always. I think that the Connecticut Supreme Court is somewhat unique in that all of its, or most of its hearings are broadcast and saved. So, you know, temperament can be observed by outside observers. I think that's a really good thing for any court system. And so I think those are two systems. You know, one of the things that I worked for two judges who were both in different ways, really singular legal figures. Judge Posner is a eminent legal scholar, and Justice O'Connor was the first woman and you know, served for many, many years. Both of them showed me how to be a judge who is humble and aware of their role, that their role is to be a public servant. And one of the things that Judge Posner did, and I think I've mentioned it here, although I may have lost track at this point, that he was really open to criticism. And one of the things that he did was he had us call him Dick. His name is Richard Posner, and his clerks were to call him Dick, which is not something that a lot of judges do. Most judges have you call them Judge Posner or Justice O'Connor. But he thought it was important because he knew that when he put on the robe and became Judge Posner, that put up a little bit of separation, and that put up a little bit of people being afraid to tell him what they thought or being afraid to challenge him. And I think that part of being Robitis, one of the problems with Robitis, aside from treating people poorly in a courtroom and treating people without dignity and respect, is that you then aren't hearing the people around you. You're not hearing contrary views. You're not hearing facts that challenge your worldview. You're not hearing from outside perspectives. And so I think about that a lot. And how do I take that and translate that for me into a day-to-day work environment that allows everybody around me to feel like they can come to me with concerns or questions that challenges to the way I'm approaching a case.
I appreciate that. I would just comment to say that I hope, and I think this is what you mean, that when you say your colleagues, you don't just mean the other justices, you mean all of the folks around you working in that system. And I would just encourage you. I think many of us, first of all, we're always televised, and depending on the day, it's not a side of the aisle thing. People have opinions about how we operate. So I don't know that televised necessarily does it, but I get your point. But I would encourage you to not just think of allowing people to call you by your name or something of that nature, but really think of ways in which what you are suggesting to those people, they feel empowered to do. Because I have observed that many people will go and think they are setting these things up, but people do not feel empowered to actually, when it matters, say what's necessary. So with that, I think we've been here long enough. I will just say this. This is an important decision we make, and I really wish that I almost wish the letter hadn't ever showed up and that we still had a hearing like this. Oftentimes, people come here to be a judge of any of our courts, and the hearings feel, at least, I'm not going to suggest that they are, but they feel as though they just go by too quickly. They feel as though it's a done deal before someone moves forward to sit on, whether it be the Superior Court, Appellate Court, or the Supreme Court. I hear from the public oftentimes that they don't feel like we've done our due diligence. I think that letter is a reminder that we need to do our due diligence. I'm sure it's also a reminder to you that you need to do your due diligence. With that, I thank you for joining us today.
Thank you.
Thank you, Senator, and Attorney Glover, thank you. Congratulations on your nomination, and thanks for bearing with us for the day.
Thank you.
All right, with that, we do have one member of the public who signed up to testify, so we will give that individual their 3 minutes. Steve Kennedy.
Thank you. Co-chairs Winfield and Staffstrom, vice chairs Flexer and Quinn, ranking members Kissel and Fishbein, and distinguished members of the Committee on the Judiciary. Thank you for hearing my testimony today. I'm the organizing and network director for the People's Parity Project, and until yesterday's graduation, a leader within our Yukon Law chapter. I'd like to preface my remarks by saying that our testimony is not meant to be a judgment of Attorney Glover personally, as we don't have reason to doubt her qualifications necessarily, but we do have separate concerns. I should also say I'm speaking on behalf of PPP specifically, and not the Connecticut Pro-People Judiciary Coalition, which we're a part of and is pushing for a more professionally diverse state judiciary, but does not take a stance on individual nominees. With that out of the way, however, the People's Parity Project and our Yukon Law chapter are concerned about the makeup of the state's judiciary, and this nomination to the Supreme Court would further skew the court in the direction of justices with prosecutorial experience over those from other underrepresented backgrounds. We're concerned about this because empirical studies have shown that judges' backgrounds can have unconscious impacts on the ways that they oversee their courts and in the ways that they rule. So, for example, former corporate attorneys and prosecutors have been shown to side significantly more often with employers over their workers in discrimination, retaliation, and other employment cases on motions for summary judgment than judges from other legal backgrounds do. Former prosecutors have also been shown to give significantly longer criminal sentences than judges from other backgrounds. And what we found is that these are the very backgrounds that a report from PPP Yukon found are most overrepresented on our state's bench, with a significant majority of our judges and justices having corporate or prosecutorial experience. And while these studies have been limited to the trial court level, obviously we're talking about the Supreme Court, there is anecdotal evidence that points towards the need for a variety of backgrounds on appellate courts as well. So many of U.S. Supreme Court Justice Thurgood Marshall's colleagues acknowledge the importance of both his personal experience and his professional background in civil rights and criminal defense to his approach to the law, and the additions to the U.S. Supreme Court's deliberations. So, for example, Justice William Brennan stated Marshall spoke from firsthand knowledge of the law's failure to fulfill its promised protections for so many Americans. And he went on to say that Marshall's perspective did have a significant influence on the court's deliberations and the outcomes of certain cases. And today, Attorney Glover herself actually mentioned the importance of learning from the perspective and experiences of potential colleagues and the people who appear before the court, the people who work in the court several times. And all of this points toward the need for more balance on the bench. So all judges have certain blind spots, and we can see that they're influenced by their backgrounds. So we do need justices coming from all backgrounds to make sure that they can fill in those blind spots for each other. So while Attorney Glover may be qualified for the Connecticut Supreme Court, she would also be the 4th justice with prosecutorial experience on a court of only 7. Meanwhile, no justices will have legal aid or public defense experience, and only 1 justice has experience representing individuals as a plaintiff's attorney.
Thank you, Mr. Kennedy. We appreciate you being with us today. All right, with that, we are going to declare our public hearing closed. We are going to convene the Judiciary Committee meeting for Monday, May 15th. The meeting will stand in recess while members caucus. The Democrats will be in 2B as in boy, and the Republicans will be in room 2600. With that, we stand in recess.